Chapter 24 of Autobiography of a Seaman, Volume 2. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Timothy Ferguson. Autobiography of a Seaman, Volume 2, by Lord Thomas Cochrane. Chapter 24. A Naval Study for All Time. It will be asked, how is it that the matters recorded in the present volume are, after the lapse of 50 years, for the first time made public? The reply is, that it was not until after the publication of the preceding volume that I have been enabled to place the subject in a comprehensible point of view, and that only through the high sense of justice manifested by the late and present First Lords of the Admiralty, in furnishing me with charts and logs, access to which was prohibited by former Boards of Admiralty. On several previous occasions the attempt has been made, but from the obstinate refusal of their predecessors to afford me access to documents by which alone truth could be elicited, it has not hitherto been in my power to arrive at any more satisfactory result than that of placing my own personal and unsupported statements in opposition to the sentence of a court-martial. The necessary materials now being conceded in such a way as to enable me to prepare them for publication in detail, it is, therefore, for the first time in my power to vindicate myself. A brief recapitulation of former refusals, as well as of the manner in which I became possessed of such documentary testimony as will henceforth exhibit facts in a comprehensive point of view, is desirable as placing beyond dispute matters which would otherwise be incredible. My declaration previous to the court-martial, that it was in my capacity as a member of the House of Commons alone that I intended to oppose a vote of thanks to Lord Gambier, on the ground that no service had been rendered worthy of so high an honour, will be fresh in the remembrance of the reader; and also that when, at the risk of entrenchment on the privilege of Parliament, the Board of Admiralty called upon me officially to accuse his Lordship, I referred them to the logs of the fleet for such information relative to the attack in Aix Roads as they might require. It nevertheless became evident that I was regarded as his Lordship's prosecutor, though throughout the trial excluded from seeing the charts before the court, hearing the evidence, cross-examining the witnesses, or even listening to the defence. On the acquittal of Lord Gambier, the Ministry did not submit the vote of thanks to Parliament till 6 months afterwards, viz. in the session of the following year, 1810. To myself, however, the consequences were, as Lord Mulgrave had predicted, immediate, bringing me forthwith under the full weight of ministerial displeasure. The Board of Admiralty prohibited me from joining the Imperius in the Scheldt. The effect of this prohibition, in a manner so marked as to be unmistakable as to its cause, produced on my mind a natural anxiety to lay before the public the reasons for a proceeding so unusual, and as a first step I requested of the Board permission to inspect the charts upon which, in opposition to the evidence of officers present at the attack, the decision of the court-martial had been made to rest. The request was evaded, both then and afterwards, even though persisted in up until the year 1818, when it was officially denied that the original and most material chart was in the possession of the Admiralty. Even inspection of a copy admitted to be in their possession was refused. An assertion of this nature might be dangerous were not ample proof at hand. It having come to my knowledge from certain affidavits filed in the Court of Admiralty by Mr. Stokes, the master of Lord Gambier's flagship, on whose chart the acquittal of Lord Gambier had been based, that, after the lapse of 8 years from the court-martial, material alterations had been made by permission of the Board itself and under the direction of one of its officers, I naturally became suspicious that the charts might otherwise have been tampered with, the more so as neither at the court-martial nor at any period subsequent to it had I ever been allowed to obtain even a sight of the charts in question. The very circumstances were suspicious. On the application for head money to the Court of Admiralty in 1817, the Court had refused to receive Mr. Stokes's chart, on account of its palpable incorrectness. On this, Mr. Stokes applied to the Admiralty for permission to alter his chart. The permission was granted, and in this altered state it was received by the Court of Admiralty, which, on Mr. Stokes's authority, decreed that the head money should be given to the whole fleet, contrary to the Act of Parliament, instead of the ships which alone had taken part in the destruction of the enemy's vessels. Fearful that material erasures or additions had been made, I once more applied to the Board for permission to inspect the alterations. The request was again refused, though my opponents had been permitted to make what alterations and erasures they pleased. The following are extracts from the above mentioned affidavits of Mr. Stokes. Extract from the affidavit sworn before the High Court of Admiralty on the 13th of November 1817 of Thomas Stokes, Master of the Caledonia, as to the truth of the manuscript chart upon which the acquittal of Lord Gambier was based, before the Court of Admiralty rejected his chart, and before the alterations were made. Quote, "And this deponent maketh oath that the annexed paper writing marked with the letter A, being a chart of the A roads, is a true copy, made by this deponent of an original French chart found on board the French frigate La Armide in September 1806, which original chart is now in the Hydrographic Office in the Admiralty, and by comparing the same with the original chart, he is enabled to depose, and does depose, that the said chart is correct and true, and that the soundings therein stated accurately describe the soundings at low water to the best of his judgment and belief." Footnote begins, the original was neither produced at the court-martial nor before the Court of Admiralty. A far greater and more deliberate error will appear in a future chapter. End author's note. Extract from a second affidavit sworn by Mr. Stokes before the High Court of Admiralty on the 17th of April 1818, after the court had refused to admit his chart from its incorrectness, and after the alterations had been made. Quote, "Appeared personally Thomas Stokes, Master in the Royal Navy, and made oath that the original manuscript chart found on board the French frigate La Armide and marked A, annexed to his affidavit on the 13th of November 1817, were delivered at the Hydrographic Office at the Admiralty, and this deponent, for greater convenience of reference, inserted a scale of a nautic mile, the original manuscript chart having only a scale of French toises, that inserting a scale of a nautic mile, the deponent had allowed 1,000 French toises to a nautic mile, and that Mr. Walker, the assistant hydrographer, accordingly made the erasures which now appear on the face of the chart," etc. In these affidavits, Mr. Stokes first distinctly swore that his chart, copied from a French manuscript, was correct. Secondly, when detected by the Court of Admiralty, that it was incorrect. Thirdly, that the original was deposited in the Hydrographic Office at the Admiralty. My application to Sir John Barrow, then Hydrographer to the Admiralty, was as follows. Letter begins, May 4th, 1818. "Sir, as it appears by the affidavit, of which I enclose a copy, that two charts of A roads, the one stated to be a copy of the other, were deposited in the Hydrographic Office, and that one purporting to be the copy has been delivered up for the purpose of being exhibited as evidence on the part of my opponents in a cause now pending in the High Court of Admiralty, and as it further appears that an alteration in the last mentioned chart was made by Mr. Stokes, and a further alteration by Mr. Walker, Assistant Hydrographer, I have to request that the Right Honourable the Lords Commissioners will be pleased to permit me to see the other or original chart of Mr. Stokes, still remaining at the Hydrographic Office, in order that I may be enabled to judge for myself of the nature and effect of the alterations now acknowledged to have been made on the charts. The reasonableness of this request will, I presume, be manifest to their Lordships, and the more especially seeing that my opponents are not only allowed similar access, but have been permitted to withdraw one of the said charts for the purpose of exhibiting it in evidence, notwithstanding that a variation from the original has been avowedly made therein. I have, etc., Cochrane. Sir John Barrow, Hydrographer, etc. Letter ends. To this request, Sir John Barrow, on the 6th of May, returned the following refusal. Letter begins, "As Mr. Stokes's charts have been restored to him, and a copy made for the use of the office, I am directed to acquaint your Lordship that my Lords cannot comply with your request in respect to the original chart, and as to the copy of the chart made in this office and now remaining here, their Lordships do not feel themselves at liberty to communicate it. I have the honour, etc., John Barrow." Letter ends. This refusal was accompanied by the following copy of a minute from the Admiralty, in which it was pretended that Stokes had only lent the original chart to the Hydrographer's Office to be copied for the use of the Hydrographic Department, though it had been made use of to acquit an Admiral, to the rejection of the charts of the fleet, as will presently be seen. "Mr. Stokes lent the original chart to the Hydrographer's Office to be copied for the use of that department. Mr. Stokes then went abroad. On his return he applied for his chart, which being mislaid, they gave him the copy. Stokes, finding the alteration objected to in a court of law, applied about a month since for his own chart. the original of which was restored to him, copy being made. 23, 141, 147. Minute ends. To this singular communication and minute I returned the subjoined reply. Quote, 13 Henrietta Street, Covent Garden, 18th of May, 1818. Sir, your letter of the 6th of May was delivered to me as I was going out of town. Consequently, I had no opportunity of referring to documents which I have since consulted in order to refute the statements which the Lords of the Admiralty appear to have received. You inform me, by command of their Lordships, that it appears by a report from the hydrographer that Mr. Stokes had become possessed of the original chart, which he lent to the hydrographer's office for the use of that department. This appears to imply that Mr. Stokes became possessed of the original chart at the time of the attack in the Scheldt under Lord Gambier, whereas Mr. Stokes made oath that it was taken from the Armide in 1806, 2 years and a half previous to the attack in question. As it does not appear from the minutes of the court-martial on Lord Gambier that the original chart was then produced, and as it is not now forthcoming in the cause now pending in the Court of Admiralty, I am compelled to disbelieve its existence, or at least to believe that it underwent material alterations after it came into Mr. Stokes's possession. The original ought to have been exhibited with the copy at the trial of Lord Gambier, and both either were, or ought to have been, filed at the office of the Admiralty with the minutes of the proceedings. But whether either are so filed, their Lordships have not permitted me to ascertain. If the original were filed, it could not afterwards have been lent by Mr. Stokes to the hydrographer's office to be copied for the use of that department. Even had the copy only been filed, sworn as it was by Mr. Stokes to be correct, there could have been no necessity, if Mr. Stokes was deemed worthy of belief, for the hydrographer to borrow the original. 8 years have elapsed since the court-martial on Lord Gambier. You inform me that Mr. Stokes, on his return from abroad, applied for his chart accordingly, which chart happening to be mislaid, he was furnished with the copy in question, viz. that made for the use of the hydrographer's department. It is important to observe that this is completely at variance with the affidavit of Mr. Stokes, who swears that he himself made the copy, and that both the copy and the original were delivered at the hydrographic office. It cannot fail to be observed that to deliver a chart at the hydrographic office, and to lend a chart to be copied for the use of that department, the language of the letter before me, are different expressions, conveying widely different meanings. It is also material to observe that it is strange alterations at all should have been made on a chart represented to be a copy of an original, and exhibited as evidence in a court of law. That such original is not forthcoming is a very material and a very suspicious circumstance. If it be true, or if there really be any other chart than that which is described as a copy and admitted to be altered, I may fairly infer that such altered copy differs so materially and so fraudulently from the original, or that the original, so called, is itself so palpable a fabrication, or has so obviously been altered, that Mr. Stokes and his employers do not dare to exhibit it in a court of law, and have withdrawn it from the hydrographer's office for the purpose of suppressing so convincing a proof of the fraud practised on Lord Gambier's trial. Exclusive of the glaring contradiction between the statements of Mr. Stokes on the court-martial and that which you have been commanded to make to me, when it is considered that Mr. Stokes is detected in having altered a document which he exhibits in a court of law as a correct copy of an original, and that he is no sooner detected than he endeavours to defend the alteration by declaring that it proceeded from the hydrographer's office, where the original was deposited, and that upon such a defence leading to an application for leave to inspect the original, answer is made that such original had merely been borrowed from Mr. Stokes, and had been returned to him at his own request, and that request too made in consequence of the alteration in the alleged copy having been detected, it is impossible not to infer a juggle between Mr. Stokes, the hydrographic office, and others whom I shall not here undertake to name, for the purpose of defeating the ends of justice. Cochrane, Sir John Barrow, hydrographer, etc. Letter ends. Receiving no reply to this letter, I subsequently addressed the following to the Secretary of the Admiralty. Letter begins. 9 Bryanston Street, Portman Square, 2nd of July, 1818. Sir, I feel it proper to enclose to you, as Secretary of the Admiralty, a copy of an affidavit accompanied by a general outline of the chart of the Basque Roads, the originals of which are filed in the High Court of Admiralty, by which their Lordships will clearly perceive that 5 more ships of the line might and ought to have been taken or destroyed had the enemy been attacked between daybreak and noon on the 12th of April. And I have to request, sir, that you will have the goodness to lay these documents before their Lordships, as well as the enclosed printed case, which they have already partially seen in manuscript, with my respectful and earnest desire that their Lordships may be pleased to cause the facts therein set forth to be verified by comparing them with the original documents, logs, charts, and records in their Lordships' possession. I am the more solicitous that the present Lords Commissioners of the Admiralty should adopt this mode of proceeding, as it will enable them decisively to judge on a subject of great national importance, and also to ascertain, what a portion of the public know, that it is not by false evidence from among the lower class of society alone that my character has been assailed, in order not only to perpetuate the concealment of neglect of duty, but to prevent an exposure of the perjury, forgery, and fraud by which that charge was endeavoured to be refuted. I beg, sir, that you will assure their Lordships on my part that as a deep sense of public duty alone induced me formally to express a hope that the thanks of Parliament might not be pressed for the conduct of the affair in Basque Roads, so in addition to that feeling, which has made me disregard every private interest, I have formed a fixed determination never, whilst I exist, to rest satisfied till I expose the baseness and wickedness of the attempts made to destroy my character, which I value more than my life. As the affidavits of Captains Robert Kerr and Robert Hockings, which as well as my own are filed in the High Court of Admiralty, may immediately be made the subject of indictment in a court of law, and as the proceedings in the Admiralty Court have been put off under the pretence of obtaining further evidence in support of the misstatements of those officers and the claims of Lord Gambier, I have respectfully to request that when the Lords Commissioners of the Admiralty shall have instituted an inquiry into the logs, charts, and documents, and ascertained the conduct of the before named officers, they will be pleased to cause public justice to be done in a matter involving the character of the naval service so deeply. If, sir, through their Lordships' means, a fair investigation shall take place, it will be far more gratifying than any other course of proceeding. I have the honour to be, etc., etc., Cochrane. John Wilson Croker, Esquire, Secretary, etc., Admiralty. Reader's note, letter ends. After the above correspondence, I gave up, as hopeless, all further attempts to obtain even so much as a sight of the charts, without which any public explanation on my part would have been unintelligible. In the year 1819, when nearly ruined by law expenses, fines, and deprivation of pay, in despair, moreover, of surmounting the unmerited obloquy which had befallen me in England, I accepted from the Chilian government an invitation to aid in its war of independence, and moved with Lady Cochrane and our family to South America, in the vain hope of finding amongst strangers that sympathy which, though interested, might in some measure compensate for the persecutions of our native land. Author's note. The malice of offended faction pursued me even to this remote part of the globe in the shape of a Foreign Enlistment Act, 59th George III, cap. 69. This act was introduced by the Attorney-General, Sir Samuel Shepherd, for the express purpose of preventing anyone from assisting the South American states then at war with Spain, the act being thus especially levelled at me, though injuriously driven from the service of my own country. I will not attempt to describe the agonised feelings of this even temporary exile under such circumstances from my country, in whose annals it had been my ambition to secure an honourable position. No language of mine could convey the mental sufferings consequent on finding aspirations, founded on exertions which ought to have justified all my hopes, frustrated by the enmity of an illiberal political faction, which regarded services to the nation as nothing when opposed to the interests of party. On my return to England, from causes which will appear in the sequel, the subject of the charts was not again officially renewed. Latterly, however, considering that at my advanced age there was a probability of quitting the world with the stigma attached to my memory of having been the indirect cause of bringing my commander-in-chief to a court-martial, though in reality the charges were made by the Admiralty, I determined to make one more effort to obtain these documents, which alone could justify the course I had deemed it my duty to pursue, in the hope that the more enlightened policy of modern times might concede the boon, which a former period of political corruption had denied. I applied to Sir John Pakington, late First Lord of the Admiralty, for permission to inspect such documents relative to the affair of Aix Roads as the Board might possess. Permission was kindly and promptly granted by Sir John Pakington, but Lord Derby's ministry going out of office before the boon could be rendered available, it became necessary to renew the application to the successor of the Right Honourable Baronet, viz. His Grace the Duke of Somerset, who promptly complied with the request. The reader may judge of my surprise on discovering, in its proper place, bound up amongst the naval records, in the usual official manner, the very chart the possession of which had been denied by a former Board of Admiralty. The Duke of Somerset, moreover, with a consideration for which I feel truly grateful, ordered that whatever copies of charts I might require should be supplied by the Hydrographic Office, so that by the kindness of Captain Washington, the eminent hydrographer to the Board, tracings of the suppressed charts have been made and are now appended to this volume. His Grace further ordered that the logs of Lord Gambier's fleet should be submitted to the inspection of Mr. Earp, with permission to make extracts, an order fully carried out by the courtesy of Mr. Lascelles, of the Record Office, to the extent of the logs in his possession. It is therefore only after the lapse of 51 years, and in my own 85th year, a postponement too late for my peace, but not for my justification, that I am, from official documents, and proofs deduced from official documents, which were from the first and still are in the possession of the Government, enabled to remove the stigma before alluded to, and to lay before the public such explanation of the fabricated chart, together with an Admiralty copy of the chart itself, as from that evidence shall place the whole matter beyond the possibility of dispute. It will in the present day be difficult to credit the existence of such practices and evil influences of party spirit in past times as could permit an administration, even for the purpose of preserving the prestige of a government, to claim as a glorious victory a neglect of duty, which, to use the mildest terms, was worth a naval and a national dishonour. The point which more immediately concerns myself is, however, this, that the verdict founded on this fabricated chart, together with the subsequent official enmity directed against me, in consequence of my determination to oppose the vote of thanks to Lord Gambier, was preserved in year after year, till it reached its climax in the consequences of that subsequent trial, which was made the pretext of driving me from the Navy, in defiance of the remonstrance of the Board of Admiralty itself. I have not long been aware of the latter fact. Admiral Collier has recently informed me that Sir W.J. Hope, then one of the Naval Lords of the Admiralty, told him that, considering the sentence passed against me cruel and vindictive, he refused to sign his name to the decision of the Board, by which my name was struck off the Navy list. The follows a map which is titled Chart A, and is captioned, "Tracing from the official French chart of the Isles of Rhe and d'Oléron, tendered to the Court-Martial by Lord Cochrane, and rejected." End of chapter 24. Recording by Timothy Ferguson, Gold Coast, Australia. Chapter 25 of Autobiography of a Seaman, Volume 2, by Lord Thomas Cochrane. This LibriVox recording is in the public domain. Recording by Timothy Ferguson. A Naval Study continued. The charts to which the reader's attention is invited are those alluded to in the last chapter, as having, after the lapse of 51 years, been traced for me by Captain Washington by the order of His Grace the Duke of Somerset. The subject being no longer of personal but of historical interest, there can be no impropriety in laying before the naval service for its judgment materials so considerately supplied by the present First Lord of the Admiralty. Chart A is a correct tracing of the A roads from the Neptune Francois, a set of charts issued by the French Hydrographic Department, bound in a volume and supplied for the use of the French Navy previous to 1809. Footnote: sets of these charts, bound as described, were found on board the grounded ships captured in the afternoon of the 12th of April, and were therefore available for the purposes of the court-martial, had it been deemed expedient to consult them. Footnote ends. Copies from the same source being at that period supplied under the auspices of the Board of Admiralty for the use of British ships on the French coasts, these, in fact, forming the only guides available at that period. Chart A shows a clear entrance of 2 miles, without shoal or hindrance of any kind, between Isle d'Aix and the Boyart Sound. The soundings close to the latter marking 35 feet at low water, with from 30 to 40 feet in mid-channel. The chart shows, moreover, a channel leading to a spacious anchorage between the Boyart and Pal Sands, marking clear soundings at low water of from 20 to 30 feet close to either sand, with 30 feet in mid-channel. In this anchorage, a line of battleships could not only have floated without danger of grounding, but could have effectively operated against the enemy's fleet, even in its entire state before the attack, wholly out of range of the batteries on Isle d'Aix, as will hereafter be corroborated by the logs and evidence of experienced officers present in the attack, and therefore practically acquainted with the soundings. To a naval eye it will be apparent that by gaining this anchorage it would not at any time have been difficult for the British force to have interposed the enemy's fleet between itself and the fortifications on Isle d'Aix in such a way as completely to neutralise the fire of the latter. Further inspection of the chart will indicate an inner anchorage called La Grande Trousse, to which any British vessel disabled by the enemy's ships, 2 only of which out of 13 remained afloat, might have retired with safety to an anchorage capable of holding a fleet, the soundings in La Grande Trousse marking from 30 to 40 feet at low water. Between these anchorages, it will be seen on the chart, there is no shoal, nor any danger whatever. Footnote: This anchorage was plainly marked on the French chart supplied to the British ships, as deposed by the officers present in the action. See the evidence of Captain Broughton, Minutes, page 222, and that of Captain Newcombe, page 198. The correctness of the chart furnished by me being thus clearly established in evidence. Footnote ends. The rise of the tide marked on the chart was from 10 to 12 feet, footnote, in reality from 18 to 20 feet at spring tides, as appeared from the testimony of various officers, Admiral Stepford amongst others. Even Mr. Stokes marked on his chart a rise of 21 feet, so that there was an abundance of water for the operation of ships of the largest class. The defence of the Commander-in-Chief was that there was not sufficient water at half flood to float the ships. End of footnote. Consequently amply sufficient on a rising tide for the 2-deckers and frigates to have been sent to the attack of the enemy's ships aground on the Pal Shoal, as testified by the evidence of Captains Malcolm and Broughton. The flood tide, making about 7 a.m, gave assurance of abundant depth of water by 11 a.m, which is the time marked in the Commander-in-Chief's log, footnote, erroneously, according to the logs of the other ships, footnote ends, as that of bringing the British ships to an anchor, in place of forwarding them to the attack of ships on shore. This chart was tendered by me to the court in explanation of my evidence. It was, however, rejected, because I could not produce the French hydrographer to prove its correctness, though copies of a similar chart, as has been said, were furnished to British ships for their guidance. Being thus repudiated, my chart was flung contemptuously under the table, and neither this nor any other official chart was afterwards allowed to corroborate the facts subsequently testified by the various officers present in the action, they being imperatively ordered to base their observations on the chart of Mr. Stokes, alluded to in the last chapter, as having been, 8 years after the court-martial, pronounced by the Court of Admiralty so incorrect as to require material alteration before it could be put in evidence in a court of law. To this point we shall presently come. A singular circumstance connected with the rejected chart should rather have secured its reception, viz. that it was taken by my own hands out of the Ville de Versoix, French line of battle ship, shortly before she was set on fire to, and therefore its authenticity as having been officially supplied by the French government for the use of that ship was beyond doubt or question. I also produced 2 similar charts, on which were marked the places of the enemy's ships aground at daylight on the 12th of April, as observed from the Imperieuse, the only vessel then in proximity. The positions of the grounded vessels are marked on Chart B. The manner of the rejection by the court, at the suggestion of the Judge Advocate, of the chart tendered by me is worthy of note. President, "I think your Lordship said just now that you thought there was water enough for ships of any draught of water." Lord Cochrane. "Yes." President, "Have you an authenticated chart, or any evidence that can be produced to show that there is actually such a depth of water?" Lord Cochrane, putting in the charts. "It was actually from the soundings we had going in, provided the tide does not fall more than 12 feet, which I am not aware of. I studied the chart of the Basque Roads for some days before. The rise of the tide, as I understand from that, is 10 to 12 feet. It is so mentioned in the French chart. I have no other means of judging." Footnote. This was fully corroborated by Captain Malcolm, when, having said that "there were no obstacles to prevent the frigates and some ships of the line from going into the Aix Roads," he was asked by the President if he made known to the Commander-in-Chief that by keeping close to the Boart Shoal the ships might have gone in." Reader's note, in the original document there is an unpaired quotation mark. The reply was in every way remarkable. Captain Malcolm, "I do not know that I ever mentioned this to the Commander-in-Chief. The charts showed it." Minutes, page 214. A complete corroboration of the correctness of my charts tendered to, but rejected by the Court, though as these had been supplied under the sanction of the Admiralty, it was out of the question to reject them as the basis of evidence, inasmuch as there could be none other of a reliable nature. Judge Advocate: "This chart is not evidence before the Court, because his Lordship cannot prove its correctness." President: "No, it is nothing more than to show upon what grounds his Lordship forms his opinion on the rise and fall of the tide." The following extract from my evidence, and the singular remark from Admiral Young, are extracted from the minutes of the court-martial. "The Commander-in-Chief had the same charts as I was in possession of, and from these I formed my conclusion with respect to the anchorage. In reconnoitring the enemy's fleet, so near as to induce him to open a fire from almost his whole line, I reported to the Commander-in-Chief the ruinous state of the Isle d'Aix, the inner fortifications being completely blown up and destroyed. There were only 13 guns mounted." Admiral Young: "Will you consider, my Lord Cochrane, before you go on, how far this is relevant?" Minutes, page 58. "My assertion of the fact that the Commander-in-Chief's charts were identical with my own, as having come from the Admiralty, was considered irrelevant, because, had they been put in, or mine not rejected, there could have been no doubt of the result of the court-martial." Reader's note, the quotation from the minutes now ends. "It was not put in for any purpose of the kind, for I had expressly said that I had no opinion as to the rise and fall of the tide, except as marked on the French official charts. The object of my putting in these charts was to show the truth of the whole matter before the Court. The President, however, flung the chart under the table with as much eagerness as the Judge Advocate had evinced when objecting to its reception in evidence." It is a singular circumstance that, notwithstanding the chart was flung under the table and rejected by the Court, I found it bound up amongst the Admiralty records. The object of the chart was in fact to prove, as indeed was subsequently proved by the testimony of eminent officers, and would have been proved even by the ship's logs had they been consulted, that there was plenty of channel room to keep clear of the batteries on Isle d'Aix, together with abundant depth of water. The ships which were sent in, though too late, were untouched by shot or shell. For the depth of water they found on going in, see page 71. And that the Commander-in-Chief, in ordering all the ships to come to an anchor, in place of sending a portion, my signals were, half the fleet can destroy the enemy, then the frigates can destroy the enemy. Yet in his defence Lord Gambier assumed that I had signalled for the fleet at a time when, as he alleged, it could not have floated for want of water. Reader's note, for clarity, I'll start again at the beginning of that phrase. And the Commander-in-Chief, in ordering all the ships to come to an anchor, in place of sending a portion of the British ships to the attack of the enemy's vessels aground on the north-west part of the Palles Shoal, on the morning of the 12th of April, had displayed a mollesse, as it was happily termed by Admiral Graviere, unbecoming of the Commander-in-Chief of a British force, superior in numbers, and having nothing to fear from about a dozen guns on the fortification of Aix, which, had the ships been sent in along the edge of the Boyart, could have inflicted no material damage either by shot or shell. See Captain Malcolm's evidence, page 58. Also Captain Godfrey's of the Etna, who, "thinks some of the enemy's shot went over them," minutes, page 173, but admits that not a mast, yard, or even a rope yarn was touched. These were precisely the points which the Ministry did not want proved, and which, as will presently be seen, the Court was no less anxious to avoid proving. Had the French chart been received in evidence, as it ought to have been, I do not say mine, but those on board the flagship itself, or indeed any copy supplied by the Admiralty to the fleet, a vote of thanks to Lord Gambier would have been impossible, and with the impossibility would have vanished the government prestige of a great victory gained by their Commander-in-Chief under their auspices. "I was furnished by Lord Cochrane with a French chart, and considered it a good one." Evidence of Captain Newcombe, page 199. "I had for several years been in the possession of official French charts, which, in my previous cruises, had not been found defective; and from those charts I had, at all times, drawn my conclusions with respect to the depth of water, or other circumstances which related to the navigation of the enemy's coast." President. — "The coast of the enemy, I suppose you mean." Lord Cochrane. — "I refer to the French coast." Admiral Young. — "When did you discover that there was this anchorage in deep water?" Lord Cochrane. — "I have said that in going in I found the soundings correct, and that, in fact, I had such confidence in the chart, that I said to Admiral Keats, when we were off there, and to Admiral Thornborough, that there could be no difficulty in going in and destroying the enemy's fleet. I took the chart on board Admiral Thornborough's ship." See my letter to Admiral Thornborough, vol. 1, page 195, Lord Cochrane's evidence, page 57. The French official chart thus being adroitly got rid of by the Judge Advocate, the other charts tendered by me, to mark the position of the enemy's ships aground, shared the like fate, though not open to the same objection. The exactness of the positions was moreover confirmed by the evidence of Mr. Stokes, the master of the Caledonia, Lord Gambier's flagship, though his chart, substituted for those in use amongst the British ships, was in direct contradiction to his oral evidence. The positions of the ships aground, as marked on my charts, were as follows: the Ocean, 3-decker, bearing the flag of Admiral Ameland, and forming a group with 3 other line of battle ships close to her, lay aground on the north-west edge of the Palles Shoal, nearest the deep water, where even a gunboat, had it been sent, whilst they lay on their bilge, could have so perforated their bottoms that they could not have floated with the rising tide. All were immovably aground, and were therefore incapable of opposition to an attacking force." "Till about noon the Ocean, 3-decker, was heeling considerably, and appeared to me to be heaving her guns overboard." Captain Malcolm, Minutes, page 209. "She escaped about 2 o'clock p.m., just before I advanced in the Imperieuse, lest all should escape." Whilst each of the group of 3 lay so much inclined towards each other as to present the appearance of having their yards locked together. There is a footnote on this page which is indicated as being correct for 2 different parts of the text. I'll read it now because it seems most appropriate at this point. "I think their yards were not locked." Evidence of Mr. Fairfax, Minutes, page 144. It was, however, so nearly that Mr. Fairfax, a witness carefully in Lord Gambier's interest, could only think about it. He reluctantly admitted that all lay "within a ship's length of each other," and ships lying aground on their bilge, inclined towards each other, at an angle of 30° R, if not locked together, completely incapable of resistance. They had, in fact, drifted with the same current into the same spot, and being nearly of the same draught of water, had grounded close to each other. The one separate was a vessel of less draught than these, and had gone a little further on the shoal. The correctness of these positions, as marked on my chart, was completely confirmed by Mr. Stokes, master of the flagship, in his oral evidence, as subjoined. Question. — "State the situation of the enemy's fleet on the morning of the 12th of April." Mr. Stokes. — "At daylight I observed the whole of the enemy's ships, except for 2 of the line on shore. 4 of them lay in a group, or lay together, on the western part of the Palles Shoal. The 3-decker, the Ocean flagship, was on the north-west edge of the Palles Shoal, with her broadside flanking the passage, the north-west point nearest the deep water." Minutes, page 147. This was the truth as to the positions of the grounded ships which escaped, these being referred to in Mr. Stokes's evidence precisely as marked on my rejected chart. That is, his evidence showed, in corroboration of my chart, the utter helplessness of an enemy which a British admiral refrained from attacking, though aground. The French charts produced by me being thus rejected, those in the possession of the Commander-in-Chief not being produced, and those connected with the fleet not being called for, the Court decided to rely upon 2 charts professedly constructed for the occasion by the Master of the Caledonia, Mr. Stokes, and the Master of the Fleet, Mr. Fairfax, neither of whom was present at the attack. It is a remarkable fact that many of the witnesses chiefly relied on by the Commander-in-Chief in confirmation of his having done his duty had not been in Aix Roads at all, and could therefore have no knowledge of anything except their remaining inactive with the fleet, whilst the enemy's ships were warping off. Mr. Stokes was of this number, yet all were questioned on points known only to officers intimately acquainted with Aix Roads and present at the action. But for the court to adopt exclusively, as will presently be seen, a chart constructed by a man who admitted that an important portion had been laid down from hearsay was monstrous, the more so as the official charts would have shown the truth. Footnote ends. Chart C was tendered to the court by Mr. Stokes, the master of Lord Gambier's flagship Caledonia. This chart professed to show, and was sworn to by Mr. Stokes as showing, the positions of the enemy's ships aground on the morning of the 12th of April, before the Ocean three-decker, together with a group of 3 outermost ships near her, had been permitted by the delay of the Commander-in-Chief to warp off and escape. Instead, however, of placing these on his chart, as they lay helplessly aground nearest the deep water, as he had sworn in his evidence, they were placed on the other side of the sand, in the positions occupied after their escape, and to this Mr. Stokes swore as their position when first driven ashore. The Ocean three-decker, and group in particular, which, according to Mr. Stokes's oral evidence, must, as already stated, have been an easy prey to a gunboat had such been sent on the first quarter instead of the last quarter flood, was thus placed on his chart where no vessel could have approached them. Footnote: Mr. Stokes, moreover, swore in his evidence that the Ocean three-decker lay on the north-west edge of the Palles Shoal, and that the group lay on the western part of the same shoal, though the latter observation was incorrect, as the group lay around the ocean, which formed part of it. On his chart, these vessels are placed to the south-east of the shoal, and the remainder nearly due east. That is, in place of being nearest the deep water, where they were easily attackable, they were placed on the chart farthest from the deep water, where they were not attackable. He swore, too, that they lay with their broadsides flanking the passage to Aix Roads. On his chart not one of them flanks the passage, but all are made to flank the opposite direction, so that they could not have fired on any British ship which might have been sent in. Footnote ends. This falsehood on Mr. Stokes's chart, in opposition to his oral evidence just given, as well as to the evidence of other officers, formed one of the principal grounds of Lord Gambier's acquittal, and it was for this end that the official French charts, presented by me for the information of the court, were rejected by the Judge Advocate. On the presentation of Mr. Stokes's chart to the court, the subjoined colloquy took place as to the methods adopted in its construction. Mr. Bicknell, quote, "Produce a chart or drawing of the anchorage at Isle d'Aix, with the relative positions of the British and French fleets, and other particulars, on and previous to 12th of April last." End quote. The witness produced it. Mr. Bicknell, quote, "Did you prepare this drawing, and from what documents, authorities, and observations? And are the several matters delineated therein accurately delineated to the best of your knowledge and belief?" End quote. Mr. Stokes, quote, "I prepared that drawing (Chart C) partly from the knowledge I gained in sounding to the southward of the Palles Shoal and the anchorage of the Isle of Aix. The outlines of the chart are taken from the Neptune Francois, and the position of the enemy's fleet from Mr. Edward Fairfax, and from the French captain of the Ville de Varsovie, and the British fleet from my own observation. The distance between the sands was copied from a French manuscript, which will be produced, and that, I take it, is correct." Mr. Bicknell, quote, "Are the matters and things therein accurately described?" End quote. Mr. Stokes, "They are." President, inspecting Mr. Stokes's chart, "There was a large chart you lent me?" Mr. Stokes, "That is the chart I allude to. This chart I produce as containing the various positions." Judge Advocate to the President, "This chart is produced to save a great deal of trouble." Minutes, page 23, 24. End quote. Reader's note: within this quotation there is a footnote, which is also a quotation. It reads, "In his subsequent evidence, Mr. Stokes admitted that he had never sounded there at all previous to the action." Question: "Had you any knowledge of the anchorage previous to the 12th of April?" Mr. Stokes: "None whatever." Minutes, page 148. He swears that everything on his chart is accurately described, then that "the distance between the sands," which was one of the most important points of the court-martial, was copied from a French manuscript, the name of whose author he does not think proper to communicate, nor does the court ask him, nor was any manuscript produced in court. Yet, as master of the Admiral's flagship, Mr. Stokes must have navigated her by the French charts supplied by the Admiralty, though these, when tendered by me to the court, had been rejected. The fleet could, in fact, have had no other for its guidance, as no British survey of Aix Roads was in existence. Such charts were surely a better guide in any case than an anonymous manuscript. No doubt, the trouble of confirming the Commander-in-Chief's neglect of duty and not following up a manifest advantage, as would have been shown had the court allowed the Neptune Francois itself to have been put in evidence, for it would have shown a clear passage of 2 miles wide, extending beyond reach of shot, instead of the 1 mile passage in Mr. Stokes's accurate outlines of the French chart and nose shoal, where he had marked only 12 feet of water. Compare charts A to C. That the President should have allowed this to pass, after having himself detected the imposition practised on the court, is a point upon which I will not comment. Mr. Stokes further admitted his chart to be valueless as regarded the position of the enemy's fleet ashore, for he said that the position was taken from Mr. Edward Fairfax and the captain of the Ville de Varsovie, and the British fleet from his own observations. That is, he confessed to know nothing but from hearsay as to the position of the enemy's fleet, the important object before the court, but only of the position of the British fleet lying at anchor 9 miles from the enemy's fleet ashore, a matter with which the court had nothing to do, he being all the time on board the flagship at that distance. Yet the court insisted on this chart being exclusively referred to throughout the court-martial. The President thus dictated to Captain Beresford, "Captain Beresford must say whether the ships are marked on that chart (Mr. Stokes's) as they appeared to him." Captain Beresford took no notice of the order. Captain Bligh was less independent when asked to vouch for the accuracy of Mr. Stokes's chart. He "thinks the enemy's ships on the morning of the 12th were as they're represented, though Mr. Stokes, in contradiction to his own chart, had sworn that they were not so marked, but only those that were destroyed." When asked if the ships aground could have annoyed the British ships had they been sent in, Captain Bligh replied, "I think they were capable of annoying the British ships." Minutes, page 154. He, however, immediately afterwards stated that the ships "were not within reach of the guns of the British squadron." Captain Kirk "thinks the situation of the enemy's fleet on the morning of the 12th was marked on Mr. Stokes's chart as nearly as it can be. There were 7 of sail of ship of the line ashore and 2 afloat." Minutes, page 166. What had the numbers ashore or afloat to do with their exact position? A palpable evasion of the question was permitted by the court. It is strange that such a chart should have been used at all, when the charts of the fleet were available, but more strange that, when the court saw that 2 miles passage in the French chart was reduced to little more than 1 mile in Mr. Stokes's chart, he was not even asked the reason why he had not conformed to the scale of the French chart, to the correctness of the outlines of which he had sworn. But the most glaring contradiction of Mr. Stokes's chart is this: he swore to his chart as truly depicting the positions of the Ocean and other grounded ships as they lay on the morning of the 12th of April, which was the point before the court, but being further questioned, reluctantly admitted that he had marked the Ocean as she lay on the 13th of April, viz. on the following day, when an attack was made on her by the bomb vessel, though he had just sworn to the positions of the ships on the chart as being those on the morning of the 12th, immediately after having run ashore to escape destruction. The fact was, as will be seen on inspection of the chart, that not one of the ships under the cognizance of the court is marked on Stokes's chart as they lay on the morning of the 12th, which position, and not that on the 13th, was the subject of the inquiry. This misrepresentation was detected by the President. The court nevertheless persisted in the exclusive use of Mr. Stokes's chart through the trial, in accordance with the suggestion of the Judge Advocate that it was produced to save a great deal of trouble. The President thus commented on the manifest contradiction. "I observe in the chart I had from you the situation of the Ocean, particularly, is not marked on the 12th. She is marked on the 13th as advanced up the Charente." Mr. Stokes. "The only ships marked on the chart on the 12th are those that were destroyed. The reason I marked her on the 13th is that a particular attack was made on her by the bombs. I observed her from the mizentop of the Caledonia, and I also had an observation from an officer, so that I had no doubt her position is put down within a cable's length." Minutes, page 147. Reader's note: during that quotation there is a footnote. The footnote reads 9 miles off. This answer shows most forcibly the nature of the data on which Mr. Stokes's chart was constructed. Footnote ends. There is something in the evidence almost too repugnant for observation. Mr. Stokes first swore that his chart accurately described the positions of the enemy's ships ashore on the morning of the 12th. He then admitted that the most material ship of the enemy's fleet was marked as she lay on the 13th. On this misstatement being detected by the President, he then swore that the only ships marked on the 12th were those which were destroyed, viz. on the evening and night of the 12th, a matter foreign to the subject of the inquiry, which was how the ships lay on the morning of the 12th, and whether Lord Gambier was to blame for refraining from attacking them at that particular time, so that the positions of the enemy's ships aground on the morning of the 12th, according to Mr. Stokes' own admission, were not marked on his chart at all, though he had sworn to this very chart as giving those positions accurately to the best of his knowledge and belief, and with the full knowledge that their position on the morning of the 12th, when they were helplessly aground, was the point before the court, not their position in the evening and on the following day, after their escape to a spot where the British ships could not have pursued them. The fact is, Mr. Stokes swore to their position after their being warped off in consequence of the British fleet being prematurely brought to an anchor, as being their positions previous to their escape, which was the matter of inquiry before the court, viz. as to whether the Commander-in-Chief had not committed a neglect of duty in permitting them to escape by the rising tide, when and before when the British force could have operated with every advantage in its favour. The court had nothing whatever to inquire about with regard to the ships which were destroyed, respecting which there could be no question, the subject of inquiry being whether the escape of the other ships, run ashore from terror of the explosion vessels on the night of the 11th, and still ashore on the morning of the 12th, ought to have been prevented. Not so much as one of the ships marked on Mr. Stokes's chart formed part of the group to which he had sworn in his oral evidence as lying on the western and northmost edge of the Palles Shoal nearest the deep water, all of which escaped towards the Charente, where he truly enough placed the Ocean 3-decker, but as she lay on the 13th instead of the 12th, having sworn to the truth of his chart as showing her position on the morning of the 12th. It was a desperate venture, and can only be accounted for by the supposition that in reality Mr. Stokes had never seen the chart to which he was swearing. It was no wonder, as proved in the first chapter, that Mr. Stokes applied to the Admiralty for permission to alter his chart before placing it in a court of law, where it must have fallen under my inspection. I will indeed so far exonerate Mr. Stokes from a portion of blame by declaring my belief that he never had looked at the chart to which he had sworn. There is little question in my mind but that this chart had been fabricated under the auspices of Mr. Lavie, Lord Gambier's solicitor, the only hope of success consisting in affirming a false position for the grounded ships, the chart being then given to Mr. Stokes for paternity. Had it been otherwise, Stokes could not possibly have sworn to a chart in diametrical opposition to his oral evidence, which truly stated that on the morning of the 12th, the Ocean and group lay on the north-west edge of the Palles Shoal, nearest the deep water, where they were easily attackable. On his chart they were placed on the opposite side of the shoal, where no ship could have got near them. Lord Gambier no doubt saw the mistake committed by the evidence of his master, and adroitly relieved him from the dilemma by placing a question of a totally different nature. With this course the court complacently complied, notwithstanding that the President had detected a discrepancy so glaring. Another material point on Mr. Stokes's chart was his marking a shoal between the Boyart and Palles Sands, where Captain Brompton and others present in the action, who actually sounded there, testify in corroboration of the French chart to there being no shoal whatever. Yet Mr. Stokes marks only from 12 to 16 feet in the deepest part. That this statement was a misrepresentation on the part of Mr. Stokes is proved by Lord Gambier himself, who, in his defence, says that, "Mr. Stokes found on this bar or bank from 14 to 19 feet," minutes, page 134, Reader's note, there are no closing inverted commas for this quote. When closely questioned on the point, Mr. Stokes deposed to these soundings, "as having been reported to him to have been found," minutes, page 150. The Neptune Francois gives from 20 to 30 feet at low water, which was no doubt correct. But even had there really only been 19 feet of water, Mr. Stokes again forgot his chart when he gave oral evidence that "the rise of tide in the A roads is 21 feet, which is more than we ever found in the Basque roads," minutes, page 150. I had put the rise of tide at 12 feet only, so that by the oral evidence of Mr. Stokes there was an abundance of water for the British force to have operated with full effect. A still further falsification of the chart was, that it reduced the channel by which the British fleet must have passed to the attack to little more than a mile in width, in defiance of the fact that on all the official French charts the minimum distance between the Boyart Sound and the fortifications of Isle d'Aix was nearly 2 miles, and that Admiral Stopford, the second admiral in command, confirmed the correctness of the French charts so far as to admit a width of 1.5 miles. The object of Mr. Stokes's statement was to prove the danger to which, in a channel only a mile wide, the British ships would have been exposed from the batteries on Isle d'Aix, had they been sent to the attack. To this end was the chart no doubt produced, and as narrowing the channel to a mile only, to meet the occasion, gave a colour to this view, his chart was accepted by the court, whilst the French charts, which marked 2 miles, were rejected. A yet more flagrant contradiction is, that within pistol shot of the western and north-western edge of the Palles Shoal, where Mr. Stokes first truly swore, "the Ocean 3-decker and a group of 4 lay aground on the morning of the 12th," he has placed the attacking British ships, where their logs show that they never touched the ground, notwithstanding that they took up their positions on a falling tide. If they could float in safety, much more could other ships have done so at 11 a.m. on a rising tide. How such a manifest discrepancy could have passed without comment from any member of the court-martial is a point which is not in my power to explain. Such are some of the leading features in this famous chart, upon which the acquittal of Lord Gambier was made to rest, though the chart was admittedly constructed, not from personal observation, otherwise than from the mizzen-top of the Caledonia 9 miles off, but from unofficial sources, from an anonymous manuscript, and even from hearsay. Yet Lord Gambier did not scruple to introduce this chart for guidance to the court in the following terms. "I have to call the attention of the court to the plan drawn by Lord Cochrane of the position of the enemy's ships as they lay aground on the morning of the 12th of April, and to that position marked upon the chart verified by Mr. Stokes. The former laid down from uncertain data, the latter from angles measured and other observations made on the spot. The difference between the two is too apparent to escape the notice of the court, and the respective merits of these charts will not, I think, admit of a comparison." Minutes, page 133. This statement was made by Lord Gambier in face of the admission previously made by Mr. Stokes that his observations were taken from the mizzen-top of the Caledonia 3 leagues off, that he had never sounded in the A roads, that the soundings were only reported to him, the name of the reporter being omitted, and that he had only marked upon his chart "the ships that were destroyed," on the evening and during the night of the 12th, the destruction in fact not being complete till the morning of the 13th. This contradiction is so important to a right comprehension of what follows, that I will, at the risk of prolixity, bring into one focus Mr. Stokes's admissions as to his data for the construction of his chart. "I prepared that drawing partly from the knowledge I gained in sounding to the southward of the Palles Shoal. The outlines of the chart were taken from the Neptune Francois (narrowed from 2 miles to 1). The positions of the enemy's fleet are from Mr. Fairfax and the captain of the Ville de Varsovie. For the distance between the sands I must refer the court to the chart which I copied from a French manuscript." Minutes, page 23-24. For this confused jumble from unauthoritative sources, the French charts were rejected as not being trustworthy, and Lord Gambier did not hesitate to endorse Mr. Stokes's fabrication as being from angles measured and other observations taken on the spot, whilst by this act he decried the use of the French charts by which his own fleet had been guided. Comment, whether on Lord Gambier's statement or on Mr. Stokes's involuntary contradiction thereof in his oral evidence, is superfluous. If such were wanted, it must be sought for in the fact already adduced in the first chapter, viz. that in 1817 and 1818, Mr. Stokes, when conscious that his fabrication must become public, and that it might fall into my hands, thought it prudent to make an affidavit before the Court of Admiralty that this chart, produced at the court-martial 9 years before, was incorrect, and therefore required alteration, for which purpose the Admiralty gave him back his chart, though this, as already observed, remains to this day bound up amongst the Admiralty records. The affidavits of Mr. Stokes will be in the remembrance of the reader. In a national point of view, Mr. Stokes's chart has another and even more important feature. A comparison between the French chart and that produced by Mr. Stokes will show that the latter narrowed the entrance to the Aix Roads, which on the French charts is 2 miles wide, to 1 mile, and that it filled a space with shoals where scarcely a shoal existed. Of the imaginativeness of Mr. Stokes in this respect, the French government appears to have taken a very justifiable naval advantage, calculated to deter any British admiral in future from undertaking in the Aix Roads offensive operations of any kind. A chart of the Aix Roads based on a modern French chart has recently been shown to me, as on the point of being issued by the Board of Admiralty, on which chart the main channel between Isle d'Aix and the Boyart Sand is laid down according to charts copied from fabricated charts produced on Lord Gambier's court-martial, and not according to the hydrographic charts on the Neptune Francois. The comparatively clear anchorage shown in the new chart is also filled with Mr. Stokes's imaginary shoals, the result being that no British admiral, if guided by the new chart, would trust his ships to the Aix Roads at all, though both under Admiral Knowles and in the attack in 1809, British ships found no difficulty whatever, from want of water or other causes, when once ordered in. The solution of the matter is not difficult. For the purpose of deterring a future British fleet from entering Aix Roads, the modern French government appears to have followed the chart of Mr. Stokes in place of their former official chart, and the British Admiralty, having no opportunity of surveying the anchorage in question, has copied this modern French chart, so that in future the fabrications of Mr. Stokes, or rather, I should say, the ingenuity of Lord Gambier's solicitor, or whoever may have palmed the chart on Mr. Stokes, will form the best possible security to one of the most exposed anchorages on the Atlantic coast of France. Assuredly no British admiral, with the new chart in his hands, should such be issued, would for a moment think of operating in such an anchorage, as is there laid down, notwithstanding that former British fleets have operated in perfect safety, so far as soundings were concerned. Chart D was constructed by Mr. Fairfax, the master of the fleet, and was used by the court as confirmatory of Mr. Stokes's chart, agreeing with it, in fact, on nearly every point. A circumstance not at all extraordinary, as in his examination Mr. Stokes first says that, quote, his marks arose from the knowledge he gained in sounding in the anchorage of the Aix, minutes, page 123, whilst Mr. Fairfax swore that he, quote, gave Mr. Stokes the marks, end quote. Footnote: I gave Mr. Stokes the marks, and I have all the different angles in my pocket with the different soundings. Mr. Fairfax's evidence, minutes, page 140. This evidence is truly wonderful, yet the court made no comment, and I was excluded from listening to the evidence. Footnote ends. A fact subsequently proved by Mr. Stokes, who admitted that he had never sounded there at all. The credibility of either witness may be left to the reader's judgment. In one respect the chart of Mr. Fairfax might have been considered by those interested to be an improvement on that of Mr. Stokes. The latter gentleman had narrowed the 2-mile channel of the French charts to a little more than a mile, but the chart of Mr. Fairfax reduces it to a mile only. Mr. Fairfax's chart was introduced to the court with the same flourish as had been that of Mr. Stokes. Mr. Fairfax, quote, this chart shows the state of the enemy's ships at daylight on the 12th of April. This chart is correct, except that the head of the Calcutta is placed by the engraver too far to the southward. It should have been about northwest by compass, and the head of the 3-decker Ocean is to the eastward, but not sufficiently far to the northward by compass, end quote. Not much correctness here, but abundance of misrepresentation. Mr. Fairfax is very particular about the position of the heads of the grounded ships, but, like Mr. Stokes, not at all particular, to a league or two, as to where they lay aground. For instance, he is very sensitive about the position of the Ocean's head, yet the Ocean herself is not to be found on his chart, though the names of other enemy ships aground, not far from where she had lain before her escape, are given, to mark the care with which the chart had been constructed. I will not in this place make any further observations upon Mr. Fairfax's chart, this being identical with that of Mr. Stokes. The exposure of the one in the next chapter will serve for the confutation of the other. The reader will, from what has been stated, be able to form a pretty correct idea as to why, in and subsequently to 1809, inspection of these charts was refused to me. At that period it was in vain that I published explanations which, without access to the charts, were incomprehensible to the public. My unsupported declarations, as had been said, falling to the ground unheeded, even if they were not the cause of attributing to me malicious motives towards the Commander-in-Chief, after his acquittal by sentence of a court-martial. But for the consideration of His Grace the Duke of Somerset, a stigma must have followed me to the grave. It is now otherwise, and I am content to leave the matter to the judgment of posterity. I must, however, remark that neither the charts of Mr. Stokes or Mr. Fairfax were shown to me on the court-martial, though shown to nearly every other witness, one, Captain Beresford, being told that he must base his observation on those charts. Had they been shown to me, I should in an instant have detected their fallacy. End of chapter 25. Recording by Timothy Ferguson, Gold Coast, Australia. Chapter 26 of Autobiography of a Seaman, Volume 2, by Lord Thomas Cochrane. This LibriVox recording is in the public domain. Recording by Timothy Ferguson. Chapter 26. A Naval Study Continued. The matters related in the preceding chapter will appear yet more extraordinary when contrasted with and confirmed by the evidence of eminent officers present in the action of A. Rhodes, that is, of such officers commanding ships as were permitted to give their testimony, for those who were suspected of not approving the Commander-in-Chief's conduct were not summoned to give evidence before the court-martial. In one instance, that of Captain Maitland, of the Bellerophon, whose opinion on the subject had been freely expressed, this gallant officer was ordered to join the squadron in Ireland, so as to render his testimony unavailable. To a gallant officer still living, Admiral Sir Francis William Austen, K.C.B., who was present in Basque Roads, but, like other eminent officers, not examined on the court-martial, I am indebted for a recently expressed opinion as to the causes why the majority of the enemy's ships were suffered to escape beyond reach of attack, as well as of the persecution which I afterwards underwent, in consequence of my conscientious opposition to a vote of thanks to the Commander-in-Chief. The following is an extract from the gallant Admiral's letter. Quote, "I have lately been reading your book, the Autobiography of a Seaman, and cannot resist the desire I feel of stating how much pleasure I derived from its perusal, especially of that part which has reference to the movements of the fleet in the Mediterranean from 1798 to 1800. Having been serving for the greater part of those years on that station, your narrative excited in my mind a vivid recollection of former times, as it were living that part of my life over again. With reference to the latter part of the volume which details the proceedings in the attack on the enemy's squadron in the Scheldt, I wish to say as little as possible which may inculpate the conduct of the Commander-in-Chief, to whom, as you probably know, I owe a debt of gratitude for his kindness to me. But at the same time I cannot but admit that he appears to me to have acted injudiciously. It would have been far better had he moved the squadron to a position just out of reach of the batteries on Isle d'Aix, when he would have been able to see the position of the enemy's ships, and thus have decided for himself whether they could have been attacked without needless risk, and not have been compelled to form his determination entirely on the report of others," who were more interested in the failure of the action than its success, from the fact shown in the first volume of the ill-feeling manifested towards me, in consequence of my being a junior officer temporarily appointed, though against my will, and after all others had declined the enterprise. Footnote ends. Had he done so, it seems probable that he would have seen things in a different point of view, and decided to send in a force sufficient to have captured or destroyed the whole. I must in conscience declare that I do not think you were properly supported, and that had you been so, the result would have been very different. Much of what occurred I attribute to Lord Gambier's being influenced by persons about him who would have been ready to sacrifice the honour of their country to the gratification of personal dislike to yourself, and the annoyance they felt at a junior officer being employed in the service. Footnote: though I had suggested the plan, after all other suggestions had failed to satisfy the Board of Admiralty. Footnote ends. I will only add that I consider your services in the Speedy, Pallas, and Imperieuse will entitle you to the warmest thanks of your country, as well as to the highest honours which have been awarded for similar services, instead of which you have in numerous instances been persecuted in the most cruel and unrelenting manner. I desire to subscribe myself with much respect and esteem, my dear Lord Dundonald, yours very faithfully, Francis W. Austen, Admiral the Earl Dundonald. Letter ends. If anything could alleviate the remembrance of the bitter persecutions originating with this one-sided court-martial, it is an unsolicited expression of opinion like that of the gallant Admiral Austen, whose name, for evident reasons, was not included in the list of those summoned to give testimony on that remarkable occasion. The other gallant officers still living entertained similar sentiments, I make no doubt, for the simple reasons that, as honourable men, it is impossible for them to entertain other opinions. What would have been the result if the court-martial had such testimony as that of Admiral Austen been permitted may safely be left to the public decision. The gallant Admiral, and the Navy public at large, will perhaps be surprised to learn that my persecutions have not ceased at this day. Despite my restoration to rank and honours, my banner has never been restored to its place in Henry VII's chapel. The unjust fine inflicted on me in 1814 has never been remitted, nor are the rights withheld during my forced expulsion from the Navy conceded, the excuse being want of precedent, though with that of the gallant Sir Robert Wilson fresh in the archives of the nation. Footnote: this fact, together with the particulars of Sir Robert Wilson's restoration, was obligingly communicated to me by that distinguished patriot Joseph Hume, together with a letter expressive of his surprise that my restoration had not been rendered complete. This letter and the enclosures will be given in another place. Footnote ends. A few words may here be devoted to a point intimately connected with this subject. In several reviews on the first volume of this work, the public has been told of the handsome rewards which have been bestowed for my services. The reader will perhaps be scarcely prepared to learn, in answer to such statements, that with the exception of the ordinary good service pension, granted for general service in 1844, 35 years after the action in Aix Roads, I never in my life received a recompense from my country in any shape, the Order of the Bath alone excepted. For my services in the Pallas, that of destroying 3 heavily armed French corvettes at the embouchure of the Garonne, and cutting out the Tapageuse, all performed in one day, not a shilling was awarded to myself, officers and crew, though in the late war with Russia, I have been told that the destruction of a Russian gunboat was scrupulously paid for. For my services on the coast of Catalonia in the Imperieuse, to which Lord Collingwood testified that, single-handed, I had stopped the advance of a French army, not a farthing was conceded, whilst the thanks of Lord Collingwood were the only expressions of the kind ever awarded for what English historians have eulogised even more highly than did his lordship. As for the partial destruction of the enemy's fleet in Aix Roads, not a farthing was given to myself, officers, or crew. But 9 years afterwards, when told that I might take my share of head money with the rest of the fleet, I replied by refusing both the offer and the money, on the ground that the ships only which took part in the action had a right to it. The reader will pardon this brief digression, which has arisen from Admiral Austen's allusions to the persecutions unworthily inflicted on me, and I have chosen the opportunity to set the public right on a subject which has been much misapprehended to the detriment of myself and family. Neither directly nor indirectly have my services throughout my whole career ever cost the country a penny beyond the ordinary pay and ordinary good service pension to which my rank entitled me, nor did any of my family ever receive a place under government, other than that to which they have risen in the ordinary course of naval promotion. Footnote: My third son is a post captain, and my youngest a commander in the Navy, both having won their rank by services in action. With regard to my eldest son, Lord Cochrane, the public shall judge of the favour shown to him on my account. He was originally placed in the Navy, in which he served 4 years, but was driven from the service by the animosity excited by the imputations against his father. After this he entered the army, in which he served 18 years. He was engaged throughout the Canadian Rebellion, and subsequently for 8 consecutive years in the pestilential climate of China during the war. He there served under Lord Clyde, acted as aide-de-camp to Major General d'Aguilar, and subsequently as Quartermaster General. His health having at length broken down under the arduous nature of his duties, he having been, as I have reason to believe, the only officer who remained for so long a period on a station proverbially unhealthy, he was ordered home on sick leave, and had to undergo the unusual mortification of being periodically, and that too at short intervals, ordered to appear before the Medical Board in London. This was actual persecution, nor did it cease until Major General d'Aguilar himself went to the Horse Guards and remonstrated against such conduct being pursued towards an officer whom he had sent home as being worn out by 8 consecutive years' hard duty. On my son's asking for an unattached majority by purchase, he was told that his length of service from 1833 to 1851 was insufficient, notwithstanding that he gave the precedent of earlier promotion in the case of an officer who had married the daughter of the Master General of the Ordnance, and who had got his majority at 11 years. Finding no prospect of promotion, my son sold out, quitting the army as a captain, as the state of his health did not warrant him returning to his regiment. I adduce this as a specimen of the kind of reward bestowed on me or my family. Footnote ends. After this positive assurance on my part, I feel confident that the portion of the press which has expressed an opinion that "I have been amply rewarded for my services," will do me the justice to acknowledge an unintentional error. Since the receipt of Admiral Austen's letter, I have been favoured with another from Captain Hutchinson, who, at the time of the action in Aix Roads, was a lieutenant in the Valiant, one of the 2 line-of-battle ships reluctantly sent to the assistance of the Imperieuse when engaged single-handed with 3 of the enemy's ships. Captain Hutchinson was, therefore, in action throughout the whole affair, but, like Admirals Austen and Maitland, was not summoned to give evidence at the court-martial. Captain Hutchinson's letter, whether in point of fact or ability, deserves to be put on record as proof that when naval officers have the opportunity of speaking their minds on any subject connected with their noble profession, there are few amongst them who will let self-interest outweigh the honour of the service. So complete is the information voluntarily given by Captain Hutchinson, with whom I have not had the pleasure of being even personally acquainted, that it might have saved me much of the lengthened critical explanation into which my sense of duty to the naval service, as well as to my own reputation, has compelled me to enter. As a further corroboration of my own proofs, written before the reception of Captain Hutchinson's letter, I can only tell that gallant officer how highly I appreciate it, and shall be surprised if the rest of my brother officers do not form the same judgment. Cumberland House, Chillingham, Canterbury, June 8th, 1860. My Lord, I have read with great interest the first volume of your Autobiography, and if the second is not yet published, it is possible that what I have to communicate may be of some service in any further notice you may give of the attack upon the French fleet in Aix Roads. I would not otherwise have taken the liberty of writing merely to express the interest taken in your memoirs, since I can only entertain that in common with every naval officer who has any true love for his profession, and of esteem for those who have so eminently adorned it by their gallantry and skill. I was 5th or junior lieutenant of the Valiant on the mortifying occasion above mentioned, and can bear testimony to the indignation which pervaded the whole fleet in witnessing the total want of enterprise and even common sense of duty which then permitted so many of the enemy's ships to escape when they were entirely at our mercy. I have, however, to mention some circumstances which may throw light upon the mystified dispatch of Lord Gambier, which certainly surprised all those who were present. In the first place, Lord Gambier can have given no positive orders to Captain Bligh of the Valiant to attack the French ships which were aground at the time indicated in the despatch, for after we anchored off the Boyart Shoal, Captain Bligh, seeing you go in with the Imperieuse unsupported, after waiting some time, expecting to be ordered by the Commander-in-Chief to assist you, went in his gig on board the Caledonia to volunteer his services. Lord Gambier expressed himself greatly obliged, but said that some other ship must accompany, upon which Captain Bligh selected the Revenge, from regard for Captain Kerr, who had been acting for him in the Valiant some time before, when he had occasion to go on leave of absence for private affairs. We accordingly ran in, as your Lordship has detailed, and I have nothing to remark as to what followed, but one circumstance of which your Lordship does not appear to have been aware. No doubt you would have observed that on the evening of the 12th the crews of the Ocean and two other enemy's line of battle ships near her were evidently flying from them in a panic, numerous boats from the shore assisting in conveying them from their ships. This was so apparent that our captain, Bligh, went in his gig with two other captains as soon as it was dark to reconnoitre these ships with a view to take possession of them with boats, if they were deserted. These captains returned, however, reporting that they had found them surrounded by boats, etc., and that consequently they could not be attacked. In the morning, however, no boats were near them, nor were any persons seen stirring on board them, and it was not until about 10 o'clock, I think, that the crews, finding that we had not taken possession, took courage, ventured to return on board their ships, and immediately began to warp them out of our reach. Captain Bligh was a man of the firmest nerve I ever knew, and therefore I can only suppose that the boats he saw were still engaged in carrying the crews on shore, though I believe it was at least 10 o'clock at night when he went to reconnoitre, and I know we were greatly puzzled at the time to account for the presence of these boats. As a proof that these ships were totally deserted that night, I need only refer your Lordship to the account of Admiral Graviere, quoted by you, where he says, "The panic was so great that ships which had not even been attacked were abandoned by their crews." But, my Lord, we heard soon after this disgraceful affair, by means of some French vessel which had been boarded or taken, that such was the case. I do not now perfectly recollect how this information reached us, but we had no doubt of the fact at the time, it only being in accordance with our own observations and conjectures. I exceedingly regret that I did not make note of this at the time, but the belief in the fact of the crews having deserted those three ships was so general and undoubted that it never occurred to me that it might be questioned. The report went further, and added one singular circumstance, that there was one man who did remain when all the remainder of the crews quitted. This was a quartermaster on board the Ocean, who, indignant at the cowardly desertion of the ships, hid himself when the crews were ordered to quit, and this was the salvation of that three-decker and the two other ships in a very extraordinary way. A little midshipman belonging to one of our smaller vessels, I believe a brig, had been sent in a jolly boat that night with a message to another ship, and having delivered it, instead of returning immediately to his own vessel, he proposed to his men to go and look at the French ships, from which the crews had been seen to fly. His men, of course, were willing, and they approached cautiously very near to the three-decker — the night was very dark — before they could observe any stir on board or around her. They were then suddenly hailed by the quartermaster before mentioned, with a loud "Qui vive?" Of course the poor little midshipman took it for granted that the ship was occupied by more than one man, and he hastily retreated, glad to escape capture himself. But had he known the truth, that little midshipman, with his jolly boat and 4 men, might have taken possession of a three-decker and 2 74s. This seems more like a story of romance than an actual occurrence, and I greatly regret that I did not then make note of every name and circumstance, which, at this distance of time, I cannot call to mind. But I have never entertained any doubts as to the facts here detailed, and I have always mentioned them in speaking of that most unsatisfactory affair of Basque Roads. Admiral Graviere's account is a positive confirmation of what we observed and fully believed as to the abandonment of the ships, and I only wonder that he should not have mentioned the noble conduct of the quartermaster. Admiral Graviere, however, would probably not have heard of the approach of the boat, and the quartermaster himself would not, perhaps, have reflected upon the possible danger the ships were in from the approach of only one little boat. Yet, if he had not been there to hail that boat, it is more than probable that the little midshipman would have continued cautiously to approach till he discovered that the ships were entirely deserted, and he would either have ventured to take possession himself, or would certainly have returned to report the circumstance, and a proper force would have been despatched to take advantage of the abandonment, if it had been found as he reported. It was the supposed abandonment of the ships, indeed, which induced him to approach them at all, and it was this also which induced Captain Bligh to reconnoitre. These, my lord, are the only circumstances I had to communicate, and no doubt they will be in some degree interesting, though not wholly satisfactory, from my inability to establish the perfect correctness and truth of them. I have not, and never had, any doubt myself, though I am by no means inclined to believe cock and bull stories. Of one thing I am very certain: there was a universal conviction that, but for the ingenious ruse adopted by your lordship of running in singly with the Imperieuse, and then making a signal of distress, or rather of want of assistance, nothing whatever would have been effected against the French fleet. I remain, my lord, your very obedient servant, Charles Hutchison, Captain, Royal Navy. The Right Honourable the Earl of Dundonald. Reader's note, letter ends. To return to the testimony of eminent officers at the court-martial, by which evidence Admiral Austen and Captain Hutchison will be pleased to find their disinterested opinions corroborated, the first evidence adduced shall be that of another distinguished officer, also still living, viz. Admiral Sir George Francis Seymour, K.C.B., G.C.H., who commanded the Pallas frigate at the action of Aix Roads, and remained by me when the line of battleships left the roads on the morning of the 13th of April. An attempt was made to stop the evidence of Captain Seymour nearly at its commencement by Lord Gambier, remarking that he had "no further questions to propose to Captain Seymour," who, however, promptly asked whether he was not "bound by his oath to relate every circumstance within his knowledge respecting the proceedings of the fleet." Minutes, page 190. To this pertinent query the President replied, "If the questions that are asked you should not seem to embrace all circumstances to which it refers, you are still bound to relate them." Minutes, page 190. Captain Seymour: "From what period am I to give my answer?" President: "From the time of your being sent in to attack the enemy, and your having remained there." Captain Seymour: "Without going back to the 11th?" President: "No. I take it from your going in on the 12th." Minutes, page 193. The President thus authoritatively stopped Captain Seymour from saying a single word relative to the neglect of the Commander-in-Chief in not having sent ships to attack before the Ocean and group floated away, as the Pallas and other vessels were withheld until the afternoon of the 12th. This, however, did not prevent Captain Seymour from taking the course which he had evidently proposed to himself. Captain Seymour: "I think the ships might have floated in sooner, that they might have come in on the last half of the flood tide," which rose as high as the last quarter of the ebb tide, when 2 line of battle ships were sent in and remained without grounding. President: "How much sooner would that have been than the time they actually did go in?" Captain Seymour: "At 11 o'clock." President: "At what time did the line of battleships go in?" Captain Seymour: "Within a short time after 2 o'clock." Minutes, page 193. These 3 hours made all the difference in the result of the action, and were, in fact, the point of inquiry before the court. At 11 o'clock the whole fleet came to an anchor in Little Basque Roads, instead of detaching a force to attack the enemy, as Captain Seymour testifies they might have done. The French ships were at that time helplessly aground. Seeing the British fleet come to an anchor, the enemy took heart, and strained every nerve to warp off, in which, being unmolested, they succeeded by throwing their guns and stores overboard, and soon after 1 o'clock had effected their escape. At 2 o'clock, seeing me go in with the Imperieuse in order to prevent the other ships from escaping also, and rightly appreciating the risk I was running single-handed, the Commander-in-Chief then, but not till then, reluctantly sent in 2 line of battleships and some frigates, and this only after repeated signals, the final one necessarily being in want of assistance. So that no attack was made on the enemy's ships till after the escape of the Ocean, and all those nearest the deep water, though these were most easily attackable. Nor would any attack have been made at all but for my last signal. Had Admiral Seymour been permitted to speak to this point, his evidence would have been the most conclusive, as the President must have seen when he ordered the witness to speak only as to what occurred after he was sent in, that is, after the French ships had escaped, which was the subject of the inquiry, about which Admiral Seymour was thus ordered to say nothing. This forms, in fact, the history of the whole affair. 3 French ships only being attacked in the afternoon, after all the outermost had been quietly permitted to heave off and escape during the morning, and with a rising tide in favour of the British force. Captain Seymour's highly honourable pertinacity in giving the above important opinion as to what was clearly the duty of the Commander-in-Chief at 11 o'clock, after he had been cautioned by the President not to speak of anything which occurred previous to 2 o'clock, when the Pallas was sent in, will be regarded, as it deserves to be regarded, in the light of truth and honour holding itself superior to power. For the sake of the service no less than that of Admiral Seymour, I am proud to record this instance in which self-interest weighed nothing in comparison with the interest of the country and the service which Captain Seymour evidently considered to be at stake. This reply of Captain Seymour took the Court by surprise, as opening the very point sought to be avoided. This led to the subjoined angry remonstrance from Admiral Young. Admiral Young: "The general question is not meant to subject the general conduct of the Commander-in-Chief to the opinions of all the officers serving under his command. If you think the two ships, Revenge and Valiant, not going in so early as you think they might have floated, to be an instance of neglect, it is your duty to state it, that we may inquire into it, and hear any other evidence upon it." The tendency and peculiarity of this remark to Captain Seymour is worthy of note. It more than insinuates that he was incapable of forming a correct judgment, and plainly tells him that his evidence will go for nothing but to hear any other evidence upon it. A perusal of the minutes of the court-martial will show the meaning of this expression, viz. that when any officer in command spoke his mind on the subject, the next witness was a master or other inferior officer to contradict his evidence. For this purpose masters and others were recalled over and over again, which is one of the most curious features of the court-martial. Captain Seymour had said nothing about the two ships, but that the ships, meaning the British line of battle ships, might have gone in to the attack at 11 o'clock, and thus replied to the insinuation. Captain Seymour: "I have already stated that I cannot say it was misconduct. I state the fact, and leave the Court to judge." Admiral Young: "You state an opinion that the fleet would have floated at 11 o'clock." Captain Seymour: "Yes, that there was water enough." Admiral Young: "Is that all you mean to say, that there would have been enough water for them to have floated in?" Captain Seymour: "Yes, that is all I have said." Admiral Young: "When you say that the ships of the line would have floated in at 11 o'clock, do you mean to speak to the depth of water alone?" Captain Seymour: "I confine myself to the meaning of the words, that there would have been water enough for the line of battle ships to have floated in. That is what I mean to say. With regard to the opposition they would have met with, the Court have as much before them as I have." Minutes, page 195. Footnote: "Two ships of the line afloat, viz. the Foudroyant and Cassard. These," said Lord Gambier in his defence, "must have entirely crippled every one of our ships in their approach through so narrow a channel, besides which some of the grounded ships were upright, and could have brought their guns to bear on the entrance." Lord Gambier's defence, Minutes, page 125. "Two enemy's ships, both of which made sail for the Charente the moment the escaped ships have got off, must have entirely crippled a powerful British squadron." Footnote ends. That is, in Captain Seymour's opinion, the fleet ought to have proceeded to the attack at 11 o'clock, instead of then coming to an anchor, and by that act giving the enemy's ships aground ample time to warp off and escape, which they would not otherwise have attempted, a point on which all French writers agree. Attention must here be drawn to Admiral Young's constantly repeated expression, "floated in." The expression appears to have been used not more to prevent Captain Seymour from using any other, than to convey the idea that there was no room in the channel for operations, but the ships, if sent to attack, must have floated or drifted in, exposed to the fire of the enemy, had Lord Gambier directed them to do so. At the conclusion of Captain Seymour's evidence, so clear and so conclusive, the Commander-in-Chief had the bad taste to remark that he "did not consider it of the least consequence." Minutes, page 196. An opinion in which posterity will most assuredly not coincide. I must here repeat that I was not permitted to be present in the Court during the examination of the witnesses, or to know who had been summoned to appear. The evidence of Captain Seymour and that of several other eminent officers would not have been taken at all had I not contrived to ascertain the names of those summoned. Finding that most of these had either not been present in the action, or were known to be in the interest of the Commander-in-Chief, I went on the half deck of the Gladiator, and wrote a note to the Court, pointing out the unfairness of such proceeding, and naming other officers who ought to be examined. They were then summoned, and their evidence will be conclusive to the reader, as it ought to have been to the court, and would have been so had not the court itself been picked by the government, that is, principally composed of officers who had been ordered to hoist their flags to qualify them for sitting on the court-martial, which being ended, they were ordered to strike their flags. As a contrast to the evidence of Captain Seymour, I will turn to that of 3 officers who were not present in the action, and in fact do not appear to have been in Aix Roads at all, either before or after it, though without a minute knowledge of those roads they could not be competent to give even a general opinion on the subject. Without reason assigned, as indeed it was not in their power to assign any, each thus delivered his testimony. Question put to each in succession: Was everything in your judgment done that could be done to effect the destruction of the enemy's ships? Captain Burleton: I think there was. Captain Ball: I think there was everything done. Captain Newman: Perfectly so. Question: From the time the Commander-in-Chief arrived in Basque Roads to the time of your quitting it, can you state any instance of neglect, misconduct, or inattention on his part to the public service? Captain Burleton: I know of none. Captain Ball: No, I cannot. Captain Newman: None. Widely different was the testimony of Captain Malcolm of the Donegal, the late Admiral Sir Pulteney Malcolm, whose love of truth, like that of Captain Seymour, was not to be fettered by negatives in reply to leading questions. Captain Malcolm thus spoke of the only 2 enemy ships afloat, Foudroyant and Cassard, which 2 ships Lord Gambier in his defence said must have entirely crippled the whole British force had it attempted to pass the channel leading to Aix Roads. "When those ships quitted their stations, there was then no obstacle to prevent the small ships from going in, by which I mean the frigates, or even 74s. The fire from Isle d'Aix they nearly avoid by keeping near the Boyart." Captain Malcolm's Evidence Minutes, page 208-209. Ends. Lord Gambier had stated in his defence that he refrained from sending in the ships on account of the danger from the fire of the fortifications. Mr. Stokes supported this view by swearing that the ships would have been within point-blank range of shot. The assertion of Captain Malcolm that they would be nearly out of reach of shot, which was true, was malapropos, though not to be shaken by the testimony of an inferior officer. It was therefore dangerous to recall Mr. Stokes in opposition to so high an authority as Captain Malcolm. Captain Kerr was consequently recalled, whilst Captain Malcolm was under examination, to say that his ship was once hit from the batteries. After which extraordinary interruption, Captain Malcolm was suffered to proceed with his testimony. President: Was the enemy's 3-decker in a situation on the morning of the 12th to have done any mischief to ships that had been sent in? Captain Malcolm: Till about noon she was heeling considerably, and appeared to me to be throwing her guns overboard. When she righted, she could have annoyed ships coming in. Question: At what time did the 3-decker remove from the situation where you saw her on shore heeling? Captain Malcolm: About 2 o'clock. I took no note of the time. Question: Would you have sent ships in before the 2 ships were removed and the 3-decker got off? Captain Malcolm: Had it appeared to me that there was no other chance of destroying those ships but by such an attack, I certainly think it ought to have been made. It was understood that they must all again ground in the mouth of the Scheldt, where it was the received opinion that they could be attacked by bombs, gun vessels, and fireships again without risk. Question: Upon the whole, are you of the opinion that, of all the French ships which got ashore on the night of the 11th of April, any more could have been destroyed than were destroyed had the British ships been sent in on the 12th of April to attack them? Captain Malcolm: Had they been attacked by the British ships, in my opinion, they could not have been warped off from the shore, as it was necessary to lay out anchors to heave them off. Those that were not aground had always the option of running further up the Charente. It should be understood that it must have been at the risk of our fleet, as I have already mentioned. Minutes, page 209-211. Of course, every naval combat must be at the risk of fleets. Such risk, in my judgment, forming the chief object in building fleets for the purpose of encountering it. But the risk of a whole squadron from 2 ships afloat and a 3-decker ashore, heeling over and throwing her guns overboard, is what no brave seaman would ever take into consideration. The chief risk, as has been alleged by Lord Gambier, was from the fire of the batteries on Isle d'Aix, which he had shortly before pronounced no obstacle. What this was may be judged from the fact that Captain Seymour in the Pallas, Captain Wolfe in the Aigle, and myself in the Imperieuse lay for 2 days in this formidable position without loss of any kind. The reply to the next question put to Captain Malcolm ought to have been conclusive with the court. Question. Would you, had you commanded the British fleet, have sent in ships to attack the enemy's ships on shore? Captain Malcolm. The moment that the 2 ships quitted their defensive position, the risk was then small of sending ships, and of course I would have sent them in instantly. Minutes, page 212, quote ends. This was spoken like a seaman. No greater contrast can be set in juxtaposition with such evidence than that of the chartmaker Stokes, the master of Lord Gambier's flagship, who, though of no higher rank than that of warrant officer, was gravely consulted as to what in his opinion was the Commander-in-Chief's duty. The subjoined evidence of Mr. Stokes is very curious, not only from its effrontery in contradiction of superior officers, but in its own flat and unblushing contradiction to itself. The portion of Mr. Stokes's evidence placed in a double column is truly wonderful, but it is more wonderful that any tribunal should have so far forgot itself as to act upon it. Quote, the ships would have been at half range of shell and point-blank shot. Minutes, page 148. They would have remained under the fire of the enemy's batteries till the tide floated them to the southward of the Pallas Shoal, but this retreat, in my opinion, they would not have been able to have gained. Page 148. If we had made the attack on the morning of the 12th, we should have sacrificed our own ships without making any impression on the enemy or destroying any of their ships. Page 148. Readers note the text now splits into 2 columns to allow comparison of the 2 texts. What follows is the first paragraph from the left column, the first paragraph from the right column, then the second paragraph from the left column, and the second paragraph from the right column. The left column begins, the enemy's ships were fast on the ground with their sterns to the westward, and they could not bring their guns to bear on the ships that attacked them. Had the French ships grounded with their broadsides flanking the passage, they could not have been attacked with the least prospect of success. Page 155. The first paragraph on the right column reads, the 3-decker lay with her broadside flanking the passage. They all 3 could have fired with complete effect on any ships that might approach. Page 149. Left column, paragraph 2. I had told Sir H. Neale that perhaps we might destroy some of their ships, but that we should sacrifice our own. Footnote. This was said with the full knowledge that when our own were reluctantly sent in, no damage was sustained. To use Lord Gambier's own words in making his defence, not one, even of the smallest of our vessels employed, has been disabled from proceeding on any service that might have become necessary. Minutes, page 138. A circumstance not at all expected by the country when the destruction of the enemy's fleet was required. Footnote ends. Right column, paragraph 2. Had foresail of the line run into Aix Roads when Lord Cochrane made the signal, the whole fire of the Isle d'Aix, as well as the fire of the Foudroyant, Cassard, and Ocean 3-decker, would have been directed on them. Reader's note, column's end. The only comment here necessary is that nothing in the evidence volunteered by Totus Oates in former years displayed greater effrontery. The evidence of the other chartmaker, Fairfax, is almost as astounding. Question. Would ships of the line sent in have been within range of shells and shot from the enemy's batteries? Fairfax. From every chart I have seen, they certainly would. Question. Could any of the enemy's ships, before they run up the Charente, have annoyed and even raked any of the King's ships that might have been sent to attack them? Mr. Fairfax. They certainly lay in a favourable place for it. Minutes, page 144. Footnote. This reply is very characteristic. He knew, as Stokes swore, that the enemy's ships were aground with their sterns to the westward, and that not only could they not return a fire, but that a broadside from a British ship must have gone clean through them from stern to bow. But, unlike Stokes, he would not swear that ships in such a position could have annoyed and raked the King's ships. The enemy's ships were merely in a favourable place for it. And so they were, had they been afloat, instead of helplessly ashore, heeling over at an angle of 30 degrees. Footnote ends. Question. Had even 2 or 3 ships of the line been sent in to attack those 2 ships, were any of the enemy's ships aground in a position to annoy our ships either in the anchorage or in their approach to it? Mr. Fairfax. Some of them certainly were. Page 145. Question. If a part of the fleet had gone into Aix Roads when the Imperieuse made the first signal, must it have remained within 3/4 of a mile of the batteries till the ebb made? Mr. Fairfax. They might have shifted with the flood. Page 146. Quotation ends. The ingenuity of Mr. Fairfax in avoiding straightforward answers to embarrassing questions is remarkable. He was one of Lord Gambier's tract distributors, spoken of in the first volume. But though he had no objection to construct an imaginary chart to serve his chief, his conscience would not permit him to swear to its contents. Nevertheless, such evasion ought not to have been tolerated by any tribunal. Yet on the charts and evidence of Stokes and this man was the result of the court-martial made to rest, in opposition to the testimony of officers of standing and character. The opinion of another eminent officer, Captain Broughton, of the Illustrious, will be even more to the purpose. President. From the first attack on the ships of the enemy on the evening of the 11th of April to the time of your leaving Basque Roads, according to your judgment, was everything done that could be done to effect the destruction of the enemy's ships? Captain Broughton. I think it would have been more advantageous if the line of battleships, frigates, and small vessels had gone in at half flood, which I take to be at about 11 o'clock a.m. or 12. The French admiral and 2 more got off and made sail towards the river very soon after the 2 that were afloat. Footnote, precisely the time at which Lord Gambier ordered the fleet to come to an anchor, after it had been got under way with every indication of proceeding to an attack. Footnote ends. Question. By the French admiral, you mean the Ocean? Captain Broughton. Yes. Question. As the 2 ships that remained at anchor did not change their position till about noon, and the Ocean continued in her position till about the same time, if the British fleet had been ordered in at 11 o'clock, which you thought would have been the proper time, Captain Broughton, I would rather say between 11 and 12, which in my judgment was more advantageous. Question. Would not the ships sent in have been exposed to the fire of the 2 ships that remained at anchor, the French admiral's ship and the batteries of Isle d'Aix at the same time? Captain Broughton. Certainly, but I conceive they were partly panic-struck, and on the appearance of a force coming in, might have been induced to cut their cables and try to make their escape up the river. Minutes, page 219 to 221. Quote ends. There was not much to be feared from a panic-struck enemy, with only 2 ships afloat out of 13, 11 being on shore. Yet those who peruse the minutes of the court-martial will marvel to find these 2 ships set up as bugbears to a British fleet. I will next adduce Captain Broughton's testimony as to the trifling opposition to be anticipated from the batteries on Isle d'Aix, which 3 weeks previous to the action had been pronounced no obstacle by the Commander-in-Chief in his letter to the Admiralty, but were now considered formidable enough to prevent a British fleet from passing within 2 miles of them. It may be here remarked that Captain Broughton was well acquainted with these batteries from having previously been here under Admiral Keats, as they were familiar to me from having been employed on the same spot under Admiral Thornborough, and having in fact engaged the Minerve frigate under their fire, which I held so cheap as to not consider them or their ineffectual fire worthy attention. As Admiral Austen well remarks, all Lord Gambier knew respecting them was from the reports of others, who had not even ventured closely to reconnoitre the batteries. The report of Captain Broughton, who had reconnoitred them, was not acted upon. President. In your services in Basque Roads, had you any opportunity of making observations upon the state of the enemy's fortifications on Isle d'Aix? Captain Broughton. Yes, I had. President. Narrate those observations. Captain Broughton. I was on board the Amelia when she was ordered to dislodge the enemy from the Boyard Shoal, and being nearly within gunshot, I observed the fortifications. Footnote. Mr. Stokes said ships going in must have been at half range of shell and point-blank shot. Minutes, page 148. Mr. Stokes's observation was taken from the mizzen-top of the Caledonia, that of Captain Broughton from actual exposure to the fire of the batteries. Footnote ends. I observed the fortifications. They appeared to me in a very different state to what I observed them when serving 2 or 3 years before under Sir Richard Keats. I thought they were repairing the works from the quantity of rubbish that was thrown up, and I counted on a semicircular battery which commanded the roadstead where the enemy lay between 14 and 20 guns. I am not positive as to the exact number. There was a small battery lower down nearer the sea. I do not know the exact number of guns. There might be 6 or 9, I suppose. What I had before taken to be a blockhouse above the semicircular battery seemed to have no guns whatever. It appeared to be a barrack for containing the guard. I thought from this observation that the fortifications of the island, at least in part, were not so strong as we supposed, and I reported my opinion to that effect to Lord Gambier. President. — Are those the only guns you observed on Isle d'Aix that could bear upon the anchorage? Captain Broughton. — They were all that I observed. There might be more. Question. — Did it appear to you that the enemy was constructing new works in front of the old ones and nearer to the sea? Captain Broughton. — I think the rubbish was the remains of the old works that had been taken down. President. — Would your Lordship wish to ask any questions on the subject? Lord Gambier. — I would wish Captain Broughton to point out on the chart the situation of the Amelia when he was on board her and made those observations. Captain Broughton. — The south point of the Isle d'Aix was just shut in with Forest Castle, and I think the bearing was nearly S.E. and by east when it was open. When it was touching the point, we were just out of gunshot from both sides. They fired at us from both sides, but the shot did not reach us. Minutes, pages 218 to 219. Quote ends. This was decisive, and in his defence the Commander-in-Chief thus attempted to evade the facts which had been officially reported to him by Captain Broughton. To contradict them was impossible. Quote, — "With respect to the force of the Aix batteries, I apprehend what appeared to Lord Cochrane and to the master of his ship as ruins of the fort were, in fact, materials for improving or increasing the work. Indeed, can it be natural to suppose that the enemy, who are so active in forming batteries wherever they can be useful, and whose engineers are considered to be equal to any, would, of all moments, choose that for dismantling or blowing up works when they expected those works would be most required? For it is very certain the enemy was as fully apprised of our intentions of attacking their fleet as myself." Footnote. Lord Gambier had just before written to the Admiralty that an attempt with fireships would be hazardous if not desperate. He had no intention of attacking otherwise. And after the enemy's ships had been driven ashore by the explosion vessels, Captain Broughton testifies to Lord Gambier's expressions that he did not intend to make an attack, as the object of their destruction seemed to be already accomplished. That is, neither before nor after the action did he intend to make any attack with the fleet, nor would he have done so unless a partial attack had been forced on him by my signal on the afternoon of the 12th of April. Footnote ends. And it will perhaps be considered less likely that the enemy should weaken their defences on Isle d'Aix, raised evidently for the protection of their fleet, when at the same time they were endeavouring to form others on the Boyart Shoal as a protection for it. Minutes, page 135. Quote ends. There was no supposition in the matter, nor any necessity for hypothesis, in the face of the fact that the fortifications were for the most part debris, or as Captain Broughton termed them, a mass of rubbish. No one said that they had been blown up, or that the enemy were weakening their defences. The fact is, that only a month before the action, Lord Gambier had himself set the matter at rest by writing to the Admiralty as follows, quote, "The advanced work between the Isles of Aix and Oleron, I find, was injured in its foundation, and is in no state of progress. It is therefore no obstacle to our bombarding the enemy's fleet." Yet it was now an obstacle to even attempt attacking ships on shore, and Lord Gambier condescended to resort to just the quoted assertions in contradiction to his own letter to the Admiralty. On the utter worthlessness of the batteries as calculated to impede the operations of a British fleet, there was abundant evidence before the court, as will be seen on an examination of the minutes of the court-martial. Such testimony confirming the correctness of Lord Gambier's letter to the Admiralty on the 11th of March, and completely disproving his Lordship's contradictory assumptions in his extraordinary defence, read to the court. Captain Broughton was next examined with reference to the imaginary shoal which forms so conspicuous an object on Mr. Stokes's chart. Quote, "If the ships had been damaged in masts and rigging, considering the direction and strength of the wind at that time, was there any place those ships could have retired to?" Captain Broughton. "I think, as the wind was northwesterly and northerly, they might have found safe anchorage and protection in what was called in the French chart I had on board La Grande Trousse, where there is 30 or 40 feet of water, out of range of shot or shells in any direction." Question. "How many ships would you have thought it necessary to send into Aix Roads to attack the enemy?" Captain Broughton. "I should think 5 or 6 ships of the least draught of water." I conjecture that the discomfited French squadron would have made very little resistance. From the situation in which the enemy were, not having recovered from the fright of the night before, I think our loss would have been very little, as few of the French ships were in a situation to fight their guns. Question. Do you know that from the anchorage in Aix Roads to the anchorage you have now just described, there is a bar goes across? Captain Broughton. No. I do not know anything of it. I sounded from the wreck of the Varsovie to that anchorage and found no shoal there. President. That is not the place. It is marked in some of the charts that between the Boyart and the tail of the Pallas there is a bar. Captain Broughton. I sounded as I came in from the fleet, but did not find any bar. Minutes, page 221 to 233. End quote. The extraordinary conduct of the President in saying, that is not the place, and then, in some of the charts there is a bar, in the place which was not the place, needs no comment. The evidence of Captain Broughton, who had sounded there, should have been fatal to the chart of Mr. Stokes, who had not, by his own admission, taken soundings. The fact was that this bar, made for the occasion, formed one of the main points in the Commander-in-Chief's defence, and Mr. Stokes' chart was retained in spite of the testimony of those who, from having sounded, could alone know anything of the matter. But Mr. Stokes shall first prove and then disprove his imaginary bar or shoal. Notwithstanding that Mr. Stokes admitted that his knowledge of the supposed shoal between the Pals and the Boyart was only founded on an anonymous French manuscript, he subsequently forgot the admission and swore to his own personal knowledge of the minutest particulars connected with the imaginary shoal. Lord Gambier. Is there not a bank between the Boyart and the Pallas shoal? Mr. Stokes. Yes. Lord Gambier. What water is there generally upon the bank at low water? Mr. Stokes. From 12 to 16 feet in the deepest part, but that part is very narrow. Lord Gambier. If there are only 16 feet, line of battleships could not pass over it at all times. Mr. Stokes. No, not until very nearly 2/3 flood. You must reckon on going over that part at 12 feet. Footnote. It is marked on Mr. Stokes's chart that the rise of tide is 21 feet. Footnote ends. Lord Gambier. To get to the anchorage, it is necessary to pass over the bank just mentioned. Mr. Stokes. It is. Admiral Young. Is there a channel of 16 feet all across? Mr. Stokes. There is a channel of 16 feet all across, but that is narrow. There are about the middle of it patches of 12 feet. President. There is no going into the channel of 16 feet without, in some instances, passing over that of 12 feet? Mr. Stokes. You may go over the channel of 16 feet, but it is so narrow that I should calculate going over that part which is only 12 feet. President. It is so intricate you must count on passing over some part with only 12 feet? Mr. Stokes. I should calculate on going over part of the 12 feet because it is so narrow it is difficult to hit the passage of 16 feet. Footnote. Yet Captain Broughton had hit it, and that without finding any shoal at all. End footnote. End quote. This is pretty minute for a man who was not present in the action, who confessed that he was ignorant of the distance between the sands, and had, in fact, quote, never sounded there at all, end quote. That his survey had been made from the mizzen top of the Caledonia, 9 miles off, and that he had his information from Mr. Fairfax and an anonymous French manuscript, which was not even produced in court nor demanded by the court, so that it is not known to this day who was the author of that manuscript, or indeed whether it ever existed, a matter which, from its non-production, I do not hesitate to doubt. The President was, however, bent on confirming Mr. Stokes's shoal, but the result was most unfortunate. In order to further substantiate the alleged fact, Captain Wolfe of the Aigle, which vessel was present during the action, thus replied to an interrogation on the point, quote, I think 4 or 5 sail of the line might have lain clear of the enemy's batteries. I lay there with the Pallas and 15 or 16 brigs, gun-brigs, cutters, and schooners. President. Would the casting your eye upon this chart, Stokes's, give you a clearer comprehension? Captain Wolfe. No, I have it all in my mind. I received orders to assist Mr. Stokes on a survey. President. What was the report of the depth of water at any particular time of tide in the situation I have pointed out between the Pales and the Boyart, if you can recollect it? Captain Wolfe. Mr. Stokes said he had found deeper water and a little more room farther to the southward." Is it not wonderful that in the face of such facts the Court should have acted on Mr. Stokes's chart or his evidence? Where Mr. Stokes had found deeper water, he had marked on his chart a shoal, in which no admiral in his senses would have trusted a frigate, though the Revenge and Valiant line of battle ships, with 5 or 6 frigates, had found plenty of water there, and, whilst destroying 2 enemy's ships, remained there through a whole tide without grounding. The following are extracts from the logs of the ships present. 3 p.m. Shortened sail and anchored in 7 fathoms near the outer ship of the enemy, Valiant in company. Log of the Pallas. 3:30. Came to with the best bower in 6 fathoms. Log of the Valiant. 4 o'clock. Anchored in 5½ fathoms. Log of the Unicorn. 3:30. Anchored in 7 fathoms. Log of the Indefatigable. 2:30. Anchored in 6 fathoms. Log of l'Aigle. Ends. The subjoined evidence of Mr. Spurling, the master of the Imperieuse, will render further allusion to the subject unnecessary. "Where we anchored, which was out of reach of shot and shell, we lay in 5½ fathoms at low water, 3 or 4 cables' length nearer to the Pallas Shoal than we lay was a good berth for 3 or 4 sail of the line to anchor in 5½ or 6 fathoms dead low water. The marks for such anchorage I took myself. I know this from my own observation. It was marked on the French chart, but I did not choose to trust it, but wished to prove it. The lead was kept going the whole of the time on both sides." President. What water did you find in working out between the tail of the Pallas Shoal and the shoal towards the Boyart when working to and fro? From 6½ to 7 fathoms. Did you make any observation before you began to engage? Yes, on the morning of the 12th I was desired by Lord Cochrane to lay a buoy on the Boyart Shoal, which I did in 6½ fathoms water, a sufficient distance to allow any ship to tack round that buoy." The reader must not imagine that I am too minutely descending into particulars. I am writing history, naval history, in which Lord Gambier is nothing, myself less, except as unavoidably connected with the proceedings of the court-martial. I have no wish to speak of Lord Gambier where it can be avoided. The subject is, however, one in which a nation is collectively interested, and the national, no less the naval character, is involved. Now that the justice of the Duke of Somerset has given me the means of incontrovertible explanation, I am personally gratified in availing myself of it, but I repeat that my object is now, as it ever was, national, and having at length those means, it is my duty no less than my pleasure to use them as a warning to future generations of the noble service to which I have the honour to belong. I must reluctantly turn for a moment to the evidence founded on Mr. Fairfax's chart. First premising that when Mr. Fairfax was asked to state the situation of the enemy's ships at noon, he replied that "at 11 o'clock he went down below and did not come up again till near 2." Minutes, page 143. That is, during the whole time of the 3 hours' delay, and the consequent escape of the grounded ships, which constituted the question before the court, Mr. Fairfax had been, by his own voluntary admission, in his berth, recovering himself from the fatigues of the previous night. During these 3 hours, as has been said, the Ocean, 3-decker, and 3 other line-of-battle ships had quietly hove off, and were running into the Scheldt. This was proved by the concurrent testimony of all the witnesses, and their escape formed the neglect, if any, of the Commander-in-Chief. Yet Mr. Fairfax unblushingly testified that his chart showed their position on the morning of the 12th, and that when at 2 o'clock he returned from his 3 hours' nap, the enemy ships were nearly in the same position as when he went down below at 11 o'clock. All these other witnesses, without exception, stating the fact that they had warped off and escaped beyond reach. Yet the court made no comment on Mr. Fairfax's evidence. When pressed to describe their position more minutely, Mr. Fairfax, with real or assumed indignation, replied, "I have described them in the chart produced by me." The court complacently declined further question, and Mr. Fairfax thus escaped the struggle between his chart and the truth, which had so much embarrassed Stokes, who had not the sagacity to perceive that his silence would have been more acceptable than his volubility. Mr. Fairfax's minute description of the nearly same position of the ships which had escaped while he was below, is yet more extraordinary. "Were any of the enemy's ships aground lying so close together as to have the yards of two of them locked together?" Mr. Fairfax. "By perspective, those near the Tonnerre seem to be very close. If you draw a line, they appear in one." President. — "The question is, whether these two ships were lying so close together that their masts and yards might be locked in, or whether they were distinct?" Mr. Fairfax. —" They were distinct at night." "Were you in any situation which enabled you to determine that they were not near each other?" Mr. Fairfax. —" No, it was prior (i.e. before daylight) that I distinguished them separate." "Can you determine how far they were asunder?" Mr. Fairfax. — "I should think a ship's length from each other, those three." Yet even the reluctant vision of Mr. Stokes, at a distance of 9 miles, could perceive at daylight 4 of the enemy's vessels lying hopelessly in a group. Mr. Fairfax, from whom a straightforward answer could not be got, said, when pressed, that amidst pitch darkness and by perspective he could plainly distinguish them as distinct from each other, and was thus with difficulty made to tell almost the truth as to how they lay when driven ashore on the preceding night. He could see in the darkness that their yards were not locked together, but they were only a ship's length from each other, a distinction almost without difference. The whole affair was made to turn on the evidence of these two masters, Stokes and Fairfax, who unhesitatingly contradicted in that evidence the testimony of the most experienced officers present in the action, though the latter, had it not been for my pertinacity, as before described, would not have been allowed to give evidence before the court. It has been shown that the charts of Messrs. Stokes and Fairfax were used to the exclusion of the actual charts of the enemy's coast supplied under sanction of the Admiralty itself, because there were none more reliable in existence. It would be easy to extract from the evidence of Fairfax much more to the same effect, but the subject is nauseating, and the naval reader may, if he choose, search the minutes of the court-martial for himself. The young officer could scarcely occupy himself more profitably if he wished to become acquainted with the practice of the service 50 years ago. A short extract from Mr. Fairfax's evidence relative to the explosion vessel and the Mediator is necessary, as Lord Gambier avowed in his defence that the explosion vessels failed in their object, and to corroborate this, Mr. Fairfax falsely placed on his chart the spot where the explosion took place in a false position, in order to confirm to the eye of the court the asseverations of the Commander-in-Chief in his defence. Like Mr. Stokes, Mr. Fairfax swore the truth in his evidence in contradiction to his chart. The assertions of the Commander-in-Chief in his defence with regard to the explosion vessels is as follows: "The explosion vessels, conducted by Lord Cochrane, failed in their object, as will be seen with reference to the small chart which I now deliver into the court." Mr. Fairfax's chart D. "This points out where 2 of them blew up. The situation in which, and the time when, those vessels blew up proved prejudicial to the enterprise in several respects. In fact, had not Captain Woolridge and some of the other officers, wholly disregarding the explosion, taken their fireships in a proper direction for the enemy, it is more than probable that none of them would have produced any effect on the enemy's fleet." Lord Gambier's Defence Minutes, page 124. Lord Gambier uttered this with the full knowledge that not a single fireship did take effect on the enemy's fleet, a fact which his lordship openly states in another part of his defence. So prematurely were the fireships kindled, and so badly were they directed. That Captain Woolridge took his fireship in a proper direction is wholly disproved by the very man upon whose chart his lordship relies, viz. Fairfax, who states in his evidence that after the explosion had taken place he hailed the Mediator to alter her course, or she would miss the French fleet. I am sorry to bring such evidence as the subjoined to confute the unfounded assertions of a British admiral, but justice to myself leaves me no alternative. Question. — "Do you recall when and where the explosion vessel blew up on the night of the 11th of April?" Mr. Fairfax. — "She was about 2 cables' length from the Lyra. The Lyra is marked in the chart produced by me, as well as the explosion vessel. When she blew up, the 5 vessels all seemed to steer for that point. I hailed 4 of them and the Mediator, and desired the Mediator to steer south east, or she would miss the French fleet." End quote. Here, Mr. Fairfax proved first that the explosion vessel took effect before a single fire ship was kindled; secondly, that the Mediator was steering in a wrong direction, not a proper direction, as alleged by Lord Gambier; thirdly, and that therefore the boom was destroyed before the Mediator could have got near it. The Mediator's log is, however, luckily amongst the Admiralty records, and is carried up to the time the ship was set on fire, viz. 9:30 p.m, but not a word is said of breaking any boom, or even coming in contact with one, though had she done so, the shock must have shook her from stem to stern. The subjoined are the Mediator's last log entries previous to her being set on fire. 8:30 p.m, cut the cable and made sail for the French squadron. 9:30, set the ship on fire. The preceding extract from Mr. Fairfax is taken from the revised minutes. He says, quote, "When the explosion vessel blew up, all the fire vessels seemed to steer from that point." End quote. What he really said was, quote, "I was below at the time of the first explosion, which I supposed was some shells bursting in the top, but I got on deck time enough to see her blow up." End quote. This was expunged and the above version substituted. The fact was, as every seaman will comprehend in a moment, that there was not a grain of powder or a single shell anywhere but in a mass in the hold, and this, as a matter of course, exploded in an instant. I do not say that Mr. Fairfax can be accused of this perversion of his evidence, as it was evidently the work of the person who revised the minutes for publication by a Portsmouth bookseller. The Mediator's log was taken out of her previously to being set on fire, and is subsequently continued up to midnight, 2 hours and a half afterwards, but still not a word is mentioned of coming in contact with a boom. This should be conclusive on the subject, and it is not my fault that a fact beyond dispute must necessarily disprove the asseverations of the Commander-in-Chief in his defence before the court-martial. These, however, are both facts. Let the reader make the most of them. Yet in his letter to the Admiralty of April 14th, Lord Gambier stated that, quote, "the weight of the Mediator broke the boom," end quote, in that letter also ignoring the effect of the explosion vessels altogether. His Lordship says in his defence that they were signals for the fire ships. The subjoined are his Lordship's words, quote, "Their explosion was to point out the proper time for the officers commanding the fire ships to set fire to their respective vessels, and to intimidate and prevent the enemy from towing off the fire ships." End quote. 3 explosion vessels, fitted at an enormous cost for ammunition, etc., to do that which a signal rocket could have done as well. If the explosion vessels did not strike terror into the enemy, assuredly nothing did, for at page 125 of his defence he admits that, quote, "not one of the enemy's ships was actually destroyed by means of fire ships." End quote. This perseverance on the part of the Commander-in-Chief in persisting that the explosion vessels failed in their object, though according to his own admission that the fire ships failed also, was attempted to be corroborated by the evidence of Mr. Fairfax, but in a different way, viz. By swearing that she blew up at too great a distance from the enemy to produce any effect at all. Quote, "President, to the best of your judgment, what was the distance of the explosion vessel from the enemy when she blew up?" Mr. Fairfax, "About a mile." Admiral Young, "What sort of night was it?" Mr. Fairfax, "Very dirty and blowing strong. The Lyra was pitching bows under." Was the night light or dark? Mr. Fairfax, "Very dark at intervals." How then did you, in a very dark night, ascertain that the explosion vessel blew up within a mile of the enemy? Mr. Fairfax, "By her computed distance from us in the Lyra, judging the distance she was from the enemy." End of quote. Minutes, page 177. At first sight, these questions on the part of the court seem impartial, but their object was to make Mr. Fairfax say that she might have been more than a mile from the enemy, as appears from the subsequent evidence. Mr. Fairfax would not say this. He, however, placed her on his chart on this very dark night near the Boyart Shoal, and not close to the Isle of Aix, and the boom, where Captain Protean was lying under the lee of the boom, says she blew up. Unfortunately for the veracity of Mr. Fairfax on this point, he had previous to the trial unwittingly written a letter to the editor of the Naval Chronicle, evidently not for publication, but in explanation of a chart. The editor of the Naval Chronicle, however, published the explanatory remarks, which are in complete contradiction to Mr. Fairfax's evidence on the court-martial. In fact, this portion of the letter tells the truth in the following language: "I have it from good authority that the fuses on board one of the explosion vessels only burned for 6 minutes and a half instead of 20. Footnote: this is incorrect. They were calculated to burn 12 minutes and exploded in about half that time. Footnote ends. Had they burned 12 minutes longer, nothing could have been better placed. I saw the French ships with lights up immediately after the explosion, before any of the fireships got near." Edward Fairfax, Naval Chronicle for 1809, volume 22, page 49. Quote ends. With this glaring contradiction between his evidence and his previous honest assertion to the editor of the Naval Chronicle, I take my leave of Mr. Fairfax and the subject, being quite content to rest my character on the contradictory evidence of those suborned to serve the cause of an administration in want of the prestige of a victory, at the expense of truth and even common sense, had such been relied on in the investigation. I will conclude with the remark that had I been permitted access to the charts before the lapse of 51 years from the date of the action, or could I, after the court-martial, have prevailed on Parliament to investigate the matter, by demanding the production of the minutes of the court-martial before voting thanks to the Commander-in-Chief, the administration of that corrupt day would never have dared to treat me as an officer maligning my Commander-in-Chief unjustly, nor to have followed up their malignity to its final consummation of driving me from the British Navy on the imputation of an offence of which I had not the smallest cognizance, as will by and by appear as plainly, and I trust as satisfactorily, as do these extraordinary revelations concerning a court-martial which will stand a beacon and a warning to the naval service as long as that service may exist. God grant that the records of that noble service to the latest day of its existence may never again be sullied in like manner. End of chapter 26. Recording by Timothy Ferguson, Gold Coast, Australia. Chapter 27 of Autobiography of a Seaman, Volume 2, by Lord Thomas Cochrane. This LibriVox recording is in the public domain. The most damnatory point connected with the court-martial is, that on finding me inflexible with regard to the vote of thanks to Lord Gambier, the Board of Admiralty ordered his Lordship, after his return to England, to write a second dispatch containing fresh details of the action, thus superseding the first dispatch written by himself as Commander-in-Chief at the time of the action. With this extraordinary demand, Lord Gambier appears to have gladly complied on the 10th of May, 1809, so that there are two dispatches, Appendix A written on the spot and Appendix B written in England, the first highly praising me for what I neither did nor intended to do, the second ignoring my services altogether. In fact, only mentioning me by name as lying about 3 miles from the enemy. One step more in the second dispatch, viz. that I was not in Aix Roads at all, would only have been in keeping with the assertion just quoted. Were not these contradictory documents now adduced, the denial of such an act, by suppressing all mention of it in the dispatches, would be incredible. Nevertheless, I fearlessly assert that to my personal conduct of the explosion vessel was solely attributable the panic produced in the enemy's fleet, and that such conduct was one of the most desperate acts on record. There, however, they are, printed in the appendix at the end of this volume. The naval reader may regret their reproduction, as I do, for the sake of the service, but he can no more ignore them than I can just pass them over. There is nothing like this in the records of the British or any other naval service, and the reasons for a precedent so unusual must themselves have been extraordinary. It is clear to me, from the order of the Board of Admiralty to the Commander-in-Chief to make a second report of the action in Aix Roads, the court-martial took its cue. This may be a harsh conclusion, and perhaps would be so were it not corroborated by circumstances, not the least significant of which was that the Commander-in-Chief's official report had been long before published in the Gazette. No naval reason to invalidate this official report was alleged, or could have existed. During my examination before the court, I alluded to the fact of having reported to the Commander-in-Chief the ruinous state of the Isle d'Aix, it having the inner fortifications completely blown up and destroyed. This I not only ascertained from the deck of the Imperieuse with perfect precision as to the side towards us, but also as to the opposite side from personal observations made from the main topgallant masthead. There were 13 guns mounted." This evidence, if admitted, and its truth, was fully proved by the testimony of other officers, completely confirmed Lord Gambier's previous statement to the Admiralty that "the fortifications were no obstacle," but now it was expedient that these fortifications should constitute the bugbear which, as was asserted, would have destroyed any British ships sent to attack the enemy's ships aground, and that the issue of the court-martial mainly rested on establishing the formidable character of the fortifications. A second despatch was called for. When, in my evidence, I was explaining to the court the little danger to be apprehended from these fortifications, one of the principal points before the court, Admiral Young stopped me with the query, "Will you consider, my Lord Cochrane, before you go on, how far this is relevant?" On my insisting upon further explanation, the Judge Advocate attempted to stop me by demanding, "Can this relate to the question asked?" The President, seeing that I would not be stopped, remarked, "Lord Cochrane states this as his reason for not taking a particular line of conduct." I stated it for no purpose of the kind, but to show that opposition from such fortifications was hardly worth taking into consideration, and thus continued, "I have felt that if I had answered yes or no to all the questions which have been put to me, I ought to be hung, and that if a court-martial were held upon me, and only the answers yes or no appeared to those questions, I should be hung for them. Judge Advocate, I believe nobody has desired your Lordship answer merely yes or no." A still more striking instance of the animus of the court was the following attempted stoppage of Captain Beresford's evidence. Captain Beresford, "The only thing I know with respect to the Caledonia being fired was by a conversation between Lord Cochrane and myself in the presence of Captain Bligh, Captain Maitland, and others." President, "Is this strictly evidence, Mr. Judge Advocate?" Judge Advocate, "Yes, I should think it is, because I conceive it is to affect the evidence of Lord Cochrane." At the present day, any such proceedings in any tribunal would be thought impossible. There, however, they are on record, showing that the openly avowed object of the court-martial was the suppression and invalidation of my evidence by any means that could be brought to bear, rather than an inquiry into the conduct of the Commander-in-Chief on the merits of the case. One point more must be noticed, relative to the manner in which the court was conducted. Having reason to believe, as has been shown, that the inquiry was being directed against myself, I was naturally anxious to be present at the reading of the Commander-in-Chief's defence, in order to judge how far I might thereby stand affected. With this view, I presented myself to the court on the 5th day of the inquiry, when it was known that the defence would be made. To my surprise, the court saw fit to refuse the privilege. President, "All the witnesses must withdraw. Lord Cochrane, with all due respect to the court, in some former court-martial, the witnesses have been permitted to hear the defence." President, "I never heard such a thing in my life. The court have ruled the point." Lord Cochrane, "The case of Admiral Harvey is a case in point." President, "Lord Cochrane, the court have determined the contrary." Lord Cochrane withdrew. One of my reasons for wishing to be present was to ascertain what use would be made of the logs of the small vessels present in the action, it being quite clear from circumstances which had come to my knowledge that some of these had been tampered with. As such an assertion may readily be doubted, it must be confirmed. When Mr. Earp inspected the logs at the Record Office, several, for the date of the action, were found missing from the log books. One, the log of a line of battle ship, had been torn out and was put back loose. This, however, is after knowledge. I will rather rest the matter on circumstances at the time. When the master of the Beagle was under examination, the subjoined conversation took place. President to the master, "Were these things written (in the log) day to day as they occurred?" Master, "Yes, everything was written day to day at 12 o'clock. Then what is called the log of the 6th of April was written on the 6th of April? Master, "Yes." And what is inserted here as of the 7th was written on the 7th in this book? Master, "Yes." Is this the identical book into which it was copied from the board? Master: Yes. And there never was any other logbook kept? Master: No. Who kept this? Master: I kept it myself. President: It is written so fair and so neat that it bears every mark of being a fair copy. Judge Advocate: I tell the gentleman I am sure no imputation rests upon him. President: No, not the least. Footnote: Inspection of more than one of the logs can leave no doubt, from the neatness of the handwriting, that those relating to the date of the action had been recopied, and could not have been written from day to day, which, from the difference in the pen and other little circumstances, must have shown itself as in other logs. In one instance, portions of the signal book have been transcribed into the ship's log. G.B. Earp. Footnote ends. It was nevertheless a fact that it had been tampered with, as was unwittingly elicited by Mr. Bicknell from the same witness. Question: You say on your oath that you believe everything in this log to be correct? Master: Yes. Question: How does it happen that the signals of the Imperieuse are inserted in the margin of the log amongst the columns, and not in the body of the log? Master: I wrote that at the same time the log was written. Why did you not put it in the body of the log in the narrative? Master: I made a mistake in copying it from the logboard. It will thus be seen that my most material testimony was attempted to be stopped by the court as irrelevant, that the Judge Advocate gave as a reason for receiving testimony really irrelevant, that it ought to be received because it would affect the evidence of Lord Cochrane, that garbled logs were resorted to, that the whole proceedings were directed against me and carefully in favour of Lord Gambier by leading questions, which abound in almost every page, that I was not allowed to be present whilst the witnesses were under examination, so that I had no opportunity of cross-examining them in my own vindication, a right granted to every man by the constitution of his country, and that I was refused admission to the court during the delivery of Lord Gambier's defence by the Judge Advocate himself, a most unusual course, that defence being full of the most injurious insinuations against my honour, though these were not borne out by evidence. In short, I was refused admission to the court, though I quoted a precedent not 2 months old in support of my right to be present, a right the more important to me, if only from the fact of Lord Gambier having written a second despatch relative to the action in A. Roads, in which despatch my services were altogether omitted, notwithstanding his lordship's praises of my conduct in his first despatch written on the spot, where everything had transpired under his own observation. I must now briefly advert to his lordship's defence, but only so far as personally concerns myself. Lord Gambier stated at the outset of his defence that he had been compelled to demand a court-martial in consequence of the insinuations thrown out against him by Lord Cochrane, which not only compromised his own honour, but that of brave officers and men serving under his command. I never threw out against his lordship a single insinuation, nor does one exist, either on the records of the court or elsewhere. I merely told Lord Mulgrave, as narrated in the first volume, that I did not consider Lord Gambier's services worthy of a vote of thanks from Parliament, and that on this ground, as bound by public duty to my constituents, I should resist it. As will presently be seen, this was also the opinion of many eminent men in Parliament, and on the same ground too, that of public duty. If I committed any offence in this, it was that of refusing to have my name coupled with that of Lord Gambier in the vote of thanks, and resisting an offer of an independent squadron and regiment, not to persist in my determination of opposing it. That my objection to the vote of thanks to Lord Gambier included any of the officers serving under him was a gratuitous assumption to secure sympathy for himself. As I have shown, the opinions of those officers present in the action, whose opinions were to be relied on, were anything but in Lord Gambier's favour. Not a single word did I utter against any officer, although on the 9th and last day of the court-martial it was with the greatest difficulty, and after a positive refusal, that I succeeded in getting a denial of Lord Gambier's unfounded assertion attached to the minutes. It will be better to give the whole transaction. The Right Honourable Lord Cochrane called in. President: Lord Cochrane, I have received the note which you addressed to me, and have taken the sense of the court upon it. The decision of the court is that, as the matter to which your lordship refers does not at all bear upon the trial of Lord Gambier, they cannot enter into it. Lord Cochrane: I would request, sir, that the letter may appear as an official letter to you, and that it may be entered upon the minutes. President: The court will take that into their consideration. The court was cleared. The court was reopened at 1 o'clock. President: Lord Cochrane, the court has taken into their consideration the note you addressed to them, and have agreed that it shall be attached to the minutes. The letter was read, and is as follows. August 1, 1809. Sir, having learnt from my brother officers that a report has gone abroad that I censured in general terms the conduct of the officers employed in the road of A on the 12th of April, I wish to have an opportunity to declare the truth on oath, considering reports of that nature highly injurious to the service of our country. I am also desirous to lay before the court the orders given to the fireships for their guidance, as these will tend to elucidate and clear some of those who consider the blame has been imputed to them. I have the honour to be, Sir, your most obedient humble servant, Cochrane. Admiral Sir Roger Curtis, President." Let the reader mark that expression of the President. It does not at all bear upon the trial of Lord Gambier, though the very first sentence of Lord Gambier's defence was an accusation of myself upon an assumption for which there was no foundation whatever. Nothing but fear of a parliamentary debate caused the letter to be attached to the minutes. So clumsily was this accusation made against me that Lord Gambier, despite the unwarrantable assumption just quoted, subsequently admitted my objection to the vote of thanks to have been solely aimed at himself, and not, as he had just said, at the officers and men of the fleet. Here are his lordship's words. "Lord Cochrane warned the noble lord at the head of the Admiralty that if this measure (open bracket, the vote of thanks) close bracket, were attempted, he should, if standing alone, oppose it, thus, without specifically objecting to thanks being given for the service performed, directing his hostility personally at me." That is, I should not have objected to a vote of thanks to the officers and men of the fleet, but only to himself personally. Yet in the same breath he accused me of traducing the officers and men of the fleet, with the intention, no doubt, of sheltering himself under the pretence of my having traduced them also. Could anything be more puerile? I gave no other warning to Lord Mulgrave than that which Lord Gambier correctly stated, and that I certainly did give, but without a word which could give rise to the slightest imputation on the officers and men of the fleet. The fact is, that I never accused Lord Gambier at all, not even to Lord Mulgrave, to whom I only expressed an intention of opposing a parliamentary vote of thanks. It was the Board of Admiralty who accused him. Here are their accusations in full. "By the Commissioners for executing the office of Lord High Admiral of the United Kingdom of Great Britain and Ireland, etc., whereas Admiral the Right Honourable Lord Gambier has, by his letter to our Secretary of the 30th of May, 1809, requested that his conduct as Commander-in-Chief of the Channel Fleet, employed in Basque Roads between the 17th day of March and the 29th day of April, 1809, may be inquired into by a court-martial, and whereas, by the logbooks and minutes of signals of the Caledonia, Imperius, and other ships employed on that service, it appears to us that said Admiral Lord Gambier, on the 12th day of the said month of April, the enemy's ships being then on shore, and the signal having been made that they could be destroyed, did, for a considerable time, neglect or delay taking effectual measures for destroying them. We, therefore, in compliance with his lordship's request, and in consequence of what appears in the said logbooks and minutes of signals, think fit that a court-martial shall be assembled for the purpose of examining into his lordship's conduct, and trying him for the same. We send you herewith his lordship's said letter, and also his letter of the 10th of the said month therein referred to, together with an attested copy of a letter of our Secretary, dated the 29th of last month, and addressed to Lord Cochrane, and his lordship's reply thereto, with the logbooks and minutes of signals above mentioned, and we do hereby require and direct you to assemble a court-martial on Monday, the 19th day of this month, open bracket, if the witnesses shall be then ready, and if not then ready, as soon after as they shall be so, close bracket, to try the said Admiral, the Right Honourable Lord Gambier, for his conduct in the instance hereinbefore mentioned, and also to inquire into his whole conduct as Commander-in-Chief of the Channel Fleet employed in the Basque Roads between the 17th day of March and the 29th day of April, 1809, and to try him for the same accordingly. Given under our hands the 5th day of June, 1809, signed Mulgrave R. Bickerton, W.M. Domett, R. Morsum. To Sir Roger Curtis, Baronet, Admiral of the White, and Commander-in-Chief of His Majesty's ships and vessels at Spithead and in Portsmouth Harbour, by command of their Lordships, W. W. Pole." There is nothing here from which it can be inferred that, to use Lord Gambier's own words in his defence, I had driven him "to defend himself against the loose and indirect accusations of an officer so much his inferior in rank." I had made no accusation whatever against him, having merely and only declared that the service rendered was not worth the thanks of Parliament, the frequency of such thanks for trifling service being at that period so notorious as to become subject for sarcasm, as will appear in the next chapter. Had Lord Gambier constructed my parliamentary opposition rightly, he might have thanked me for saving him from himself, and would have done so, had not his peculiar failing vanity demanded an ovation for services which, under evil advice, he had prevented from being fully consummated. So far from accusing Lord Gambier, I was ordered by the Admiralty to do so, and refused to my own detriment, telling the Board to go to the logs of the fleet and frame their own accusations if they had any. Yet even this consideration did not prevent Lord Gambier from giving utterance to the following bombast: "Whether Lord Cochrane supposed that he might with impunity endeavour to lower me in the opinion of my country and of my sovereign, signal marks of whose favour had at that instant been exclusively conferred upon himself, whether his lordship thought to raise his own reputation at the expense of mine, and whether he expected that his threat would intimidate me to silence, I know not." How could I raise my own reputation at the expense of Lord Gambier, who had, in the first despatch, said that my conduct in the action of Aix Roads "could not be exceeded by any feat of valour hitherto achieved by the British Navy," though in his second despatch, substituted for the first after his return to England, and that too by order of the Board of Admiralty, he only remembered that I "lay with my ship about 3 miles from the enemy." His lordship was not once within gunshot of the enemy, whilst my frigate was throughout engaged, and for some time single-handed, against 2 line-of-battle ships and a 50-gun ship, the Calcutta, which I captured. So far from raising my reputation at the expense of Lord Gambier's, I voluntarily stated on the court-martial that "the feelings of Lord Gambier for the honour and interest of his country were as strong as my own," for which mark of good nature his lordship said in his defence that even "in the present proceedings Lord Cochrane stands in a situation only as an officer under my command," the meaning of which evidently was that I ought not to say anything but by order. The expression could not have had any other meaning. I will not enter further into Lord Gambier's unfounded recriminations upon myself, further than to remark that even had they any foundation, in no way did they bear upon the subject of the trial, much less were they in any way connected with his defence to the inquiry as to why it was that with a favourable wind, a rising tide, and plenty of water, he had refrained from attacking 11 ships helplessly ashore, allowing all but 3 to escape. This was the inquiry before the court, which, departing from the subject of inquiry, connived at its being substituted for recriminations on me for accusing Lord Gambier, though I had never done so. Upon the real point, Lord Gambier in his defence wisely abstained from trusting himself, except in such terms as the following: "If he had sent in any ships, and they should have been necessitated to remain a whole tide in the roads of A, if they had been crippled in going in, if the wind, which was favourable for carrying them in, should not have shifted so long as to bring them out again, and that even if the wind were fair, and they should lose their foretopmasts, the crews would not have been able to get the ships before the wind." To this I will add, that if, instead of conjuring up these absurd dangers to be apprehended from an enemy of whom Lord Gambier had said to Captain Broughton that they were already destroyed, his lordship had sent in his ships to finish the work, the court-martial would never have been heard of, and he would have enjoyed a legitimate triumph. I was not his enemy. Those who persuaded him not to second my efforts were so, unquestionably. Quitting these ifs, and calculations of possible risk and conjectural disasters, 1 or 2 points professionally connected with the defence remained to be noticed. Lord Gambier knew that during the ebb and rising tide the enemy's ships ashore were preparing to warp off with the flood, and he also knew that the only 2 enemy ships at anchor, the Foudroyant and Cassard, which at the court-martial were converted into bugbears of the whole British fleet, would be prepared in case of attack, which they naturally expected, to cut or slip, and so run for the mouth of the Charente, as they did the moment the ships aground had warped off and escaped. When the British fleet weighed from Basque Roads, the enemy was, as Captain Broughton testified, panic-struck. When, in place of proceeding straight on to the attack, the British ships came to an anchor in Little Basque Roads, the enemy, as their own writers declare, considered la mollesse de Lord Gambier an unexpected stroke of good luck, and set energetically to work to warp off their ships from the bank on which they were stranded. As Captain Broughton rightly says, had the frigates and smaller vessels been then sent in, and a demonstration only made of others ready to follow, the destruction of the whole must have been complete. This is neither a matter of naval tactics nor science, but a commonplace consequence. It was this which caused Captain Malcolm to say, quote, "Had it appeared to me that there was no other chance of destroying them but by such an attack, I certainly think it ought to have been made." End quote. And again, quote, "Had they been attacked by the British ships, they could not, in my opinion, have been warped off from the shore, as to do so it was necessary to lay out anchors and heave them off." End quote. There are no ifs or contingent disasters in Captain Malcolm's opinion, which, as Captain Hutchinson pertinently remarks, was that of every officer in the fleet. But even after the enemy's ships had escaped, and the two at anchor, the Foudroyant and Cassard, had run for the Charente, the Commander-in-Chief allowed an hour and a half to escape before a single ship was sent into the inner roads. Nor would any have been sent at all, had I not taken the Imperieuse in alone, and then hoisted the signal in want of assistance. Had not this been done, not a single ship of the enemy's fleet would have been destroyed, unless from the impossibility of getting her again afloat, and I am not aware that any such instance occurred. To excuse this neglect, the hypothesis of banks and shoals in the charts of Messrs. Stokes and Fairfax was resorted to, for they neither existed in the French charts nor in reality. Coupled with this was the alleged danger of point-blank shot from the dilapidated batteries. Quote, "Scarcely," end quote, says Lord Gambier, quote, "had the Caesar reached the A roads before she grounded, and lay in a perilous situation exposed to the point-blank shot of the batteries." End quote. Unfortunately for this hypothesis, a careful search in the Caesar's log shows that she was never once touched by shot or shell, and that in place of grounding in A roads, she grounded on the Boyard Shoal, on her way to the A roads, and that she lay there beyond the reach of shot, thus proving what other officers testified, viz., that there was plenty of room in the channel to avoid shot. The Caesar only went a few feet too far, and came off next morning without damage of any kind. A still less worthy part of the defence was in laying the fault on myself and Captain, now Admiral Seymour of the Pallas, that nothing more was done. Lord Cochrane, says the Commander-in-Chief, remained in the road of A during the 13th and 14th, accompanied by the Pallas, sloops and gun-brigs, but nothing was attempted by those two frigates. The fact was, that in the light of the line of battleships destroyed on the evening of the 12th, before any assistance came, the Imperieuse was severely damaged, so much so as to occupy the whole of the 13th in repairs. This is why Admiral Seymour so gallantly stood by us, and the 14th was occupied in vain attempts, even then, to get a force sent in. Had Admiral Seymour run the Pallas alone against the line of battleships which remained at the mouth of the Charente, he would not have earned the high reputation he now enjoys. But when Lord Gambier threw out his questionable insinuation, he forgot to mention that Admiral Stopford lay at a short distance with 2 line of battleships and half a dozen frigates, beside having our 2 frigates and all the smaller vessels under his command. Had Admiral Stopford been asked why, with such a force under his orders, he remained inactive, the reply would not have been to the Commander-in-Chief's credit. Admiral Stopford would not have been a spectator only, could he have helped himself. I now quit this miserable subject for ever. The real fact is that from the over-persuasion of those who were jealous of a junior officer originating and being appointed to carry out plans deemed impossible by others, Lord Gambier declined to second my efforts, as Admiral Austen has plainly said in his letter previously quoted, the fact being as completely confirmed by Captain Hutchinson. The decision of his lordship was no doubt arrived at when a council of officers was summoned on board the flagship on the morning of the 12th, at which time the enemy's fleet was lying helplessly ashore. That after such council his lordship never intended to make any attack at all on the French ships is proved beyond question by the subjoined testimony of Captain Broughton. Quote, "A ship or two might have been placed, in my opinion, against the batteries on the southern part of Isle d'Aix, so as to take off their fire and silence them. I mentioned to Sir H. Neale, when the signal was made for all captains in the morning, that I thought they were attackable, speaking of the confused state in which the French ships appeared to be at the time. I heard my Lord Gambier the same morning say open bracket, at this council, close bracket, it had been his intention to have gone against the batteries I now speak of, but as the enemy were on shore, he did not think it necessary to run any unnecessary risk of the fleet when the object of their destruction seemed to be already obtained." That is, he admits my exertions to have destroyed the French fleet, which was not destroyed, all except 3 ships having escaped, and plainly tells Captain Broughton that he will do nothing more. This should forever decide the point. If, however, proof be still wanted of the utter worthlessness of any opposition in the power of the enemy to offer, whether by fortifications or ships, it is to be found in the following statement at the close of Lord Gambier's defence. "I conclude by observing that the service actually performed has been of great importance, as well in its immediate effects as in its ultimate consequences, for the Brest fleet is so reduced as to be no longer effective. It was upon this fleet the enemy relied for the succour and protection of their West India colonies, and the destruction of their ships was effected in their own harbour in sight of thousands of the French. I congratulate myself and my country that this important service has been effected, under Providence, with the loss only of 10 men killed, 35 wounded, and 1 missing. Not even one of the smallest of our vessels employed has been disabled from proceeding on any service that might have become necessary." Reader's note: the next page is a chart marked Chart B, Isle d'Aix and Les Palles. It has a caption which reads, "Being a tracing of the official French chart and showing the positions of the enemy's ships as they lay ashore on the morning of the 12th of April 1809, previous to their escape." By this voluntary admission of Lord Gambier I am willing to be judged, feeling certain that posterity will be as fully convinced of the inability of the enemy to inflict material damage on our ships as was Lord Gambier himself, according to his own testimony, as quoted in the above passage. As Lord Gambier truly says, no damage worth mentioning was done to any of our ships, to which I shall add that at no period after the enemy's ships were driven ashore were they in a condition to inflict damage. This his lordship not only admits, but proves in the concluding paragraph of his defence, and yet the whole point of the trial is made to rest on the surmise that had Lord Gambier done anything against the enemy's ships aground, the destruction of the British force must have been the consequence. That is, by doing nothing, the enemy's ships were destroyed, though by doing anything, our own would have been in danger. The subjoined chart, B, will show at a glance the whole affair. A. Ocean, 3-decker, and group on the north-west edge of the Palles Shoal. These were permitted to escape. B. Calcutta, captured by the Imperieuse and set on fire. C. Ville de Varsovie, hauled down her colours to the assisting ships, afterwards burned. D. Tonnerre, ditto ditto. The last 3 were destroyed on the falling tide, but no others, these being the only enemy's ships which, after the escape of the other 4, remained assailable. E. The position taken up by the Imperieuse, she being at the time of the arrival of the assisting force engaged with the Calcutta, and with the other 2 ships. F. Position of the British ships sent in after the Ocean and group had warped off, viz. within pistol shot of the sand on which the escaped ships lay till 1 p.m. aground. The best comment, perhaps, on the whole affair of Aix Roads is what had previously been effected with a less force than under Lord Gambier, and when the fortifications were perfect. The subjoined historical facts should for ever put an end to all controversy on the subject, and at the same time to the untenable defence set up at this memorable court-martial. "A well-planned and vigorous attack on the coast of France being in 1757 much desired, with a view to give a decisive blow to the marine of that kingdom," open bracket, the very purpose for which Lord Gambier was sent, and which Lord Mulgrave especially impressed on me, close bracket, a fleet was ordered to be got in readiness under the command of Sir E. Hawke, Rear Admiral Knowles being appointed second in command. On the 20th of September, the fleet made the island of Oleron, and Sir E. Hawke ordered the Vice Admiral to proceed to Basque Road, to stand in as near to Isle d'Aix as the pilot would carry him with such ships of his division as he thought necessary, and to batter the fort until the garrison should either abandon it or surrender. On the 22nd of September, the fleet entered the bay called the Road of Basque, between the islands of Ray and Oleron. About 8 the next morning, Admiral Knowles in the Neptune, with the Magnanime, Barfleur, America, Alcide, Burford, and Royal William, made sail towards Aix. Captain Howe, afterwards Earl Howe, in the Magnanime led the van. At 12:30, the fort upon the island began to fire, but he continued to advance without exchanging a single shot, continually urging his pilot to lay his ship as close to the fort as possible. He dropped his anchor under the very walls. It was, however, near an hour before the fort struck its colours." Biographical Memoir of Earl Howe in the Naval Chronicle, Vol. 1, 1799. See also Campbell's Lives of the Admirals. This was the very fort, only now in ruins, or to use Lord Gambier's words, no obstacle from the dilapidated condition of the fortifications, that his lordship adduced as a reason for not endangering the British fleet by exposing the ships to its fire. Admiral Harvey had perhaps Lord Howe's exploit in his mind's eye when he told Lord Gambier to his face that, "had Nelson been there, he would not have waited for fire-ships, but would have dashed at once at the enemy," an assertion of which there can be no doubt, though poor Harvey was dismissed the service for this and similar opinions. Another extract from Lord Clarendon's remarks on Admiral Blake shall close the subject. "He despised those rules which had been long in practice to keep his ship and men out of danger, which had been held in former times a point of great ability and circumspection, as if the principal art requisite in the captain of a ship had been to be sure to come home safe again. He was the first man who brought ships to contemn castles on shore, which had been thought ever very formidable, and were discovered by him to make a noise only, and to fright those who could be rarely hurt by them." Clarendon's History of the Rebellion. End of chapter 12. Recording by Timothy Ferguson, Gold Coast, Australia. Chapter 28 of Autobiography of a Seaman, Volume 2, by Lord Thomas Cochrane. This LibriVox recording is in the public domain. Recording by Timothy Ferguson. The Vote of Thanks. From this time forward I never trod the deck of a British ship of war at sea as her commander, till 39 years afterwards I was appointed by her present most gracious Majesty to command the West India Squadron, the greater portion of the interval being marked by persecution, of which the court-martial on Lord Gambier was only the starting point. The commencement of the parliamentary session in 1810 was remarkable for its votes of thanks, and the refusal of all information which might justify them. This led Lord Milton to declare in the House of Commons that "votes of thanks from their frequency had lost their value, and ceased to be an honour. They had got so much into the habit of voting thanks, that it was almost an insult not to vote them." February 1st. On the 25th of January 1810, Lord Grenville adverted in the House of Lords to notice of motion for a vote of thanks to Lord Gambier for his services in destroying the enemy's ships in Basque Roads, and observed that, as the last intimation on the journals respecting Lord Gambier was his arrest, it would be necessary that the minutes of the court-martial should be laid before the House, in order to enable it to judge of the necessity for a vote of thanks. To this Lord Mulgrave strongly objected, on the ground that it "would appear as if it was wished to retry the case." Laying the sentence of acquittal only before the House, said his lordship, would be "sufficient to render their proceedings regular, and would answer all the purposes of the noble lord." With this the House was obliged to be content, though how that sentence had been obtained the reader is now made aware. On the 29th of January, in pursuance of notice previously given, I made a motion for the production of the minutes of the court-martial in the House of Commons, as being, from the extraordinary discrepancy between the nature of the evidence and the sentence, absolutely necessary, in order to enable members fairly and impartially to decide whether the thanks in contemplation of ministers were due to Lord Gambier for the part he took in what had been denominated a victory in the Basque Roads. Footnote reads, "The action took place in Aix Roads. The only victory gained by Lord Gambier in Basque Roads was that of bringing his ships to anchor there, whilst the enemy's ships were quietly heaving off from the banks on which they had been driven, 9 miles distant from the fleet. Footnote ends. In support of this production of the minutes, I adverted to a previously expressed opinion of the Chancellor of the Exchequer, Mr. Perceval, that Lord Gambier had been honourably acquitted, but that an officer's having done no wrong did not entitle him to the thanks of the House, which, if bestowed on trifling, or indeed on any but brilliant achievements, would dwindle into contempt, even with those on whom they should be conferred. Votes of thanks were already lightly esteemed in the Navy, and I pledged myself, if the House would insist on the production of the minutes, to prove that "Lord Gambier's defence was contradicted by itself, by his Lordship's official letters, and by his own witnesses, many of whom, as to essential facts, were at variance with themselves and with each other." Lastly, I undertook to prove to the House that the chart of the 12th of April was "in a most material point false, and in every respect a fabrication." I will not inflict on the reader a recapitulation of the long discussion which followed, but the opinions of some whose names are to this day held in respect are too much to the point to be passed over. The opinion expressed by Mr. Tierney is so remarkable that I shall give it entire as reported. "The question was not as to the noble Lord's (Gambier's) innocence, but as to his claim to a most distinguishing reward. The honours of the House were high things, dear and valuable, but dear only because they implied merit, valuable only because that merit must be rare. Honours too frequently bestowed lost their value, and became signs of nothing but the weakness which lavished them, or the worthlessness on which they were to be thrown away. He would vote for the minutes, but in his vote he begged to be understood as merely calling for the matter to enable him to shape his opinion. He could mean no slight to Lord Gambier. He respected his Lordship's character, he had some opportunities of hearing him spoken of, and it was always in a high strain of praise and estimation. But he had never understood that Lord Gambier took any share of the merit of the achievement to himself. He had not approached the French fleet nearer than 7 miles. Ministers had praised Lord Gambier for discretion. He hoped they had not intended this as an instance in the enumeration of its proofs. It became the House to be cautious of being prodigal of honours entrusted to their distribution. Lord Cochrane ought to be heard. His judgment and character, his signal gallantry and signal honours the red ribbon, deserved the serious attention of the House. Even his feelings, led as they were perhaps astray by an excessive strength and sensibility, deserved all the attention which could be paid to them." The opinions of Mr. Whitbread are no less remarkable. Sir C. Hamilton had said that the reason why no more ships were destroyed was solely attributable to me, and that he would engage to prove it to the House. He, however, omitted to do so. Mr. Wynne also declared on behalf of the Ministry that the evidence was all on Lord Gambier's side, and opposed to it only my solitary evidence. This called up Mr. Whitbread, whose remarks are reported as follows: "The noble Lord (Cochrane) had done wrong in returning any answer to the application of the Admiralty," demanding the reasons for my opposition to the vote of thanks. See Vol. 1, page 404. "He ought to have told them, as a member of the House of Commons, he had no answer whatever to make, and if they thought the logs inconclusive, why did they not manfully come down and try the question in that House? The honourable gentleman (Mr. Wynne) talked of the injustice of trying an officer in that House. Must not the merits of every officer be inquired into when it is proposed to confer on him a vote of thanks? Was he not then on his trial? Was not that a species of trial to which any officer must necessarily be exposed before he could receive the high honour of the thanks of Parliament? After a court-martial, by which Lord Gambier had been acquitted, did it follow as a matter of necessity that they must grant him the thanks of that House? He presumed that this by no means followed. What then was the situation to which the House was reduced? The noble Lord (Cochrane) had committed himself more than he had ever heard man do in that House, to prove his statements respecting the conduct of Lord Gambier, and now a member, Sir C. Hamilton, came forward and said that the duty entrusted to Lord Cochrane had not been properly executed, and if it had been, he might have done far more injury to the enemy's ships. The honourable Baronet (Hamilton) said that at the time Lord Cochrane was in command, and made signals to the vessels employed under him, some of them obeyed and others disobeyed the instructions they received, and that those who disobeyed were ultimately successful, while those who obeyed at the moment failed. The worthy baronet also added that those who disobeyed the signals were promoted, whilst those who obeyed were not. What would become of the subordination of our navy if our officers were to be informed in any one instance that those who obeyed the instructions of their superior officer were to be passed by, while those who disobeyed his signals might expect to be promoted? This submission by a ministerial partisan was true. It was chiefly owing to this that the fireships, to use Lord Gambier's words, "failed to take effect on the enemy's ships," viz. by kindling them where they drifted on the shoals or went wide of the enemy's fleet. The quotation continues. From the disagreeable situation in which the House was placed on both sides, he thought they must unavoidably have the minutes. Various other opinions were expressed. Mr. Wilberforce thought acquiescence in my motion for the production of the minutes "most important, as throwing a stigma on all the members of the court-martial," which was true enough, one of my objects being to show that the influence of a corrupt government had been used to vitiate a tribunal upon which the very safety of the navy depended. How far I may have succeeded in this may be left to the reader's judgment. See Lord Grey's expressions infra. Mr. Ponsonby could not agree to the motion because its adoption would be a violation of the fundamental principles of jurisprudence. Sir Francis Burdett said that Lord Gambier's plan seemed to be a desire to preserve his fleet, my plan to destroy the enemy's fleet. He had never heard that the Articles of War held out an instruction to preserve the fleet. What if Nelson, at the Nile or Trafalgar, had acted on this principle? He had never heard that Lord Gambier, in the affair of Basque Roads, pretended to have done any hard or even important service. His only merit seemed to consist in what he omitted to do." Thus having been put on my defence by direct accusation on the part of a ministerial supporter that I had not done my duty, I implored the House to give me an opportunity not only of defending myself, but of laying bare matters of more importance to the country than either my judgment or character. I again pledged myself to prove all that I had asserted, and to stake everything that was valuable to a man on the issue, at the same time telling the House that, if the minutes were granted, I would expose such matters as might make the country tremble for its safety, and entreating it well to consider that there was another tribunal to which it was answerable, that of posterity, which would try all our actions and judge impartially. Neither argument nor a sense of justice availed, and the word sentence was substituted for minutes in an amendment carried by a large majority of the faction, in that day dependent on and wielded by ministers, of whose general conduct Lord Grey, in the opening debate of the session, thus thought it necessary to express himself. He was glad to find from the humble and chastened tones of ministers that they appeared to feel some remorse for the numerous miseries which, by their imbecility and misconduct, they had inflicted on their country. Had it been otherwise, he should have supposed the almighty vengeance was hanging over this nation, and that therefore the hearts of its rulers had been hardened in proportion as to their understandings were darkened." This merited censure, from one of the great lights of that day and of all time, passed unheeded in the conduct of the session, which outdid its predecessors in acts of subserviency to the faction in power, by whose supremacy it was felt that the rotten borough interest could alone maintain itself against the national execration which was now beginning to make itself heard. At the conclusion of the preliminary debate, the Chancellor of the Exchequer rose to move a vote of thanks to Lord Gambier for his eminent services in destroying the French fleet in the Basque Roads. My name, as having effected anything, was purposely and very ingeniously left out, but warm thanks were accorded to those who directed the fireships, not against the enemy, but against the banks of the Boyart and Pale Shoals. The passage in the vote of thanks is curious. "For their gallant and highly meritorious conduct on this glorious occasion, particularly marked by the brilliant and unexampled success of the difficult and perilous mode of attack by fireships, conducted under the immediate direction of Captain Lord Cochrane." Yet Lord Gambier stated in his defence, "The success of the first part of the enterprise arose from the terror excited by the appearance of the fireships, as they failed in the principal effect they were intended to produce." Minutes, page 131. If the House had been in possession of the minutes of the court-martial, would they have voted thanks to officers of whom the Commander-in-Chief says that they "failed in their object"? Not a word of thanks to me for having conducted it, but to the Commander-in-Chief, then 12 miles off, his only merit consisting in coming 3 miles nearer, anchoring out of gunshot, and to men whom a ministerial supporter had praised by saying they had been promoted for "disobeying my signals," and this though the First Lord of the Admiralty had offered me his own regiment, a squadron of frigates, with carte blanche to do what I pleased with them, and a vote of thanks conjointly with Lord Gambier if I would not offer any opposition. The value of such a vote under such circumstances had been rightly estimated, even by those who acquiesced to it. The value of the service rendered was paltry in comparison with what it ought to have been, and the vote, either to myself or my superiors, would have been worthy of it. I had from the first refused to have my name coupled with such pretence as a fraud on national honours. Yet, leaving me altogether out of the vote of thanks, so long as thanks were voted, and giving them to the Commander-in-Chief and the officers under "my immediate direction," was a specimen of party spite so transparent that it could deceive nobody. The Chancellor of the Exchequer, either ashamed of his subject or forgetting the purpose in hand, most unaccountably gave me in his harangue the credit of the whole affair. He could only have done this from two motives. Either he was too much a gentleman to permit his personal honour to be trampled under foot by his colleagues, or he could not have read the vote of thanks till he came to it at the conclusion of his speech. There is, however, a third hypothesis. The subjoined eulogy might have been pronounced to blind the House. "The attack having thus recommenced on the night of the 13th successively," there was no attack on the night of the 13th, for all the ships taken were destroyed on the afternoon and night of the 12th. Was followed up on the next day by the noble Lord Cochrane. No such thing. I followed up nothing on the 14th, except trying to evade Lord Gambier's signals of recall. A pretty clear proof that the Chancellor had never even read the despatches, and less the minutes of the court-martial. With peculiar gallantry. The consequence was that no less than 3 sail of the line and a 50-gun ship were completely destroyed. The House would not, therefore, he trusted, be disposed to refuse its thanks for eminent services when performed under such great peril and risk, whilst the enemy were possessed of the protection of their own batteries, about which I did not trouble myself, and by which the Imperieuse was not once hit. And other advantages which they could bring into play for the security of their own vessels. It was an enterprise of great and peculiar hazard and difficulty. The result had been highly injurious to the enemy, and had the effect of not only disabling, but removing the enemy's whole squadron from the possibility of being for a considerable time available for the purposes of the naval campaign. Was not this an object of great magnitude?" From this speech it is clear that the Chancellor of the Exchequer considered that the whole success was attributable to my exertions, and it is no less apparent that he contemplated my being included in the vote of thanks. Then why leave me out of the vote of thanks, and give those thanks to those who had nothing to do with this "work of great magnitude"? Lord Mulgrave made no such blunder in the House of Lords, nor even mentioned my name except in terms of a reprobation, possibly because I refused his Lordship's temptation of a squadron and a regiment to hold my peace. Yet it may be that the Chancellor of the Exchequer made no mistake. His eulogy might have been merely intended to appeal to the popular ear, whilst contemptuously excluding me from the vote. Be this as it may, the trick succeeded, and my voice was drowned amidst the clamour of faction, as were the voices of those who supported me in the House. Still, I was not disposed to allow the vote to pass without further protest. I again warned the House that "even their verdict was not conclusive upon character, but that there was another tribunal to which even the House was amenable, and that the public would one day exercise a judgment, even though the House might shirk from a just decision. I inquired what portion of Lord Gambier's exploit merited thanks, or what had been the nature of his exploit. He lay at a distance, never brought his fleet to the place of action, or even within danger, and yet, for such supineness, he was to receive the highest honours of his country. The ground taken by ministers was frivolous, that where the subordinates admittedly deserved the praise, the superiors must receive it. The public would one day read the minutes, though the House would not. The public would judge from the facts, though the House would not. The public would not submit to have its eyes bound, because the House chose to keep theirs shut. Let a single reason be adduced for this vote of thanks, and I was ready to vote for it. but the reasons which had been obtruded on the House were unworthy the name of arguments." Sir John Orde, of all the supporters of the ministry, gave the only honest reason for his vote in favour of Lord Gambier, though probably his argument might not pass current at the present day. It was this: "As thanks to his lordship have been proposed, I shall vote for them, because I entertained this opinion of Lord Gambier's conduct before the prorogation of Parliament, and their lordships of the Admiralty appeared to do the same." Poor Sir John! He must have had better reasons for his arguments than arguments for his reasons. A few more reasonable opinions than that of worthy Sir John shall be transcribed verbatim, and first those of Sir Francis Burdett. "Sir Francis Burdett wished to know whether the service of Lord Gambier was worth the thanks of Parliament, even admitting it to have all the value attributed to it by anything but the unblushing and profuse spirit of ministerial favouritism." Lord Gambier had recently been a colleague of the Lords of the Admiralty. He would not ask whether, on the other hand, there was not the full and decided testimony of a man competent to give his judgment, and of whose admirable valour and good fortune the House and nation had but one opinion. He felt that in making these observations he might be treading on perilous ground. He was probably bringing on himself some charitable retorts, particularly those of a gentleman whose charity was of a very peculiar nature, but he was careless about such remarks, for though he deprecated that person's charity, he would not shun but would rather court his hostility. The footnote reads, "Mr. Croker, who did not, however, respond to the challenge of my excellent colleague. Had he done so, the House would no doubt have been highly amused at the result, but Mr. Croker was wise in his day and generation." The quote continues. Had there been anything said to make out a reason for the vote demanded? Where was the evidence of the Commander-in-Chief's intrepidity or skill, of that boldness which bursts its way through all obstacles, of that genius before which obstacles vanish? In place of this, the House was insulted with a dry catalogue of negatives, and an account as to how the noble Admiral inspected the action at a distance of 7 miles. There is a footnote here of the word 9. The quote continues. The question had been treated lightly, but levity was unbecoming the grave matter for their deliberation. Mr. Windham said, "The thanks of that House did not deserve to be lavished on any man unless his services were of that rank which forced itself into universal report and universal admiration. It was not to be evolved in some obscure process of official chemistry, nor to be drawn out under bundles of obscure records, not to be elicited by any keen, cunning, recondite, subtilising process beyond the practice or perception of the general mass of mankind." There's a footnote here. The footnote reads, "alluding to the court-martial." The footnote ends. The quote continues. To be praised, it must be known. To become matter of thanks, it must be matter of public fact. In voting thanks, it was time to pause. These old rewards had become worthless. It had been said that nothing was left but the peerage, and even of that high honour ministers had been most lavish. This was the natural process when there was no distinct scale of merit and reward. It was high time to stop. They had in their hands the great provision for national virtue. They had the honours of the country entrusted to them, and it became them, as legislators, not to suffer its streams to be idly diverted, nor to be prodigally and profusely poured forth to slake the thirst of undeserving ambition, still panting, still insatiable." Argument and fact were alike unavailing, and Sir John Orde's extraordinary reasons and opinions prevailed. To 161 of the Admiralty opinion, only 39 could be found alive to a true sense of legislative dignity or functions. A few remarks on what passed in the House of Lords, where similar thanks were voted, are necessary. Lord Mulgrave said that it was with great surprise that he first heard that a noble lord serving under the noble Admiral, and a member of another House, had intimated his intention to oppose the vote of the House of Commons, on the ground that his commander had not done his duty to the utmost. Lord Mulgrave, of course, alluded to my conversation with him 9 months before, though I never said anything of the kind to his lordship. What I said was, quote, that the Commander-in-Chief had not done anything deserving the thanks of Parliament, end quote. Had the minutes been allowed to be produced in either House, this would have been proved beyond question, in spite of the sentence of acquittal, which was alone laid on the table. Lord Mulgrave was no less unjust in attempting to convince the peers that I had done nothing but carry out Lord Gambier's plan of fireships, referring them to Lord Gambier's letter of March 19th, 1809, in which, instead of recommending an attack by fireships, Lord Gambier had denounced such an attempt as, quote, hazardous if not desperate, end quote. Reader's note, there is a footnote here. The footnote reads, see Lord Gambier's letter, volume 1, page 312. Reader's note, footnote ends. As would have appeared had the minutes of the court-martial been laid before them. Mine, as explained in the first volume, was not an attack by fireships alone, for such an attack could only have ended in the boarding of the fireships by the enemy's rowboats and the murdering of the crews. It was an attack by means of explosion vessels, which should impress the enemy with the idea that every fireship was similarly charged, so as to have the effect of deterring them from boarding, and thus the fireships, had they been properly directed, must have done their work in spite of the enemy's rowboats. Yet Lord Mulgrave followed Lord Gambier in his suppresso veri. On the very day Lord Gambier had not recommended the use of fireships, though Lord Mulgrave's speech would lead the House, in the absence of minutes of the court-martial, to infer that he had recommended their use, the Commander-in-Chief had stated that an attack with fireships would be, quote, hazardous if not desperate, end quote. A curious way truly of recommending the use of fireships, though, had he recommended them, they would have been of no use without the explosion vessels, the terror created by which formed the very essence of my plan, and was the sole cause, even of the trifling success gained. Again, said Lord Mulgrave, quote, Lord Cochrane arrived at Plymouth. He had on a former occasion been employed in blockading Rochefort, and was acquainted with the coasts. He was therefore consulted, and spoke with greater confidence of the success of the attempt than those who wrote from that quarter. It was not, however, merely zeal and desire of execution he showed, but also the talent he displayed in meeting the objections started by naval men, which induced the Admiralty to employ his lordship." End quote. This representation was thoroughly incorrect. So far from there being any, quote, desire of execution, end quote, on my part, I tried every means in my power to avoid being entrusted with the execution of my own, not Lord Gambier's, plans, as Lord Mulgrave insinuated. He, however, unconsciously admitted that other naval men started such objections, that they could not be got to undertake an attack with fireships, and therefore the duty was thrust on me, with the addition of the explosion vessels I had suggested, thus convincing the Admiralty Board that an attack on my plan was both easy of execution and certain in its result. Lord Mulgrave's expression of, quote, those who wrote from that quarter, end quote, viz. Lord Gambier, showed that the Commander-in-Chief had no confidence in fireships. Neither had I, unless accompanied by my plan of explosion vessels. Still persisting that this was an attack by fireships merely, Lord Mulgrave told the House that it was nothing new, which was the case if the explosion vessels were left out, but that, quote, in the course of the last century there were two services performed by fireships, the first in 1702 at Vigo, and the second off Minorca in 1792. But what was the present service? Recollect, a fleet protected by shoals and currents in sight of their own coast, and in presence of their countrymen. Nothing in the annals of our navy was more brilliant. End quote. Who then performed that brilliant service, than which nothing could be more satisfactory? Lord Mulgrave told the House that Lord Gambier did, whilst lying with his fleet 9 miles off, and reluctantly sending 2 line of battleships and some frigates to my assistance, when almost too late to rescue me from the dilemma into which, in sheer despair of anything being done, I had voluntarily rushed, with the determination that if my frigate was sacrificed, while he was calmly looking on, he should take the consequences, and what they would have been I need not say. It was this act of mine, and this only, which caused the paltry service to be effected of destroying 2 line of battleships and a store-ship, instead of the whole enemy's fleet. Lord Mulgrave's statements were severely rebuked by Lord Holland. Quote, Lord Holland represented in strong terms the light in which ministers place themselves before Parliament and the country by coming forward, so hastily in the first instance to procure thanks, and then suddenly sending Lord Gambier to a court-martial with the thanks on their lips. He thought that in a case of parliamentary thanks, the case should be clear and strong to receive such a reward. What said Lord Cochrane in his reply to the Admiralty? There is a quote within the quote. It reads, "Look and sift the logbooks, and not ask me for accusations." The quote within a quote ends. The original quotation continues. He, Lord Holland, condemned the precipitancy of ministers who by their measures had endeavoured to stultify the House as they had already stultified their own administration. After sending Lord Gambier through the ordeal of a court-martial, Lord Mulgrave now came down, pronounced his praises, and called upon the House to vote him their thanks. It was not in this manner that the French government conducted itself towards their admirals and generals. They instituted a very severe inquiry as to this affair at Basque Roads, and many of their commanders were most severely punished. The footnote reads, "For having, as Bonaparte afterwards said," see Volume 1, page 421, "suffered themselves to be terrified by the explosion vessels, so as to take every fire ship for one, and then to run their ships ashore in order to avoid the impending danger, this result forming the very essence of my plan. Poor Captain Lafon of the Calcutta was shot, not for surrendering to Lord Gambier's fleet, but to the Imperieuse frigate under my command, she being a vessel of inferior force to the Calcutta." The quotation continues. They did not give thanks to General Monnet for his defence of Flushing, but on the contrary censured his conduct most severely. There is a footnote here. It begins, "though he had thwarted, but not so effectively as he might have done, the powerful armament mentioned at the commencement of the next chapter." The footnote ends. The quotation continues. If the barren thanks of both Houses of Parliament were often to be voted in this way, they would soon cease to be of any value. The noble Lord Mulgrave had said a great deal about the Battle of Talavera, and the resistance made to the vote of thanks in that instance. Now it did not appear to him, Lord Holland, that the Battle of Talavera could have anything to do with the action of Basque Roads, or with the conduct of Lord Gambier. But if resistance to the vote of thanks to Lord Wellington were adduced as a proof of party motives, it might well be considered a proof of party spirit on the other side to bring forward motions of thanks for services of such a description as those of Lord Gambier." The remarks of other noble lords were more to the purpose. "Earl Grosvenor did not think the services of Lord Gambier of such a nature as to require the particular thanks of the House. He thought such should only be given on very signal and important victories. Nobody could doubt they were due to Lord Howe for his victory on the 1st of June, to Lord Duncan for his victory at Camperdown, to Lord St. Vincent for his glorious achievements near the Cape which gave him his title, or to the immortal Nelson for the splendid exploits with which he had adorned our naval history. These were things which spoke for themselves, and nobody could doubt the propriety of voting thanks, as it were, by acclamation. He thought, however, the services of Lord Gambier were of a very inferior description, and called for no such reward. Earl Darnley had no objection to the vote of thanks, but at the same time he thought the present vote one of the efforts now too often resorted to throw a false lustre on the government. To compare the services rendered by Lord Gambier at Basque Roads with the battles of the Nile or Trafalgar would be the height of presumption." Lord Darnley was right. The vote itself, no less than the assumption of victory, where, through the pusillanimity of the Commander-in-Chief, none had been achieved, had no other object than to throw a false lustre upon the government, powerful in Rottenborough influence, but justly mistrusted by all besides, whether in Parliament or out of it. Because I acted practically and conscientiously on these sentiments, I have been marked through my life an object of party malevolence. However dexterous might be the ministerial legerdemain, which could convert into victory the admitted intention of the Commander-in-Chief not to fight, there is a footnote here. The footnote reads, "See Captain Broughton's evidence, page 95. The footnote ends. The text continues. Lord Melville alone exposed the real secret of the matter. "Lord Melville conceived the Admiralty to have acted extremely wrong in giving to Lord Cochrane a command so contrary to the usual rules of the service, and which must have been so galling and disgusting to the feeling of other officers in Lord Gambier's fleet. He respected as much as any man could the zeal, intrepidity, and enterprise of Lord Cochrane, but it was wrong to presume that these qualities were wanting in officers of that fleet of superior standing to his lordship. Such a selection naturally put Lord Cochrane upon attempting enterprises whereby great glory might be obtained." Here lies the gist of the whole matter. Had I devised the plan of attack, and had the Board of Admiralty acceded to my earnest wish, and left it to my seniors to execute, or had I persisted in my determination to refuse a command which the Admiralty literally forced upon me, all would have been well. Even had Lord Mulgrave fulfilled his promise of satisfying the amour propre of the fleet, which he neither did nor intended to do, all might have been well. As it was, I was exposed to the full amount of hostility which formed my reason for declining the command in the first instance. It was felt, as Admiral Austen plainly says, by the officers of the fleet in the Basque Roads, that a decisive victory would elevate me in national estimation over my seniors, as it unquestionably would have done. Lord Gambier was an easy man, and the shoal and current bugbear was successfully used to bring the fleet to an anchor in a place of going on to the attack, he knowing no better, and having taken no trouble to ascertain the fact, in short, confining himself to mere blockade. This was the fault of the Commander-in-Chief, but it did not justify him in bringing forward charts made up for the purpose of proving imaginary dangers from ruined fortifications and shoals where none existed. Reader's note, there's a footnote here, it reads, see Captain Broughton's evidence, page 64. Footnote ends, the text continues. Nor did it justify the evidence of influenced witnesses to prove danger, in defiance of his lordship's own admission that no ship suffered injury. Reader's note, there's a footnote here, it reads, see Lord Gambier's defence, page 100. The footnote ends, the text continues. It did not justify his lordship in assuming many things in his defence which were not in evidence at all, and many more things that were totally at variance with the evidence contained in the minutes. To have declined pushing an advantage to victory, in deference to the jealousy of senior officers, was one thing. To trump up a story of an old storeship breaking up a boom of more than a mile in lineal extent and moored with 100 anchors was another. It will now be seen why the government of that day refused the production of the minutes of the court-martial, almost every page of which would have rendered the defence of the Commander-in-Chief, or rather that of his solicitor, Mr. Lavey, for I will do Lord Gambier the justice of believing that he did not write the defence read to the court by the Judge Advocate, untenable for a moment. That the ministry of that corrupt day should have resorted to such a subterfuge can, however, scarcely add to the contempt with which history already regards them. I told the House of Commons that, quote, posterity would judge their acts, end quote. Here, then, is matter for that judgment. That it was not made public at the time arose from two causes. First, that in those days the bulk of the press was influenced by the ministry, and a jackal howl from one end of the kingdom to the other would have been, and was, the reward of my pains. Secondly, that until his Grace the Duke of Somerset gave me, a few months since, the charter and other official materials requisite to lay the matter before posterity, it was not in my power to do so, except on my previous attempts at justification by assertions which would have had no more effect on the public mind than now would those of the factions which persecuted me. As I belonged to no party in the House, I found no friends but the few who, like myself, stood alone in their independence of party. They were themselves disorganised, and deceived by the well-timed eulogy of the Chancellor of the Exchequer into the belief that the vote of thanks included me also. The numbers of the independent party were, however, as nothing compared to the organised masses in power, or eager to place themselves in power. The debate was felt to have most seriously damaged the party to whom I was politically opposed, and that party ever afterwards made me a mark for their revenge. In this brief sentence may my whole subsequent history be comprised. End of chapter 28. Recording by Timothy Ferguson, Gold Coast, Australia. Chapter 29 of Autobiography of a Seaman, Volume 2, by Lord Thomas Cochrane. This LibriVox recording is in the public domain. Recording by Timothy Ferguson. Refusal of my plans for attacking the French fleet in the Scheldt. Just at the period of the court-martial on Lord Gambier, great national expectations were excited by the combined military and naval expedition to Walcheren under the Earl of Chatham and Sir Richard Strachan. The object of this armament, the most formidable England had ever sent forth, was the capture or destruction of the French fleet in the Scheldt, and of the arsenals and dockyards of Flushing, Ternus, and Antwerp, at the latter of which ports Bonaparte was carrying on naval works with great vigour. The force employed for this purpose comprised 40,000 troops, 35 sail of the line, 2 50-gun ships, 3 44-gun ships, 18 frigates, and nearly 200 smaller vessels, besides dockyard craft. The first portion of the expedition quitting the Downs on the 28th of July, 1809, and anchoring the same evening near the coast of Walcheren. To the reader acquainted with the views expressed in the first volume of this work, it will not be surprising that I viewed the departure of this force with regret, as had one half of the troops been placed, as suggested in my letter to Lord Mulgrave, on the islands of the French coast, and had half the frigates alone been employed, as had been the Imperieuse, and other vessels in the Mediterranean, not a man could have been detached from western France to the Spanish peninsula, from which the remaining portion of the British army might have driven the French troops already there. Full of these views, and knowing that short work might be made of the Walcheren expedition, so as to liberate both the naval and military force for service elsewhere, I laid before the Admiralty a plan for destroying the French fleet and the Flemish dockyards, somewhat analogous to that which would have proved completely effectual in Basque Roads, had it been followed up by the Commander-in-Chief. My new plan had, moreover, received an important addition from the experience there gained, and was now as formidable against fortifications as against fleets. The first measure of indignation against me for my late services to my country was the summary rejection of my plan, and not only this, but a refusal by Admiralty letter given elsewhere to proceed to the Scheldt to join my frigate, which had been sent there under the temporary command of the Honourable Captain Duncan, a most excellent and gallant officer. Of the disastrous failure of the Walcheren expedition, the destruction of a large portion of the army by disease, and the retreat of the remainder, I shall not speak, these matters being already well known to the student of English history. I will, however, assert, and the assertion will be borne out by the plan of attack submitted by me to the Admiralty, that had my recommendation been adopted, even though not carried out under my own supervision, nothing could have saved the French fleet then in the Scheldt from a similar fate to that which had befallen their armament in Aix Roads, even, as with the disaster in Aix Roads fresh in remembrance is probable, had the French fleet in the Scheldt taken refuge above Antwerp, it could only have placed itself in a cul-de-sac, whilst there was ample military and naval force to operate against the dockyards and fortifications during the period that my appliances for the destruction of the enemy's fleet were in progress. For I in no way wished to interfere with the operations of the general or admiral commanding, but rather to conduct my own operations independently of extraordinary aid from either. The cost of this plan to the nation would have been 10 rotten old hulks, some 50,000 barrels of powder, and a proportionate quantity of shells. The cost of the expedition, which failed, in addition to the thousands of lives sacrificed, was millions, and the millions which followed, by the prolongation of the war, by the refusal of the Admiralty to put in operation any naval expedition calculated to effect a beneficial object, who shall count? So much for war when conducted by cabinets. But I was now a marked man, and the government evidently considered it preferable that the largest force which England had ever despatched from her shores should incur the chance of failure in its object, than the simple and easily applied plans of a junior post-captain should again jeopardise the reputation of his Commander-in-Chief. It was very curious that whilst this animosity was being directed against me in my professional capacity, I had shortly before received from His Majesty George III the highest decoration of the Order of the Bath for my professional services. So little secret did the government make of their determination not to employ me again, that the public press regarded this determination as a settled matter. It was nothing that I had been instrumental in destroying the fleet so much dreaded by our West Indian merchants and the nation generally, or that I had offered to serve the French fleet in the Scheldt in the same way. I was now an obnoxious man, and the national expenditure of millions for defeat was by the ministry of that day deemed preferable to chief victory if achieved by a junior officer to whom the Chancellor of the Exchequer, whilst denying him thanks for the service, had attributed the destruction of a fleet quite as formidable as the one in the Scheldt. It may be scarcely credible to the present age that the government should have openly announced such a determination. On the principle adopted throughout this work of adducing nothing without proof, it will be necessary to place the preceding facts beyond dispute. From one of the most talented periodicals of the time I extract the following passage. Quote, "The worst injury which the radical reformers have done the country has been depriving it of Lord Cochrane's services, and withdrawing him from that career which he had so gloriously begun." End quote. The pretence was that I had withdrawn myself at the time I was entreating the Admiralty to permit me to return to my frigate. This matter will shortly be made very clear. One grave cause of offence to the ministry, in addition to my determination to oppose the vote of thanks to Lord Gambier, had been the part I took at the famous meeting held at the Crown and Anchor in the Strand. For a junior naval officer in that day to associate with such persons as Sir Francis Burdett and Major Cartwright was bad enough, but that he should act with them was a thing unheard of in the naval service. At this meeting many irritating things were said, though not by me. The late trial of the Duke of York was freely handled, and Colonel Wardle, the principal promoter of it, held up to public admiration. The "borough-mongering faction," as it was forcibly termed by Sir Francis Burdett, was painted as involving the country in perpetual misfortune, and consigning to hopeless imprisonment all who ventured to expose their practices, whilst it was said even His Majesty could not carry on his fair share of government, being compelled to choose his ministers from a faction which not only oppressed the people, but controlled the king himself. The resolutions moved by good old Major Cartwright at this celebrated meeting were at that time regarded as treason, though at the present day sound doctrine, viz. that, "so long as the people were not fairly represented, corruption must increase, our debts and taxes accumulate, our resources be dissipated, the native energy of the people be depressed, and the country be deprived of its best defences. The remedy was only to be found in the principles handed down to us by the wisdom and virtue of our forefathers, in a full and fair representation of the people in Parliament." This was perfectly true, and singularly enough, after the lapse of 51 years, the very same question forms the principal feature of our present session of Parliament, the debates on the subject in our day differing very little from their predecessors of half a century ago, if we may credit the following picture from a Times leader of April 23rd last. "Call reform what you will, it is almost anything you please except legislation. The belligerent parties will fight and cheat one another, and both together will cheat the people." If, after a battle of 50 years, the people have not achieved the victory which early reformers began, I have some right to call on the public to estimate the amount of obloquy which fell upon myself for my voluntary enrolment amongst the combatants on their side, and in the belief that the public of the present day will do my memory that justice which through life has been denied me, I shall not shrink from laying these matters before them. If such a picture of our present legislators be truly drawn, what must have been that of the faction against which I had to contend? The speech made by me at the Crown and Anchor was very moderate, and indeed was spoken of by the ministerial organs as expressing less of the spirit of faction than any which had been delivered on that day. The worst part of it, so far as I can recollect, was that generally recorded that "I hoped the time would come when ministers would not be employed all day in thinking what they were to cavil about all night, and all night in useless debate, whereby the real business of the country was neglected, so much so indeed that when the newspapers had reached me abroad, I felt ashamed at the manner in which the government of my country was conducted." I had even gone further in moderation, though the ministry did not know it, viz. by observing to Sir Francis Burdett that I thought he was going too far. His reply was characteristic. "My dear Lord Cochrane, you don't know ministers. If you wish to get anything from them, you must go for a great deal more than you want. Even then you will get little enough." "Oh," I replied, "if those are your tactics, go on, I'll follow." The real grievance was, however, my support of the motions in Parliament which arose from the meetings at the Crown and Anchor. Mr. Maddox distinctly charged the ministry with trafficking in seats, offering to prove to the House that Lord Castlereagh had, through the agency of the Honourable Mr. Wellesley, been instrumental in purchasing for Mr. Quintin Dick the borough of Cashel, and that when in the matter of the Duke of York Mr. Dick had determined to vote according to his conscience, Lord Castlereagh intimated to that gentleman the necessity of voting with the Government or resigning his seat, which was accordingly done. The Ministry declined to accept the challenge. *Footnote. The defence of these charges consisted of what was termed eloquence, but which was nothing but empty declamation without the slightest attempt at argument. The subjoined effort of Mr. Canning on this very occasion is a specimen. There is a quote within the footnote. It reads, "Good God! Was this the time to suppose that the character of the House of Commons was lost, and that the most hazardous experiments should be made to restore it? It was the character and influence of that House which had achieved all our blessings, and distinguished the character and condition of this country from that of any other country in the world. Was the source from which such blessings flows to be stigmatised as a sink of corruption?" The quote ends. The footnote continues, "Even at the present day, this is amusing." The footnote ends. The text continues. The subsequent motion of Mr. Curwen went further, but I must not forget that I am writing my autobiography and not political history. I never made pretensions to parliamentary eloquence, and shall not inflict on the reader my humble efforts, excepting only those connected with the naval service. On the 19th of February I moved for certain papers relative to the conduct of the Admiralty Court, and as my speech on that occasion was sufficiently comprehensive, I will adduce it with some slight explanations indicative of the practices which at that time were in full operation. "If these papers are granted, it will be in my power to expose a system of abuses in the Admiralty Court unparalleled in this country, even exceeding those prevalent in Spain under the infamous administration of Godoy. The whole navy of England was, by the existing system, compelled to employ one individual to carry on its business before the Admiralty Court, a person, perhaps, in whose competence or honesty they might have no confidence. But admitting his ability and integrity to be unquestionable, still the thing was preposterous. Would any man like to employ an attorney who, at the same time, did business for the other side? Was such a regulation consistent with equity or common sense? Even the personal liberty of naval officers was answerable for some seizures, the produce of which notwithstanding went to the Crown, and the most abominable compromises sometimes took place. Whether the profits of these compromises found their way into the pockets of any particular individual I was not absolutely sure, but had evidence to presume that this was the fact. What indeed could be the design of confining the captors to one proctor, except that secrecy as to these questionable transactions may be preserved?" One case was my own. In the first volume of this work is narrated the capture of the King George privateer, or pirate, for which seizure by any vessel of war a reward of £500 had been issued. The King George, in part, actually belonged to parties connected with the Maltese Admiralty Court. As her condemnation was unavoidable, she was condemned as a droit to the Crown, and costs to the extent of £600 were decreed against myself, officers, and crew for having taken her, a subject which will hereafter have to be further alluded to. The effect of this system was to indispose officers to look after prizes, and thus many an enemy's vessel was suffered to escape. One of my reasons for harassing the French out of the coasts of Languedoc and Catalonia was that it appeared more advantageous to effect something of service to the country than to take prizes for no better end than to enrich the officers of the Maltese Admiralty Court, and at the same time to be ourselves condemned in costs for our trouble. Some curious stories might be told of the effects of the system. It was my own practice, when any money was captured in a prize, to divide it into two portions, first the Admiral's share and next our own. Then we buried the money in a sandbank, in order that it might not be in our possession, and as opportunity occurred, it was afterwards taken up. The Admiral's share being transmitted to him, our share was then distributed at the capstan in the usual proportions. As I never made any secret of my own transactions, the Maltese officials regarded me with perfect hatred, they no doubt honestly believing that by appropriating our own captures to our own use, we were cheating them out of what they had more right to than ourselves. By their practices they appeared to entertain one idea only, viz., that officers were appointed to ships of war for the sole purpose of enriching them. In a case narrated in the first volume, where I had, in Caldorg's Bay, taken 13 vessels laden with corn for the French army in Barcelona. After having sunk 2 small vessels of war protecting them, we sold the corn vessels and their cargo to the Spaniards for a trifle, dividing the dollars amongst us, after sending Lord Collingwood his share. We afterwards took the vessels of war, after raising them, to Gibraltar, where I purchased one as a yacht. Had I sent those corn vessels to Malta, and had them condemned there, in place of obtaining anything from the capture, a heavy bill of costs for the condemnation of such small vessels would have greatly exceeded the sum realised by their sale. To return to my address to the House, "The Navy was paralysed by this corrupt system. The most insignificant vessels were condemned at an expense equal to that of the largest, so that the condemnation of a fishing lugger might be swelled up to the expense of condemning an Indiaman, the labour of capture ending in nothing but putting money in the proctor's pocket. As an instance within my own knowledge, Moses Griffin, a Jew agent at one of the outports, received 2/3 out of the produce of a vessel, the remaining third being the whole share distributed for the admiral, captains, inferior officers, petty officers, seamen, and marines. What was the effect of such a system but to paralyse the Navy? It prevented exertion on the part of the officers. Could it possibly be necessary to have 120 ships of the line in commission to blockade 23 ships of the enemy, if proper exertions were made? To ensure alacrity in harassing the shipping and commerce of the enemy, the abuses of the Admiralty must be stopped, and nothing else would be effectual." A more startling practice was the following: "The commerce of the enemy was carried on to an immense extent by a system of licences, which permitted the enemy to trade where they pleased. These licences, issued by us, formed an article of common sale in Hamburg and other places, and by means of such licences the enemy's ships were seen coasting along by hundreds in perfect security, even filling the river Thames, contrary to the Navigation Act. We were thus raising up sailors for Bonaparte, to whose commerce and navy our ministers were the best friends." My representations were met by Sir Walter Scott, the Judge of the Admiralty Court, with the inquiry as to "how that the court could possibly be answerable for the accounts of the agents on which I had founded my invectives. Lord Cochrane was a prompt accuser, but an unfortunate one, and he pledged his credit that these accusations would prove as unfortunate as any that had preceded them." Unluckily for Sir William Scott's allusion to my "unfortunate habit of making unfounded accusations," Mr. Rose, the Treasurer of the Navy, got up and officially confirmed my statements by admitting the abuses complained of. "This evil," said Mr. Rose, "had been so strongly represented to him that soon after he had become Treasurer to the Navy he had bestowed many days and nights in its investigation. The result was that he had before him no less than 153 cases, 9 out of which were before the Judge of the Admiralty Court, Sir W. Scott himself, in consequence of the enormous charges which their accounts contained. In one case, the charges of an agent at Portsmouth, who had 62,000£ to distribute, amounted to 9,462/., of which 1,200£ was stated to be for postage." Mr. Rose recommended me to alter my motion, and to move for papers relative to a particular ship. I took this advice, and moved for documents relating to 2 vessels which was carried. Sir William Scott, however, never forgave me. On the 9th of March, when these papers were laid before the House, I moved for others in order to elucidate them. This gave rise to another debate, in which some curious facts were brought to light by Colonel Wardle. "In the Navy Pay Office, it was usual to promote junior clerks over the heads of men who were many years their seniors in the service. One junior clerk, 11 years in the office, was promoted to a place of £300 a year over the heads of senior clerks from 27 to 30 years in service. In another case, a gentleman was obliged to retire against his will on £170 per annum, and a boy of 14 was appointed to his situation, with a raised salary, and over the heads of many senior clerks. The Secretary of the Sick and Hurt Office was pensioned off at his full salary of £500, and an assistant appointed in his stead with a salary of £1,000." On the 12th of March, my respected colleague, Sir Francis Burdett, than whom a purer patriot never breathed, moved that Mr. Gale Jones should be discharged from Newgate, to which prison he had been committed by order of the House for placarding a handbill, the contents of which were construed into a violation of the privileges of the House. Sir Francis, conceiving that the people had privileges as well as those claiming to be their representatives, or rather that the popular voice constituted the power of their representatives, demanded the release of Mr. Jones, on the ground that the House possessed no privilege to commit a man for asserting his right to discuss its measures, and that neither legally nor constitutionally could such a privilege exist. The debate which ensued, not coming within the scope of this work, may be omitted. Suffice it to say that Sir Francis published in Cobbett's Weekly Register a revised account of his speech, in which he declared that the House of Commons sought to set aside Magna Carta and the laws of England by an order founded on their own irresponsible power. Accompanying this revised speech was a letter addressed by Sir Francis to his constituents of Westminster, and these coupled together the House chose to construe into a breach of their privileges also. The result, as everyone knows, was a motion for the committal of Sir Francis Burdett to the Tower. My worthy colleague, however, refused to surrender. As there was no knowing to what lengths the despotism of the House might extend, a rumour of breaking into the honourable baronet's house being prevalent, a number of his friends, myself amongst them, assembled at his residence in Piccadilly to see fair play. But one morning during our absence, an officer armed with the Speaker's warrant forcibly entered, and Sir Francis was carried off to the place of his imprisonment. It is quite unnecessary to detail these circumstances, as they are well known to every reader of English history. On the day after my excellent colleague's capture, the electors of Westminster held a meeting in Palace Yard, and adopted a petition which fell to my lot to present to the House. The petition went even farther than had Sir Francis, by denouncing the House as prosecutor and juror, judge and executioner, and denying its right to exercise these combined offices. It taunted the House with evading the offer of a member to prove at the bar that two of the ministers had been distinctly charged with the sale of a seat on their benches, and that such practices were as notorious as the sun at noonday." They therefore prayed not only for the release of their member, but for a reform of the House itself, "as the only means of preserving the country from despotism." To have committed the whole of the electors of Westminster for adopting such a petition would have been inconvenient. To have committed me for presenting it would have been scarcely less dangerous, as depriving Westminster of both its representatives. The predominant feeling in the House appeared to be that of astonishment that a naval officer should dare to meddle with such matters. One member opposed its reception at all. Another begged me to withdraw it, which I refused to do, and therefore the House adopted the only possible alternative of "ordering it lie on the table." The feeling towards myself may be conceived. A similar petition from the freeholders of Middlesex was presented by Mr. Byng, and denounced by Mr. Perceval as a "deliberate and unparalleled insult to the House." The petition denying the right of the House to imprison Sir Francis, and accusing Mr. Perceval and Lord Castlereagh by name as openly trafficking in seats. The petitioners further declaring that the presence of Sir Francis Burdett in the House was necessary to "enforce his plan of reform." Angry debate followed, but neither Sir Francis nor Mr. Jones were released till the following month of June. On the 11th of May, Mr. Croker proposed a vote for the ordinances of the Navy, when I embraced the opportunity of making what was at that time termed "one of the most remarkable speeches ever delivered in that House." The speech was indeed remarkable, not for its eloquence, for it had none, but for some very awkward statistics which my enforced leisure had enabled me to collect and arrange. And let me here remark, that when my parliamentary speeches are adduced, the object is to give a faithful picture of the condition, as well of the House as of the Navy at that period, not as specimens of an eloquence to which I had no pretension. My parliamentary efforts, such as they are on record, and the reproduction of a portion may save both myself and the reader the trouble of further dilating thereon. One besetting sin of the administration was the bestowal of pensions, which was carried on to a wonderful extent. Wives, daughters, distant relatives, etc., of all sorts of people who had votes or influence, claimed a pension as a matter of right. Another besetting sin of the government was doling out pittances scarcely sufficient for the support of life to those who had fought and bled for their country. Bearing this in mind, the reader will readily comprehend the following "remarkable" address, as it has been termed by historical writers, to the House of Commons. "An admiral, worn out in the service, is superannuated at £410 a year, a captain at £210, a clerk of the ticket office retires on £700 a year. The widow of Admiral Sir Andrew Mitchell has 1/3 of the allowance given to the widow of a Commissioner of the Navy. I will give the House another instance. 4 daughters of the gallant Captain Courtenay have £12 10s. each. The daughter of Admiral Sir Andrew Mitchell has £25. 2 daughters of Admiral Epworth have £25 each. The daughter of Admiral Keppel, £24. The daughter of Captain Mann, who was killed in action, £25. 4 children of Admiral Moriarty, £25 each. That is 13 daughters of admirals and captains, several of whose fathers fell in the service of their country, receive from the gratitude of the nation a sum less than Dame Mary Saxton, the widow of a commissioner." The pension list is not formed on any comparative rank or merit, length of service, or any other rational principle, but appears to me to be dependent on parliamentary influence alone. Lieutenant Ellison, who lost his arm, is allowed £91 5s. Captain Johnston, who lost his arm, has only £45 12s. 6d. Lieutenant Arden, who lost his arm, has £91 5s. Lieutenant Campbell, who lost his leg, £40. And poor Lieutenant Chambers, who lost both legs, has only £80, whilst Sir A.S. Howard retires on £1,500 per annum. The brave Sir Samuel Hood, who lost his arm, has only £500, whilst the Secretary of the Admiralty retires in full health on a pension of £1,500 per annum. To speak less in detail, 32 flag officers, 22 captains, 50 lieutenants, 180 masters, 36 surgeons, 23 pursers, 91 boatswains, 97 gunners, 202 carpenters, and 41 cooks, in all 774 persons, cost the country £4,028 less than the net proceeds of the sinecures of Lords Arden, £20,358, Camden, £20,536, and Buckingham, £20,693. All the superannuated admirals, captains, and lieutenants put together have but £1,012 more than Earl Camden's sinecure alone. All that is paid to the wounded officers of the whole British Navy, and to the wives and children of those dead or killed in action, do not amount, by £214, to as much as Lord Arden's sinecure alone, viz. £20,358. What is paid to the mutilated officers themselves is but half as much. Is this justice? Is this the treatment which the officers of the Navy deserve at the hands of those who call themselves His Majesty's Government? Does the country know of this injustice? Will this too be defended? If I express myself with warmth, I trust in the indulgence of the House. I cannot suppress my feelings. Should 31 commissioners, commissioners' wives, and clerks have £3,899 more amongst them than all the wounded officers of the Navy of England? I find on examination that the Wellesleys receive from the public £34,729, a sum equal to 426 pairs of lieutenants' legs, calculated at the rate of allowance of Lieutenant Chambers' legs. Calculating for the pension of Captain Johnston's arm, viz. £45, Lord Arden's sinecure is equal to the value of 1,022 captains' arms. The Marquis of Buckingham's sinecure alone will maintain the whole ordinary establishment of the victualling department at Chatham, Dover, Gibraltar, Sheerness, Downs, Helgoland, Cork, Malta, Mediterranean, Cape of Good Hope, Rio de Janeiro, and leave £5,460 in treasury. 2 of these comfortable sinecures would victual the officers and men serving in all the ships in ordinary in Great Britain, viz. 117 sail of the line, 105 frigates, 27 sloops, and 50 hulks. 3 of them would maintain the dockyard establishments at Portsmouth and Plymouth. The addition of a few more would amount to as much as the whole ordinary establishments of the royal dockyards at Chatham, Woolwich, Deptford, and Sheerness, whilst the sinecures and officers executed wholly by deputy would more than maintain the ordinary establishment of all the royal dockyards in the kingdom." Even Mr. Ponsonby, who lately made so pathetic an appeal to the good sense of the people of England against those whom he was pleased to term demagogues, actually receives, for having been 13 months in office, a sum equal to 9 admirals who have spent their lives in the service of their country, 3 times as much as all the pensions given to all the daughters and children of all the admirals, captains, lieutenants, and other officers who have died in indigent circumstances or who have been killed in the service." This portion of the speech, true in every figure, was not incorrectly termed remarkable, and it made an enemy of every sinecurist named, as I had afterwards but too good reason to know. Nevertheless, the administration had made a mistake. I was not permitted to be employed afloat, and was determined to effect all the good I could for the naval service by advocating its interests ashore. But the worst was yet to come. My very excellent grandmother, of whom I have spoken in the first volume of this work, in terms feebly expressive of her worth, had a pension of £100 for the services of her gallant husband, Captain Gilchrist, and though she had been dead 8 years, some patriotic individual had been drawing her pension as though she was still living, given 100 widows with a pension of £100 each, and someone was at the national expense the richer by £10,000 per annum. On this point I thus proceeded, no doubt to the intense disgust of the party enjoying the defunct pensions. Quote, "From the minute expenses noticed in the naval estimate, viz. For oiling clocks, killing rats, and keeping cats, I suppose that great care has been taken to have everything correct. It was, therefore, with great surprise that I found the name of my worthy and respected grandmother, the widow of the late Captain Gilchrist of the Navy, continuing on the list as receiving £100 per annum, though she ceased to exist 8 years ago." Notwithstanding the unanswerable argument of my grandmother's pension and the equally unanswerable comparison of sinecures and naval rewards, the Secretary of the Admiralty, Mr. Wellesley Pole, considered that he satisfactorily replied to both by pronouncing my statements "inaccurate and my complaints inconsistent." As to the pensions to the children of admirals, Lord Cochrane must know very well that the widow or children of an admiral were not entitled, strictly speaking, to any pension." In his defence of the sinecures of his own family, Mr. Wellesley Pole was even more infelicitous. "Lord Cochrane has thought proper to make an attack on the Wellesley family, of which I am a member. He asserts that the Wellesleys receive from the public no less than £34,000 a year in sinecure places, and then makes a calculation of the number of arms and legs that sum would compensate. In answer to this, I observe that no member of the Wellesley family, except the noble lord at the head of it, possesses any sinecure. The noble lord certainly did, many years ago, receive the reversion of a sinecure, which had since fallen in, when he was about to go to a distant part of the world in a most arduous and important public station. He was at that time in a delicate state of health, and had a large family." That is, Mr. Wellesley Pole confirmed my calculation of the arms and legs. Though one sinecure had "fallen in," he neither said when, nor what other sinecures had since accrued to the head of the family. His general reply to the matter is curious even at the present day. Mr. Wellesley Pole proceeded, "There is a considerable degree of eccentricity in the noble lord's manner, but at the same time he has so much good British stuff about him, and so much knowledge of his profession, that he will always be listened to with great respect. It is, therefore, the more to be lamented that he does not follow the dictates of his own good understanding, instead of being guided by the erroneous advice and adopting the wild theories of others. Let me advise him that adherence to the pursuits of his profession, of which he is so great an ornament, will tend more to his own honour and to the advantage of his country than a perseverance in the conduct which he has of late adopted, conduct which can only lead him into error, and make him the dupe of those who use the authority of his name to advance their own mischievous purposes." This overture was unmistakable. If I would quit Sir Francis Burdett, sell my constituents, and come over to the ministerial side, the government would, despite the affair of Lord Gambier, put me in the way of advancement. If I did not forsake my party, the high professional character drawn by Mr. Wellesley Pole would avail me nothing, not even to get employed again. I need scarcely say that the overture, politely insinuating as it did that I was to be bought, was rejected on my part. The remainder of my speech consisted of a contrast between this reckless extravagance in pensions and sinecures, and the petty saving which rendered the Navy useless. "Such are some of the pretended savings by which, when any are made, the country is duped. Were there a prospect of success, I could point out some savings better worthy attention. By adopting canvass of a better quality, a saving equal to the additional income tax imposed by the Whigs may be made, equal in fact to 1/4 of the Navy. The remaining 3/4 of ships will be more effectual than the whole, as their velocity would be increased by upwards of half a mile in 7, and they would thus be enabled to capture those vessels which at present escape from them all. The enemy distinguish our ships of war from foreign ships by the colour of the wretched canvass, and run away the moment they perceive our black sails rising above the horizon, a circumstance to which they owe their safety, even more than to its open texture. I have observed the meridian altitude of the sun through the foretopsail, and by bringing it to the horizon through the foresail, have ascertained the latitude as correctly as I could have done otherwise. The paltry increase of cost will be more than compensated by the superior strength of the canvas, on which depend the safety of the ship and the preservation of all lives on board. I shall, no doubt, hear it urged that a remedy is about to be applied, and so it has ever since I can remember, but remedies at public boards are sought in vain." To comprehend the preceding statements, it may be necessary to observe that we had at that time more than 1000 ships of war of all classes afloat, and that from the general bad character of their sailing and equipment, the enemy, who had little more than 1/10 of the number, fairly laughed at us. Under any circumstances the waste of money was deplorable, but under the corrupt system by which worthless ships were then introduced into the Navy, to which subject allusion is made in the first volume, it was utter paralysation of every natural effort. The amount of obloquy these efforts to raise the condition of the naval service brought on me, amongst persons who held that afloat or ashore the duty of a naval officer was implicit obedience to the ministry of the day, will be readily understood. Reply to my statements being impossible, the ministerial organs made me subject to numerous bad squibs, one of which is subjoined. "You fight so well and speak so ill, your case is somewhat odd. Fighting abroad you're quite at home, speaking at home abroad. Therefore your friends, than hear yourself, would rather of you hear, and that your name in the Gazette than journals should appear." The wit is somewhat obtuse, but the feeling here expressed was no doubt sincere. The ministers indeed began to suspect that they had committed an error in preventing me from joining my ship, and shortly afterwards attempted to repair it by ordering me immediately to sea, with what effect will appear in the next chapter. To the credit of the present age, wilful corruption has passed away, but false economy still prevails. It is only 6 years ago that we commenced a war without a single gunboat, the only description of vessel that could operate with effect in the enemy's waters. The consequence was that nothing was effected. At the close of the war we built gunboats by the score, but now that they may be required for the defence of our own coasts, only to find them so rotten as to be in danger of crumbling under the concussion arising from their own fire. In the absence of a more assignable reason, it may be assumed that they have been cheaply built, for it cannot for a moment be supposed that the disaster arose from want of proper supervision. The subjoined extract from a leading article of the Times on April the 25th, 1860, will tell the story better than I can, and by that the public will see that the vice of what may be termed extravagant saving is not yet extinct. "5 years ago we were compelled to denounce the management of our military and naval establishments. The public and the government have long since done us justice in this matter, the former demanding that the system which paralysed the efforts of Englishmen should be at once reformed, the latter by setting about those reforms with more or less activity. We have now most unwillingly to return to the charge, and to lay before our readers a sad history of mismanagement and waste. At this time, we are told, there are 47 gunboats, besides mortar vessels, hauled up at Haslar Yard. All the world remembers the paean which was sung over this miniature fleet. Christened with coquettish little names, the gunboats, built according to the newest model and commanded by gallant young officers, were the pets and the pride of the country. It was told how after the war they were all drawn up ready for use on the shortest notice, how they could be brought down to the water in less than an hour, and the enemy confronted in less than a week with an extempore fleet as formidable as any that could issue from Cherbourg. 22, we are told, have been repaired at a great cost, and with the exception of Cochrane, are fit for launching. 9 vessels are under repair, 14 are waiting examination. These repairs began more than 3 years ago, and have been continued at intervals to the present time. It will appear singular that vessels built only in 1854 and 1855 should so soon require such extensive reconstruction. Very quietly do these repairs seem to have been carried on. The decay has been attributed to the fact that the gunboats had been stripped of their copper and placed high and dry in a current of air. But now it is announced that the decay must be attributed to another cause. Some gunboats which had been kept afloat have been hauled up, and have been found to be far more defective than those stored beneath the sheds, and the only conclusion which can be arrived at is that the whole of our gunboats afloat are unfit for service." They have been constructed with the most reckless disregard to the quality of the material. If those which have been examined are a sample of the whole, we are at this moment without an efficient gunboat. Scarcely a sound piece of wood can be seen about them, every part bearing marks of sap, and some of the ribs are completely enveloped with it. The pressure of the hand on their frame crumbles it to dust. Much more to this effect is given in our naval intelligence. The copper bolts also, which should have gone through and been clinched on each side, "were found to have been changed into short ends of about 2 inches, driven in on each side," a fact which, if correct, convicts either the builders or their workmen of a deliberate and most disgraceful fraud. It may be that the government price was too low, and it is said that only 2 sound vessels were built by a firm which lost money by their construction. But that cannot be an excuse for the others. The public will demand a searching and unsparing inquiry into these delinquencies, and if it should appear that men holding a foremost position in the community have been guilty of such malpractices, they should be duly exposed and punished. End of chapter 29. Recording by Timothy Ferguson, Gold Coast, Australia. Chapter 30 of Autobiography of a Seaman, Volume 2, by Lord Thomas Cochrane. This LibriVox recording is in the public domain. Recording by Timothy Ferguson. Chapter 30. My plans for attacking the French coast refused, and myself superseded. It has already been stated that the Impérieuse frigate under my command had been placed by the Admiralty under the orders of the Honourable Captain Duncan, son of the distinguished Admiral of that name, as acting captain, but that permission to resume her command in the Scheldt had been refused on my application to rejoin her, no doubt with the intention of preventing me from effecting anything more which might become obnoxious to another admiral. Now that my presence in the House of Commons had become inconvenient, the Admiralty affected to consider that I was unjustifiably absenting myself from my ship, and an intimation was given that I must join her within a week. So far from my absence being voluntary, it had been forced upon me from the necessity of attending the court-martial, and an acting captain was to be put in my place. When I found that this step was determined on, I asked that Captain Duncan might be appointed, knowing that he would carry out my views in the management of a crew to which I was attached, as from long and arduous service they were attached to me. But notwithstanding this temporary appointment, I was anxiously urging on the Board of Admiralty the necessity of further operations in which it was my earnest wish to bear a part. The correspondence which took place with the Admiralty will not only show this, but the record may prove useful in case of future wars. On the 7th of June, 1810, I transmitted the subjoined letter to the Honourable Charles Yorke, who had succeeded Lord Mulgrave as the First Lord of the Admiralty. London, 7th June, 1810. Sir, when I had the honour to present myself to you the other day, I used the freedom to submit to your judgment the mode by which the commerce of the enemy might, in my humble opinion, be greatly injured, if not completely ruined, and that such mode, whilst assisting the present, would be providing for the future exigencies of the state. The subject has pressed itself so forcibly on my attention that I am induced to address you by letter, which is perhaps the best means to avoid engaging too much of your time. Passing over the points I then noticed as a stimulus to the Navy, which, unfortunately for this country, though for the benefit of our inveterate foe, is checked and restrained in its operations, I shall beg permission to call your attention to other parts of the subject I had then the honour to introduce. I am more impelled to the intrusion by the intelligence recently received of the islands of Las Midas on the coast of Catalonia having been taken by the French, who were doubtlessly influenced by the motive that ought to actuate us to possess ourselves of the islands on the coast of France, or such of them as tend to aid her best interests. In the present state of our Navy, the French rest in the fullest confidence of assured security, and are, therefore, entirely at our mercy, as regards the objects in my contemplation. In the present state of French security, l'Île Groa, at the mouth of the Loire, and l'Île d'Aix, on the coast of Brittany, may be easily seized by 800 men, in defiance of any opposition, and by a coup de main a fourth part of that number would be sufficient. These islands would afford safe anchorage to our cruisers, with the wind on shore, and when, in the winter season, it is dangerous to approach them. The islands at the entrance of the port of Marseilles could be taken by 100 men, and their importance is demonstrable by their situation. United with the possession of one of the Heres, they would enable us to cut off the communication between that part of France, which consumes the commodities of Italy, and thus the trade of Leghorn and Genoa, once of importance to us, would be lost to our enemy, who now exclusively enjoys it. The port of Bayonne, whence the French supply their dockyards at Rochefort and Brest with timber, may be rendered useless by sinking a few old vessels laden with stones. In like manner, the anchorage of Isle d'Aix might be destroyed, the passages in the entrance of the Garonne rendered impracticable, and that of Mamusson filled up. Proceeding on a more extensive scale, Belle Isle offers itself to particular notice, and would be a most valuable acquisition, as it gives shelter at all times to shipping. At Sète, commanding the entrance of the canal through which the whole produce of Italy and the shores of the Mediterranean are transported to the north of the French Empire, the locks might be seized on with facility, and held or blown up, in defiance of the whole power of Bonaparte now in France. The Isle of Elba might be reduced with as little difficulty, and, as it contains two excellent harbours, and protects the anchorage in the Piombia Passage, it is well calculated to interrupt all intercourse between the Roman, Italian, and Tuscan states. Were it in our hands at this moment, it would be an invaluable depot for our manufactures, which, on cutting through the trade with France, would be in the greatest demand throughout the whole of Italy. It was given up at the termination of the last war in ignorance, as may be presumed, of the great advantage which it affords in this respect. I need not suggest to you, sir, that if the measures on which I have thus slightly touched were carried into effect, it would, even should the enemy be disposed to disturb us, require a large portion of the force intended for the subjugation of Spain to be diverted from its purpose. If these measures were to be followed up by a flying naval expedition of trifling extent, and with comparatively only a handful of troops, the enemy might be held in check, or, at any rate, their plans elsewhere would be frustrated in part, and the remainder must become insignificant from perplexity and embarrassment. I submit to you, sir, that were it not for our naval superiority, and a few thousand ships were at Bonaparte's disposal, our coasts would not be safe. The vessels in our ports would be swept away, and very possibly the ports themselves laid in ashes. As we have at least physical powers and more honourable incitements than Bonaparte to aid our energies and direct our objects, we ought bravely to pursue all that he will dare to attempt. If, sir, these points should appear to interest you, and you should think it necessary to require of me further detail or information, I shall be happy to wait on you for that purpose at any time you may be pleased to name. I had intended to bring this subject before the House, but a variety of obvious reasons showed me the propriety of addressing you in the first instance. I have the honour, etc., Cochrane. The Right Honourable Charles Yorke. The letter ends. In reply to this letter, I was told by Mr. Yorke that the acting captain had been appointed to the Imperieuse for my accommodation, instead of Captain Duncan having been appointed from the necessity before mentioned. Mr. Yorke concluded his letter with a peremptory order for me to proceed to sea within a week. Admiralty, June 8th, 1810. My Lord, I had the honour this morning of receiving your Lordship's letter of yesterday, communicating your Lordship's opinions on various points of service connected with operations on the French coast, in the Bay as well as in the Mediterranean, which appear to be nearly of the same effect with those which I had the honour of hearing from your Lordship personally some days ago. I beg to return you my thanks for this communication of your sentiments, and have now to inform you that as your Lordship's ship the Imperieuse is nearly ready for sea and destined for the Mediterranean, and as the period of the session of the Parliament, during which your Lordship has been accommodated with an acting captain to command the frigate in your absence, has now nearly reached its close, I presume that it is your intention to join her without loss of time, and to proceed in her to join Sir Charles Cotton, who will no doubt employ your Lordship in the annoyance of the enemy, and in the protection of our allies, in the manner best suited to the exigencies of the service. I request that your Lordship will have the goodness to inform me as early as you can on what day next week it is your intention to join your ship, as His Majesty's service will not admit of her sailing being much longer postponed. I have the honour, etc., C. Yorke, Captain Lord Cochrane. The assertion that an acting captain had been appointed to the Imperieuse for my accommodation as a Member of Parliament was monstrous, for after the court-martial was ended, I begged to be allowed to join her, first, soon after the Walcheren expedition sailed, and again when it failed to satisfy the national expectations, even then offering to destroy the enemy's fleet as had been done in Aix Roads. I afterwards asked permission to view the siege of Flushing as a spectator only, and was refused, the refusal being fortunately still in my possession. Admiralty, October 11th, 1809. My dear Lord, I have mentioned your request to the Naval Lords at the Board, and find it cannot be complied with. I am, my dear Lord, your very faithful servant, Mulgrave. The Lord Cochrane. Notwithstanding Mr. Yorke's version of the reason of my absence from the Imperieuse, I determined to make one more effort for permission to carry out my plans for harassing the enemy's coast, and thereby preventing them from forwarding troops to Spain. My object was to get 2 or 3 frigates and a few troops under my command. Had I been able to accomplish this, what had been effected with the Imperieuse alone on the coast of Catalonia will be my excuse for saying that such a force would have been the most valuable aid to the British army in the Peninsula. Preferring, therefore, the service which I was desirous to render to my country to my own wounded feelings, I addressed another letter to Mr. Yorke. London, June 11th, 1810. Sir, in acknowledging the receipt of your letter of the 8th, I confess much embarrassment. The measures submitted to your judgment were, in my humble opinion, of great national importance. They had in view to weaken the hands of our enemy and strengthen our own. I therefore indulged in the hope that they would have received your countenance and support. It must have been apparent to you, sir, that I did not offer them on light grounds, nor without calculated certainty of success in the event of their prosecution. I flattered myself with the hope of being employed in the execution of a service which my previous observations would have enabled me to act with confidence. But although, sir, you are pleased to thank me for my communication, you pass over in silence the objects it embraced, and do away with even the expressions of courtesy bestowed on it, by asking, on what day in this week it was my intention to join my ship, as His Majesty's service would not admit of her sailing, being much longer postponed," thus leaving me to conclude that in taking the liberty of approaching you, I had trespassed too far, and that to prevent my importunities in future, you had deemed it advisable to order me to my ship, and further to join Sir Charles Cotton, who you signify "would no doubt employ me in the annoyance of the enemy and in the protection of our allies in the manner best suited to the exigencies of the service." I have throughout life been accustomed to do my duty to the utmost of my power, and my anxiety to render the performance of it acceptable to my country, whilst it stimulated me to inform myself on the best means for that purpose, may have led me to intrude on those with whom alone rests the power of encouraging my expectations. Yet I might have imagined that my motives would sufficiently plead my excuse. On the present occasion I had an additional inducement in addressing myself, in the first instance, to you, sir, instead of the House of Commons. I felt that I was paying the respect due to the First Lord of the Admiralty. It appears, however, that I have inadvertently offended, and am sorry for it, as the public interest may be injured by the steps I have taken. I should have been gratified had you done me the honour to call for details of the sketch which I laid before you, when I should have been happy to supply a properly digested plan, by which I propose to secure the objects here shadowed forth. Had this plan been brought under your consideration, I may venture to say that you would have directed it to be carried into execution, and I should have envied any person whom you might have honoured with the charge of it, however much I might have regretted the refusal to permit me to share in it. I should nevertheless have cheerfully rendered every information required of me, or that I might have conceived necessary. I have now no alternative than to submit to the wisdom of the House the propositions you have thought proper to reject, or rather suffer them to die away without further notice. I do not pride myself on the accuracy of my judgment, but may be allowed to understand those matters that come under my own immediate observation better than those who have had no experience in such kind of warfare. The capture of Los Medas by the French has confirmed me in the opinions I gave to Lord Mulgrave on my last reconnaissance of Isle d'Aix, and which I had the honour to state to you in my last. I again submit that a similar course pursued by His Majesty's Government towards France would distract the purposes of Bonaparte, and injure him infinitely more than any other step likely to be taken. The capture of even one of the islands enumerated in my former letter would be felt by him much as we should feel if a French force were to capture the Isle of Wight. In another part of your letter you say that I have been accommodated with an acting captain to command the Impérieuse frigate during my absence. I have to assure you that it was an accommodation I never solicited, and one which, far from conveying a favour, was extremely painful to my feelings, as it prevented my going on a service which I was extremely desirous of witnessing. I even made application to Lord Mulgrave for permission to be a spectator only of the scene of Flushing, so as to avail myself of the opportunity to acquire information about the Scheldt and its environs, but was refused, although others not connected with the service obtained leave to proceed there. In conclusion, I beg permission to say that I have yet some objects of moment to bring forward in Parliament, and that as there is no enterprise given to the Impérieuse, I have no wish that she should be detained for me one moment. I have the honour, etc., Cochrane. The Right Honourable Charles Yorke. P.S. Your letter, sir, is marked private, which I consider as applying solely to the destination of the Impérieuse, and of course shall be silent on that subject. End quote. Reader's note, letter ends. The reply of the First Lord that it was neither his duty nor inclination to enter into controversy with me, a proof how the interests of a nation may suffer from the political pique of a single man in power. Not an individual of the ministry considered me incapable of carrying into execution, even with an insignificant force, the plans foreshadowed, yet they were treated with contemptuous silence, and a command to proceed immediately on a subordinate service. Admiralty, June 12, 1810. My Lord, I have had the honour this morning of receiving your Lordship's letter of yesterday. As I do not conceive it either my public duty, so it is by no means my private inclination, to be drawn into any official controversy with your Lordship, either in your capacity of captain of a frigate in His Majesty's service, or of a member of Parliament. For this reason I must beg to decline replying to several parts of your Lordship's letter, in which you appear to have much misconceived my meaning, as expressed in my former letter, or to observe upon the turn and direction which your Lordship is pleased to endeavour to give to our correspondence. I have thought it proper to lay the two letters which I have received from your Lordship, being on points of service, before the Board of Admiralty for their consideration, and have only now to request to be distinctly informed whether or not it is your Lordship's intention to join your ship, the Impérieuse, now under orders for foreign service, and nearly ready for sea, as soon as Parliament shall be prorogued. I shall be much pleased to receive an answer in the affirmative, because I should then entertain hopes that your activity and gallantry might be made available for the public service. I shall be much concerned to receive an answer in the negative, because in that case I shall feel it to be my duty to consider it as your Lordship's wish to be superseded in the command of the Impérieuse. I am, my Lord, your most obedient servant, C. Yorke. Captain Lord Cochrane. Letter ends. A more unjust order from a lay lord of the Admiralty than this, to join the Impérieuse and proceed on foreign service, was never issued from the Admiralty. As a lay lord, he was wholly ignorant of naval affairs, but nevertheless refused to even listen to the advice of an experienced sea officer, who had at least seen some service, and was therefore capable of offering an opinion. In place of this, he ordered me to sea without the semblance of promotion in any shape, or even the offer of a larger ship. I had nevertheless received the warm thanks of Lord Collingwood for, as his Lordship expressed it, having with a single frigate stopped a French army from penetrating into eastern Spain. With the same inadequate means I had kept the whole coast of Languedoc in alarm, so as to prevent any combination of troops on the Spanish frontier, this voluntary service being executed in such a way as to induce Lord Collingwood to write to the Admiralty that, quote, "my resources seemed to have no end." End quote. Weighed down with fatigue and anxiety, I had returned home in the hope of relaxation, when the Admiralty, even before there had been time to pay off my ship, ordered me to prepare plans for destroying the French fleet in Aix Roads, Lord Gambier having plainly told them that if he made the attempt, quote, "it must be at their peril and not his." End quote. I prepared those plans with the addition of a novel element in naval warfare, and drove ashore the French fleet, which afterwards became a wreck, in spite of the want of proper co-operation on the part of the Admiral, who had hesitated to attack them. On my return to England, I had been offered by Lord Mulgrave the thanks of Parliament in conjunction with the Commander-in-Chief, but refused to couple my name with his. After all these services, for which I never received reward nor thanks, except the red ribbon of Bath from the hands of my sovereign, another First Lord ordered me to proceed to sea in a week, and that in a capacity as subordinate as the one occupied before any of these services had been performed. Nay, more, in spite of my pointing out to him how, with a trifling force, I could do far more than I had done, a proposition which he treated with contemptuous silence. There is nothing worse in the records of the Admiralty even at that period. Nevertheless, this ill treatment determined me not to shirk from my duty, though I was resolved that Mr. Yorke should neither get an affirmative nor a negative from me as to joining the frigate. If the command of the Impérieuse, under the orders of Sir Charles Cotton, were forced upon me, I would take it, but of this the Admiralty should be the judges, not I. Had Lord Collingwood lived to reach England, the Admiralty would not have ventured to thrust such a command upon me after my services of the previous 3 years, and my plans for future operations, which, as I have once or twice said, would have saved millions spent on prolonged strife in the Peninsula. In the vain hope that the national welfare would, on calm deliberation, rise superior to petty official spite, I again addressed Mr. Yorke as follows. Portman Square, June 11th, 1810. Sir, when I had the honour to present to you in writing those ideas that I had previously communicated verbally, it was far from my views, and contrary to my intention, to draw you into any unofficial correspondence. My solicitude to see the interests of my country promoted, and the power of the enemy reduced, were my only objects. I presumed that amidst the pressure of business, any hints thrown out in desultory conversation might escape your memory, but that committed to paper they would meet your consideration. This was my chief reason for addressing you by letter. As a member of Parliament, I never harboured a wish to intrude myself on your notice. I know that as a captain of a frigate I do not possess any consequence, and am conscious that I never assumed any. But, sir, I submit that if information promising essential benefit to the state is procured, the source from which it flows, however insignificant, is not of the least moment. With an impression which I must lament, sir, that you decline entering on those parts of my letter which alone prevailed with me to trouble you, I regret having done so. I am not in the habit of entreaty, but when the public service is to be advanced, entreaty becomes a duty. I trust, therefore, that you will pardon me if I repeat the hope that you will be pleased to regard the subject in a more favourable light, and examine the grounds and principles on which my opinions are founded. I feel convinced that any other officer, possessed of the knowledge necessary to form his judgment, will tell you that the measures I have proposed may, to a certainty and with great ease, be carried into execution, and that the enemy would in consequence be entirely crippled in his best resources. Had I been fortunate enough to receive the least encouragement from you, I should have brought forward other subjects than those noticed. Amongst these is one that has reference to the coast of Catalonia, where the maritime towns are occupied by troops of the enemy, just sufficient to keep the peasantry in awe and exact from them provisions. These, by possessing the open batteries the French convey coastways, in fishing boats and small craft, to their armies, which, from the scarcity of cattle, fodder, and the state of the roads, they could not obtain by any other means. The few troops stationed along the coast for these purposes might be seized and brought off with a trifling force, employed in the way I have indicated. As a proof of this, the aide-de-camp of General Lacau and a whole company were bought off by the marines and crew of the Impérieuse alone, to whom they surrendered, well knowing that had they left the battery, they would have been put to death in detail by the oppressed and irritated Spaniards. I am thankful, sir, for your kindness in laying my letters before the Lords Commissioners. The flattering terms in which you speak of my humble abilities also demand my acknowledgment, and whilst again tendering them to the service of my country, I beg permission to say that it is the first wish of my heart, and the highest aim of my ambition, to be actively employed in my profession, and that from former associations I prefer the Impérieuse to every other frigate in the navy. But as she is to proceed immediately on foreign service, I fear it is impossible for me to be in readiness to join her within the time specified. I have the honour, etc., Cochrane. The Right Honourable Charles Yorke. The letter ends. To this letter no reply was vouchsafed, and the Honourable Captain Duncan was confirmed in the command of the Impérieuse, which, in the following month, sailed to join Sir Charles Cotton off Toulon. Parliament being prorogued within a few days after the date of the last letter, I had no opportunity of bringing the subject before the House. On the publication of the first volume, it was said by some gentlemen of the press, when kindly reviewing its contents, that something more might have been said of that excellent and gallant Admiral, Lord Collingwood. This, I admit, would have been an easy task as regards the gossip of others relative to his lordship, but that is not the principle upon which this work is conducted, every incident therein having befallen myself personally. The fact was, that though I had the good fortune to serve under Lord Collingwood, it had never been my lot to serve with him. His lordship's first act on joining him was, as is narrated in the first volume, to appoint me as the successor of the officer in command for the squadron in the Ionian Islands. Shortly after my arrival at Corfu, I fell in, as has also been said in the first volume, during a cruise with a number of the enemy's vessels, bearing the commandant's licence to trade, and in spite of the licence captured and sent them to Malta for condemnation. The commandant, as shown in the first volume, hereupon denounced me to Lord Collingwood as an unfit person to command a squadron. I was immediately afterwards recalled, and, as the reader knows, was subsequently employed in harassing the French and Spanish coasts, without personal intercourse with his lordship, except when paying a flying visit to the fleet blockading Toulon. End of Chapter 30. Recording by Timothy Ferguson, Gold Coast, Australia. Chapter 31 of Autobiography of a Seaman, Volume 2, by Lord Thomas Cochrane. This LibriVox recording is in the public domain. Recording by Timothy Ferguson. Visit to the Admiralty Court at Malta. At the commencement of 1811, finding that, in place of anything being awarded to the Impérieuse for numerous prizes taken in the Mediterranean, the Maltese Admiralty Court had actually brought me in debt for vicious condemnation, I determined to go to Malta and insist on the fees and charges thereon being taxed according to the scale upon which the authority of the court in such matters was based. It is not my intention to enter generally into the nature of the demands made by the Maltese court, but rather to point out the manner in which, after realisation of the prize funds, costs were inflicted on the officers and crews of ships of war, till little or nothing was left for distribution amongst the captors. This will give a good idea of the practices which prevailed, preventing officers from harassing the coasting trade of the enemy, as the expenses of condemning small craft were ruinous, being for the most part the same as those charged by the court for the condemnation of large vessels. One of the customs of the court was as follows: to charge as fees 1/4 more than the fees of the High Court of Admiralty in England. This 1/4 was practically found to amount in some cases to 1/2, whilst any scale of charges by which the conduct of the court was guided remained inaccessible to the captors of prizes. The principal officer of the court in this department was a Mr. Jackson, who held the office of Marshal. This officer, however, though resident in Malta, performed his duty of Marshal by deputy, for the purpose of enabling him also to exercise the still more profitable office of Proctor, the duties of which he performed in person. The consequence was that every prize placed in his hands as Proctor had to pass through his hands as Marshal, whilst as Proctor it was further in his power to consult himself as Marshal as often as he pleased, and to any extent he pleased. The amount of self-consultation may be imagined. Right profitably did Mr. Proctor Jackson perform the duty of attending and consulting himself as Mr. Marshal Jackson. Subjoined is an extract from the charges of Proctor Jackson for attending himself as Marshal Jackson. Attending as Proctor in the registry and bespeaking of a motion, 2 crowns. Paid himself as Marshal for said motion under seal and extracting, 9 crowns. Copy of said motion for service, 2 crowns. Attending the Marshal himself, and feeing and instructing him to execute the same, 2 crowns. Paid the Marshal himself for service of said motion on himself, 2 crowns. Certificate of service on himself, 1 crown. Drawing and engrossing affidavit of service on himself, 2 crowns. Oath thereto and attendance on himself, 2 crowns, 2 reals, 3 scudos. By what ingenious process Marshal Jackson managed to administer the oath to himself as Proctor Jackson, I know not, but the above charges are actual copies from a bill in my possession, the said bill containing many hundred similar items besides. Some idea of its extent may be formed from the statement that, previously to a debate on the subject, I pasted together an exact copy, the different sheets of which the bill of charges was composed, formed them into a huge roll, and amidst the astonishment and laughter of the House of Commons, one day unrolled it along the floor of the House, where it reached from the Speaker's table to the bar. In addition to this multitude of fees and charges, the Marshal also claimed and received, as his own especial prerequisite, 1/2% on the inspection of prizes, 1% for their appraisement, and 2.5% on the sale. Thus, with 1/4 added, as aforesaid, made just 5% on all captures for the Marshal's prerequisite alone, irrespective of his other fees, which, being subjected to no check, were extended according to conscience, so that for every amount of prizes to the extent of £100,000, the Marshal's share as a matter of course would be £5,000, wholly irrespective of other fees of court, calculated on a similar scale. When numerous other officials had to be paid in like manner, also without check on their demands, it scarcely needs to be said that such prizes as were usually to be picked up by ships of war on the Mediterranean coast entailed positive loss on their captors, the result, as has been said, being that the officers avoided taking such prizes, and thus the enemy carried on his coasting operations with impunity. In other words, the most important object of war, that of starving out the enemy's coast garrisons, was suspended by the speculations of a colonial Admiralty court. Foiled in procuring redress in the House of Commons, where my statements were pooh-poohed by the representatives of the High Court of Admiralty as rash and without proof, I determined on procuring, by any means whatever, such proof as should not easily be set aside. Embarking, therefore, in my yacht Julie, one of the small French ships of war captured in Caldagues and afterwards purchased by me, as narrated in the first volume, I set sail for the Mediterranean. On arriving at Gibraltar, I considered it prudent to quit my yacht, fearing that so small a vessel might fall a prey to the French cruisers, and embarked on board a brig of war bound to Malta. My first demand upon the Admiralty Court on arriving at that place was the prize accounts of the Imperious and Speedy should be taxed according to the authorised table of fees. The revision was refused. Entering the court one day when the judge was not sitting, I again demanded the table of fees from Dr. Moncrieff, then Judge Advocate, who denied that he knew anything about them. As, by Act of Parliament, they ought to have been hung up in the court, I made careful search for them, but without success. Entering the judge's robing room unopposed, I there renewed the search, but with no better result, and was about to return tableless, when, having been directed to a private closet, I examined that also, and there, wafered up behind the door of the judge's retiring chamber, was the Admiralty Court table of fees, which I carefully took down, and re-entered the court in an act of folding up the paper, previously to putting it in my pocket. Dr. Moncrieff instantly saw what I had got, and rose from his seat with the intention of preventing my egress. Reminding him that I had no cause of quarrel with or complaint against him, I told him that guarding the judge's water-closet formed no part of his duties as Judge Advocate, and that it was rather his place to go and tell the judge that I had taken possession of a public document which ought to have been suspended in court, but the possession of which I had been denied. He seemed of the same opinion, and suffered me to depart with my prize, this, in half an hour afterwards, being placed in the possession of a brother officer who was going over to Sicily, and promised to take charge of it till my arrival in Girgenti. This rape of the table, as it was termed in a poem afterwards written on the occasion by my secretary and friend, Mr. William Jackson, caused great merriment, but the judge, Dr. Sewell, was furious, not perhaps so much at the invasion of his private closet, as at losing a document which, when laid before the House of Commons in connection with the fees actually charged, would infallibly betray the practices of the Maltese court. A peremptory demand was accordingly made of me for the restoration of the table, this being met by my declaration that it was not in my possession. The judge, believing this to be untrue, though in fact the tables were in Sicily, finally ordered me to be arrested for an insult to the court. The duty of arresting me devolved on my friend in duplicate Mr. Marshal, Mr. Proctor Jackson. I reminded him that the court was not sitting when the alleged offence was committed, and therefore it could be no insult. I further cautioned him that his holding the office of Proctor rendered that of Marshal illegal, and that if he dared to lay a finger on me, I would treat him as one without authority of any kind, so that he must take the consequences, which might be more serious to himself personally than he imagined. The Proctor Marshal, well knowing the illegality of his double office, which was not known, much less officially confirmed in England, prudently declined the risk, on which the judge ordered the Deputy Marshal, a man named Chapman, to arrest me. Upon this I informed Chapman that his appointment was illegal also, first as holding the office of Deputy Marshal to an illegally constituted person, and secondly from his also exercising the duplicate office of Deputy Auctioneer, the auctioneer being a sinecurist resident in London. So that if as Deputy Marshal combined with Deputy Auctioneer he ventured to arrest me, he too must put up with the consequences. ___. The Tory organs in England said that I had threatened to shoot Chapman. I need hardly say this was a gratuitous falsehood. With the exception of the silly duel narrated in the first volume, I have never either harmed, or intended to harm, a man in my life, otherwise than in action. The fact was, both these Maltese officials were illegally appointed, and they knew it. The officers and crews of ships of war present had had too much experience of their selfish conduct, and were as well pleased as myself at the success of my methods of keeping their natural enemies at bay, so that the pseudo-marshals were in reality frightened at their own warrants. This went on for many days, to the great amusement of the fleet in harbour, no one being willing to incur the risk of arresting me, though I walked about Malta as usual, Chapman following me like a shadow. At length the judge insisted on the Deputy Marshal Auctioneer arresting me at all risks, on pain of being himself committed to prison for neglect of carrying out the orders of the court. Finding himself in this dilemma, Chapman resigned his office. On this, a man named Stevens, unconnected with any other official position, was appointed in a proper manner, and all the legal formalities being carefully entered into, I no longer resisted, as that would have been a resistance to law. The manner in which the arrest was made showed a spirit of petty malevolence quite in keeping with the dispositions of men who are making enormous fortunes by plundering the officers and crews of His Majesty's ships of war. I was on visit to Percy Fraser, the Naval Commissioner, when the newly appointed Deputy Marshal, who had watched me in, was announced, and on entering told me he was come to arrest me. On demanding his credentials, I found them to be signed by Mr. Proctor Johnson, and as I wanted this proof of his acting as Marshal illegally, admitted myself satisfied with them. The Deputy Marshal then requested me to accompany him to an inn where I might remain on parole. I told him I would do nothing of the kind, but that if he took me anywhere it must be to the town gaol, to which place he then requested me to accompany him. My reply was, "No, I will be no party to an illegal imprisonment of myself. If you want me to go to gaol, you must carry me by force, for assuredly I will not walk." As the room was full of naval officers, all more or less victims of the iniquitous system pursued by the Maltese court, the scene caused some merriment. Finding me inflexible, the Vice-Admiralty official sent, first for a carriage, then for a piquet of Maltese soldiers, who carried me out of the room on the chair in which I had been sitting. I was then carefully deposited in the carriage and driven to the town gaol. The apartments assigned for my use were the best the place afforded, and were situated on the top story of the prison, the only material unpleasantness about them being that the windows were strongly barred. The gaoler, a simple worthy man, civilly inquired what I would please to order for dinner. My reply was, "Nothing," that, as he was no doubt aware, I had been placed there on an illegal warrant, and would not pay for so much as a crust, so that if I was starved to death, the Admiralty Court would have to answer for it. At this declaration the man stood aghast, and shortly after quitted the room. In about an hour he returned with an order from Mr. Marshal Jackson to a neighbouring hotel keeper to supply me with whatever I chose to order. Thus armed with carte blanche as to the cuisine, I ordered dinner for 6. Under strict injunctions that whatever was prized in Malta, as well in edibles as in wines, should be put upon the table. An intimation to the gaoler that he would be richer by the scraps, and to the hotel master to keep his counsel for the sake of the profits, had the desired effect, and that evening a better entertained party, naval officers, never dined within the walls of Malta gaol. This went on day after day, at what cost to the Admiralty Court I never learned nor inquired, but from the character of our entertainment, the bill when presented must have been almost as extensive as their own fees. All my friends in the squadron present at Malta were invited by turns, and assuredly had no wardroom fare. They appeared to enjoy themselves the more heartily as avenging their own wrongs at the expense of their plunderers. At length the Admiralty authorities thought it high time to decide what was to be done with me. It was now the beginning of March, and I had been incarcerated from the middle of February, without accusation or trial. It was evident that if I were imprisoned much longer, I might complain of being kept out of my place in Parliament, and what the electors of Westminster might say to this, or what the House of Commons itself might say, were questions seriously to be pondered by men whose titles to office were unconfirmed. They had at length discovered that I had committed no offence, beyond the fact of having been seen to fold up and put in my pocket a piece of dirty paper, but what that paper might be, or where it was, there was no evidence whatsoever. At length they hit upon a notable expedient for getting rid of me, that is, to get His Excellency the Governor to ask me to give up the table of fees. This I declined, telling His Excellency that as I had been incarcerated illegally, I would not quit the prison without trial. It was accordingly determined that I should be put on my trial, the puzzle being as to what offence I should be accused of. The plan, as I afterwards found, was to interrogate me, and thus to entrap me into becoming my own accuser. On the 2nd of March I was taken to the Court House, accompanied by the Naval Commissioner, Mr. Fraser, Captain Rowley, the naval officer in command, and nearly all the commanding officers in port. 2 clerks, one a German, the other a Maltese, were said to have deposed to "seeing a person whom they believed to be Lord Cochrane with a folded paper." On the strength of this evidence the following charge was made out, "that I had entered the registry of the Admiralty Court, and had there taken down the table of charges, that I had held up the same so as to cause it to be seen by the King's Advocate, Dr. Moncrieff, and had then put it in my pocket and walked away." This charge contained a wilful falsehood, that is, that the table of fees was hung in "the registry." the perversion of truth being proved by the remarks in Parliament of the King's Advocate, Sir John Nichols, on the authority of the Maltese Court, as follows: Lord Cochrane went to the courtroom of the Vice-Admiralty for the purpose of comparing the charges in his bills with the table of established fees, which, according to the Act of Parliament, should be suspended in some conspicuous part of the court. After looking for it in vain in the court and in the registry, whither he was first directed by His Majesty's Advocate, he was told that he might see it affixed on a door leading to the adjoining room. The table was certainly not in its place, but it was as certainly not concealed." Speech of Sir J. Nichols in the House of Commons, June 6th, 1811. It was equally false that the King's Advocate directed me where to look for the table of fees, the whole affair having taken place as narrated in this chapter. To this I replied that "there must be an error, for as the Act of Parliament ordered that the table of charges should be displayed in open court, it could not possibly have been the paper which I saw in the judge's water closet. That the paper showed by me to Dr. Moncrieff was folded up, so that he was necessarily ignorant of its purport or contents. Finally, I denied having taken down the table of charges, as established by Act of Parliament, from the court-room." After this reply, I demanded to be confronted by my accuser for the purpose of cross-examining him. This the judge would not allow, but said he should consider my denial in the light of a plea of "not guilty." He then put to me a series of interrogatories, for the purpose of getting me to incriminate myself, but to these I refused to reply in any way, merely repeating my assurance that His Honour must have made a mistake, it being highly improbable that the lost table of fees should have been hung anywhere but in open court, as the Act of Geo. 2 prescribed, that is, in an open, visible and accessible place, which His Honour's retiring closet was not. Dr. Sewell then admitted that the charges entered on the table of fees had not been ratified by the King in Council, and that he had therefore not caused them to be suspended in open court, according to the Act, on which declaration I protested against the whole proceedings as illegal. Finding that nothing could be done, the judge then asked me to go at large on bail. This I flatly refused, alleging myself to be determined to remain where I was, be the consequence what it might, till the case should be decided on its merits. At this unexpected declaration the court appeared to be taken aback, but as I refused to be bailed, the judge had no alternative but to remand me back to prison. As it may be useful to note the despotic practices of our foreign tribunals in those days, I will transcribe a portion of the judge's speech on this occasion, as correctly reported at the time. On my demanding to cross-examine the witnesses against me, Dr. Sewell said, "The present course was the one practised on these occasions. He would not allow any but a direct answer to the charge made, and if that contained no crime, he should himself be responsible." He then said that he must administer to Lord Cochrane certain interrogatories, and on Lord Cochrane persisting in demanding his accuser or accusers, in place of replying to the questions, the judge peremptorily required answers. In place of giving these, I denied the competence of the court to take cognizance of a criminal charge, asserting that it was not a court of record, and that on a pretended accusation made by witnesses who could not be produced, I had been arrested, imprisoned in the common gaol, and publicly criminated without being permitted to clear myself by being placed face to face with my accusers, etc., etc. On arriving there, my friends were of the opinion that the affair had been carried far enough, and that I should apologise for taking the table of charges, and send for it at Girgenti. To this counsel I refused to listen, as I wanted the tables for exhibition in the House of Commons, and would in no way compromise the matter. On this, the senior naval officer, Captain Rowley, said to me, "Lord Cochrane, you must not remain here. The seamen are getting savage, and if you are not out soon, they will pull the gaol down, which will get the naval force into a scrape. Have you any objection to making your escape?" "Not in the least," I replied, "and it may be done, but I will neither be bailed nor will I be set at liberty without a proper trial." In short, it was then arranged that my servant, Richard Carter, should bring me some files and a rope, and that I should cut through the iron bars of the window, and that when everything was in readiness, on the first favourable night, a boat should be manned at the sally-port, and that I should be taken across to Sicily to pick up the table of fees at Girgenti. Some 3 or 4 nights were occupied in cutting through the bars, the marks being concealed in the daytime by filling up the holes with a composition. When all was in readiness, my friends and I held our last symposium at the expense of the Admiralty Court. The gaoler was purposely made very tipsy, to which he was nothing loth, and about midnight, having first lowered my bedding into the streets, to be carried off by some seamen under the direction of my servant, I passed a double rope around an iron bar, let myself down from the 3-storey window, pulled the rope after me so that nothing might remain to excite suspicion, and bade adieu to the merriest prison in which a seaman was ever incarcerated. On arriving at the harbour, I found the Eagle's gig in readiness, and several brother officers assembled to take leave of me. The night was dark, with the sea smooth as glass, it being a dead calm. When pulling along the island, we came up with the English packet, which had sailed from Malta on the previous day, she having been since becalmed. As she was bound for Girgenti, to pick up passengers and letters from Naples, nothing could be more opportune, so dismissing the gig, I went on board, and was on my way to England, doubtless, before I was missed from my late involuntary domicile at Malta. I had thus a manifest advantage in those days of slow transit, that is, that of arriving in England a month before the news of my escape from Malta could be sent home by the authorities of the Admiralty Court. As I afterwards learned, nothing could exceed the chagrin of the Admiralty officials at having lost not only their table of charges, but their prisoner also. No one had the slightest suspicion that I had gone to sea, and that in a man-of-war's boat. Yet nothing could better show the iniquitous character of the Maltese Admiralty Court than the fact that my escape was planned in conjunction with several naval officers present in harbour, who lent me a boat and crew for the purpose, the whole matter being previously known to half the naval officers present with the squadron, and after my escape to not a few of the seamen, all of whom must have been highly amused at the diligent search made for me the next day throughout Valletta, but still more at the reward offered for those who aided me in escaping. Yet not a word transpired as to the direction I had taken, or the time occupied in searching for me on the island might have been turned to better account by an endeavour to intercept me at Gibraltar, where I remained long enough to dispose of my yacht, and amuse the garrison with a narrative of my adventures since I left the Rock 2 months before. End of chapter 31. Recording by Timothy Ferguson, Gold Coast, Australia. Chapter 32 of Autobiography of a Seaman, Volume 2, by Lord Thomas Cochrane. This LibriVox recording is in the public domain. Recording by Timothy Ferguson. Naval Legislation half a century ago. On my return from the Mediterranean, having no prospect of employment, I devoted myself assiduously in Parliament to the course I had marked out for myself, viz. the amelioration of the condition of the naval service, whether by originating such measures of my own accord, or assisting others who had the same object in view. At this period it was the custom to compel naval officers on foreign stations, in whatever part of the world located, to draw bills for their pay. The consequence was that the bills had to be sold at a discount, sometimes amounting to 35 and 40%, the whole of the loss falling on the officers negotiating the bills. A motion to place officers of the Navy upon the same footing as officers of the Army was made by Captain Bennett, and strenuously opposed by the First Lord of the Admiralty, Mr. Yorke, as an innovation on old rules and customs, which, once sanctioned, no one could tell where it might stop. Upon this I inquired, what greater difficulty there could be in paying officers of the Navy abroad than in paying officers of the Army. There were consuls at all foreign stations who could certify what the rate of exchange really was. Under the present system, to my own knowledge, officers on the Gibraltar station were 25%, or a fourth of their scanty pay, out of pocket, and it was with great difficulty that they could provide themselves with proper necessaries." The effect of these remarks was that Sir C. Pole moved as an amendment that a committee should be appointed to inquire into the state of the Navy generally, and this was seconded by Admiral Harvey. The debate having taken this turn gave me the opportunity of entering more minutely into particulars. I will transcribe my remarks from the reports of the time. "Lord Cochrane said an increase of pay to the seamen in the Navy would be of little advantage to them, so long as the present system continued. He had in his hands a list of ships of war in the East Indies. The Centurion had been there 11 years, the Rattlesnake 14 years, came home the other day with only one man of the first crew. The Fox frigate, under the command of his brother, had been there 15 years, the Sceptre 8 years, the Albatross 12, etc. not one farthing of pay had been given all that period to all those men. Had he made a calculation on the Fox frigate, and supposing only 100 of the men returned, there would be due to the crew £25,000, not including the officers. What became of these sums all the while? The interest ought to be accounted for to Government or to the seamen themselves. The Wilhelmina had been 10 years, the Russell 7 years, the Drake 6 years, of which the men would be exiles from England for ever, and another vessel 4 years. Nothing would be of greater service than the frequently changing the stations of ships, which might be done without any inconvenience, and even with much advantage to the East India Company's ships. The seamen, said Lord Cochrane, from the want of their pay, had no means of getting many necessaries of the utmost consequence to their health and comfort. They drew less prize money under the existing acts than formerly. He instanced a vessel, the proceeds of which came to £355. By the present mode of distribution, the seaman would receive 13s. 5½d, while by the old mode he would have received 15s. 1½d. From the officer's share there was deducted in all 75 per cent, allowing only 10 per cent for the prize courts. The minister had exultingly asked what had become of the commerce of France, but he would undertake to show him, before he was 48 hours on the coast of France, at least 200 sail of the enemy's vessels. If they were to pay more liberally the judges of the Admiralty courts, and operate a proper reformation in them, he would undertake to say that they might score off at least 1/3 of the present ships of the navy. Ministers said there were no vessels on the coast of France, but he said there were, and if they would go with him, he would show them how they could be got at. He rather thought that the inattention of the government to the profligate waste of the public money arose from their own unwillingness to believe anything contrary to their own crude notions on these subjects. He stated, and he begged the House to attend to it, for it was as important as the subject of Mrs. Clarke, that in the reign of James II. The pay of a captain of a first rate was £80 more than at present. King William, when he came over with his Dutch troops, whom he was much more anxious to attend to than he was to attend to his subjects here, took up his pen and cut off 1/2 of the pay. So much for foreign troops, but still, taking the advance of prices into view, King William left it far better than it is now. His lordship then again called the attention of the House to the extent to which the French coasting trade was carried on, and observed that it could not be checked unless greater encouragement were given to the captains. If he commanded a ship on the French coast, by keeping at a good distance he might go to sleep, but in order to intercept those coasting vessels, the captain must be on deck watching all night. It was impossible officers would do this merely to put money into the pockets of those who practised in the Admiralty courts. Mr. Yorke said that at this late period of the session it would be impossible to enter upon a subject of such detail. As to ships being detained so long upon foreign and distant stations, it was much to be regretted, but it was often unavoidable. These were singular reasons for not entertaining a subject of such importance. According to Mr. Yorke, it was too late in the session to conduct the war successfully, whilst the other evil complained of could only be regretted. For want of a better argument, I was accused of insinuating that without the chance of prize money, officers would lose a great incentive to duty. I only took human nature as I found it, and it is not in human nature to exercise unremitting vigilance and exertion without the hope of reward, much less that unceasing vigilance by night as well as day, requiring almost constant presence on deck to intercept an enemy's coasting trade, carried on almost solely in the night, when the enemy felt secure of our vessels being run out to sea from want of a motive to remain in shore. On the 6th of June I entered on the subject of the Maltese Court of Admiralty. As the debate in the House is sufficiently explicit, previous comment is unnecessary. Vice Admiralty Court of Malta. Lord Cochrane rose to make the motion of which he had given notice. The noble lord began by stating that he had before had occasion to trouble the House on this subject, but he then failed in his attempt to obtain justice on the ground that there was not sufficient evidence of the facts stated to warrant the House in entertaining his motion. He had since, however, personally been at Malta, and had procured such a chain of evidence that, if the House should now be pleased to entertain his motion, he had no doubt but that he should be able to lay before them such a connected string of evidence of flagrant abuses in the Vice-Admiralty Court at that island as would astonish all who heard it. He would undertake to prove that if the Court of Admiralty at home would do their duty, 1/3 of the naval force now employed in the Mediterranean would be sufficient for all purposes for which it was employed there, and that a saving might be made in the naval service alone of at least 5 millions sterling a year. If the committee for which he moved last year had been granted, the evidence to prove this might now have been before the House." There was no question at the time, and many naval officers are yet living to confirm the assertion, that the rapacity of the Admiralty Courts and their extravagant charges for adjudication and condemning prizes did prevent the interception and capture of the majority of the numerous small vessels employed in the coasting trade of the enemy, this forming to him the most vital consideration as the means of provisioning his armies. At the commencement of the war, the capture of large vessels coming from distant parts with valuable cargoes gave so much prize money as to render both officers and crews careless about little exertion, more or less, but when the enemy's foreign trade was destroyed, nothing remained to be looked after but small craft, and as the Admiralty Court charges had increased in an inverse ratio to the worthlessness of small craft, few would run the risk of looking after them with the certainty of small gain, and the more than probability of being brought in debt for their pains. The consequence was, that little or no destruction was offered to the enemy's coasting trade, which, important as it was to him for subsistence, ought to have been far more so to us, as its destruction would have deprived him of the means of subsistence. Between the years 1803 and 1807, the naval establishment was increased from 200 to 600 vessels of war, notwithstanding which the coasting commerce of the enemy still went on, and it should have been obvious that when the navy increased to upwards of 1,000 ships, nothing more was done. The amusement of cutting out coasting vessels, when under the protection of batteries, ceased to operate as an incentive. The logs of frigates showed that their commanders avoided the risk of keeping their ships in contiguity with the shore at night, and secured a good night's rest for their men by running into the offing. Hence the enemy's coasting convoys proceeded by night, and in the day ran into some port or other place of protection. The result in the frigate's daily journal, "employed as usual," was no less true than comprehensive. For telling such truths as these, an outcry was raised against me for depreciating the character of officers. The case was my own. I took prizes in the Mediterranean and elsewhere by dozens, for which neither my officers nor crews got anything, the proceeds being swallowed up by the Admiralty Courts. I then turned to harassing the coast armies and forts of the enemy without hope of reward, deeming this kind of employment the most honourable to myself and the most advantageous to my country. So far from pointing out the effect on the mind of officers in general being a reflection of their honour, it was only creditable to their common sense. They could not reasonably be expected to sacrifice their rest and that of their crews, or to run their ships into danger and themselves into debt, to the exclusive emolument of the Courts of Admiralty. I have no hesitation in asserting that had the Ministry diminished the Navy by 1/2, and given the whole cost of the other half to the Admiralty Court officials in lieu of their charges, the remaining ships would of themselves have turned the course of the war, and their commanders would have reaped fortunes. In February 1811, I pointed out to the House of Commons the monstrous fact that 107 ships of the line were in commission to watch 23. Hansard, Vol. 15. These remarks will enable the naval reader to comprehend what follows. They are not intended so much for a history of past maladministration as a beacon for the future. "The noble lord then read a letter from a captain of a vessel at the Cape of Good Hope, complaining that the officers of ships of war were so pillaged by those of the Vice-Admiralty Courts, that he wished to know how they could be relieved, whether they could be allowed the liberty to send their prizes home, and how far the jurisdiction of the Vice-Admiralty Court extended, for that the charges of that court were so exorbitant it required the whole amount of the value of a good prize to satisfy them. In the case of one vessel that was sold for 11,000 rupees, the charges amounted to more than 10,000. This was the case in Penang, Malacca, and other places, as well as at the Cape." He would not, however, wish to dwell on this, but put it to the feelings of the House whether naval officers had any stimulus to do even their duty, when the prizes they took would not pay the fees of the Vice Admiralty Courts merely for condemning them. It had been stated the other day at some meeting or dinner by a very grave personage, the Lord Chancellor, that the ships of France were only to be found in our ports. If that statement were believed by ministers, he should be glad to know why we at this moment kept up 140 sail of the line, and frigates and sloops of war in proportion to that number." What follows is very curious, as establishing the magnitude of the charges of adjudication in the Vice Admiralty Courts. The bill for the condemnation of the King George privateer, the first vessel taken by the Imperieuse, had brought me 600 crowns in debt, and was of such magnitude that I had an exact copy made of it and pasted continuously together. The result will be gathered from what follows. "His lordship then produced the copy of a proctor's bill in the island of Malta, which he said measured 6 fathoms and a quarter, and contained many curious charges. The unrolling this copy caused a general laugh, as it appeared long enough to reach from one end of the house to the other." This proctor, the noble lord said, acted in the double capacity of proctor and marshal, and in the former capacity feed himself for consulting and instructing himself as counsel, jury, and judge, which he himself represented in the character of marshal, so that all those fees were for himself in the one character, and paid to the same himself in the other. He then read several of the fees, which ran thus: for attending the marshal himself, 2 crowns, 2 scudi, and 2 reals, and so on in several other capacities in which he attended, consulted, and instructed himself, were charged several fees to the same amount. An honourable member, not then in the House, had last year opposed the motion he had brought forward for a committee to inquire into this subject, but on seeing these articles of his own proctor's bill, his lordship flattered himself that the honourable member would now join in the support of the present motion. The noble lord said he had produced the copy of the bill to show the length of it. He then showed the original, and to show the equity and moderation of the Vice Admiralty Court, he read one article where, on the taxation of a bill, the court, for deducting 50 crowns, charged 35 crowns for the trouble in doing it. A vessel was valued at 8,608 crowns, the marshal received 1% for delivering her, and in the end the net proceeds amounted to no more than 1,900 crowns out of 8,608. All the rest had been embezzled and swallowed up in the prize court. He was sorry, he said, to trespass on the time of the House on a day when another matter of importance was come before them. He pledged himself, however, that no subject could be introduced more highly deserving their serious attention and consideration." I am not sure, by late treaties, prize money in future wars is not in effect abolished, though how treaties can exist during war I am not aware. If this be so, or anything like the spirit of such an arrangement, certain I am that the prestige of our navy is gone till the old system is restored. The United States Government has, I am told, had the good sense not to conform to any arrangement of the kind. If my life be longer spared, I may, in a future volume, revert to this subject. However, even as the matter now stands, something must be captured, and I would suggest as a remedy for this enormous Admiralty Court evil, to assimilate the regulations of those courts to the courts of law. Pay the judges and officials as other judges and officials are paid. Permit officers of the Navy to choose their own proctors, as suitors in other courts choose their own attorneys. It is not honourable for the Government, nor just to those serving under its authority, to compel officers to place the litigation of all prizes, even detained neutrals, in the hands of one individual who, under the name of proctor, may have hundreds of causes in hand at the same time. The detention of a neutral may compromise a captain's fortune in the event of an unfavourable or hurried decision, for in such cases the liability to damages falls exclusively on captains, the admirals and crews having no responsibility. For my own part, as it was neither my bounden public duty nor safe to my personal interests to interfere with neutrals, I avoided their detention, however apparently flagrant the violation of their nominal neutrality. "He, Lord C., would not trouble them with anything concerning himself, because he trusted he had a remedy elsewhere. The noble lord then stated that altering or regulating the fees established by the king in council for the island of Malta was contrary to Act of Parliament, that when he went to Malta 5 years ago he found the fees very exorbitant, and in order to prove to the House that the fees demanded now were fees which had been altered since the table of fees was sent out, the noble lord mentioned an instance of 13 small vessels which had been taken by the gallant Captain Brenton, who lately lost his arm in the service, being brought into the Vice-Admiralty Court for condemnation. The charge made for doing that act, which must be done before the prizes could be sold, was 3,767 crowns, but on a severe remonstrance from Captain Brenton, the judge deducted 3,504 crowns, and was glad to accept 263 crowns instead of 3,767, rather than have a noise made about it in England. He, Lord C., could assure the House that the subject was well worthy their attention, and, if the Lords of the Admiralty knew all the circumstances, he was confident that instead of opposing they would support his motion. He meant to accuse the Judge, the Marshal, and the Registrar of the Court with abuse of their offices, and concluded by moving, that there be laid before this House, 1. Copy of the commission or appointment of Dr. Sewell to officiate as Judge of the Vice-Admiralty Court of Malta. 2. Copy of the commission or appointment of Mr. John Jackson to the office of Marshal to the said court. 3. List of the proctors officiating in the said court, with the dates of their admission. 4. Copy of the appointment of Mr. Locker to execute the office of Registrar of the said court. 5. Copies of the several deputations given by the Registrar and the Marshal of the said court to their respective deputies to the end of February last, together with the notifications of those appointments to the High Court of Admiralty, or the Board of Admiralty, with the reasons assigned for such nominations or appointments. 6. Copies of any representations made to the Lords Commissioners of the Admiralty regarding the incompatibility of the situations of Proctor and Marshal united at Malta in the person of Mr. Jackson, and the consequent correspondence with the Court of Admiralty, or the Judge of the Court of Admiralty, on that subject. 7. Copy of any table of fees established by His Majesty in Council, and furnished to the Courts of Vice-Admiralty under the Act of 45 Geo. 3 C72, or any other Act of Parliament. 8. Copy of the table of fees by which the charges were made on the suitors in the Court at Malta. 9. Copy of the authority by virtue of which judges of the Vice-Admiralty Courts are empowered to alter or amend the table aforesaid, or to make any other table of fees, to regulate the charges incurred by the suitors in that court. 10. Copies of official demands made, or official correspondence which has taken place between the Judge of the Vice-Admiralty Court at Gibraltar, or at Malta, and the High Court of Admiralty, or the Judge of the High Court of Admiralty, requiring or regarding a table of fees, to be sent for the guidance of those courts, or either of them. 11. List of the number of vessels that have been prosecuted in the Court of Vice-Admiralty at Malta, and which have been liberated on payment of costs and damages or otherwise. 12. Copies of the appointments which Wood, Esquire, late Secretary to Lord Viscount Castlereagh, holds in the island of Malta. Continues. Mr. Yorke said that he did not mean to object to the production of the greater part of the papers moved for by the noble lord. His motion seemed to charge with extortion the persons connected with the Admiralty Court at Malta, and certainly the prima facie appeared to justify it, and some reform might be necessary in some of the departments, which induced him to acquiesce in the general features of the noble lord's motion. But some difficulty might exist in the production of one or two of the papers he moved for, as they possibly implicated some private correspondence, which it would be improper to produce. Many of the papers moved for must be brought from Malta, and therefore it would be impossible that the investigation could take place this session, and he hoped the noble lord would, on examination, if he found just ground, persevere in his motion, as it was certainly highly improper for the dignity of the House and the due management of the affairs of the country that a remedy should not be applied to those evils if they existed. Sir John Nicol, King's Advocate, while he admitted with the First Lord of the Admiralty that the case, as it stood at present, called for an inquiry, thought proper at the same time to state, in the absence of his learned friend, Sir W. Scott, that he had no control over the Vice-Admiralty Court of Malta in matters of prize. The appeal lay to the King in Council, and his learned friend was not in the smallest degree responsible. If the abuses charged by the noble lord existed, they ought to be corrected. But his doubt was as to the means. His Majesty in Council had the authority to correct abuses as to fees, etc., but no application, so far as he knew, had been made in that quarter. It was the fashion now to come to Parliament in such cases. As to the character of the judge of the Prize Court of Malta, he, not having been in the habit of corresponding with him, could not undertake to speak positively to that point. Having practised with him for some time at the same bar, he had every reason to believe that he was a man of talent and integrity, and that the noble lord knew he was not wanting in spirit to execute what he thought right. He was absent, and he was a judge, and no prejudices ought to be admitted against him till he had an opportunity of being heard in his defence. He hoped the noble lord was under a misapprehension. The regulation of fees had been probably left to the judge, because he himself could hardly have any interest in augmenting them. They could hardly fall below £2,000, to which sum only he was entitled out of them. From the failure of the noble lord in substantiating charges made by him on former occasions, it would be fairly inferred that the accusations preferred by him might possibly turn out to be unfounded. Sir Francis Burdett said that he should have made no observation on the subject, after having seconded the motion, but from what had fallen from the right honourable gentleman who had just sat down, that his noble colleague had not substantiated the charges he formerly brought forward. The reason of this was obvious. The noble lord had never had an opportunity given to him to substantiate his charges. He had pledged himself to prove them at the bar of the House, but his motion for a committee was negative. Mr. Rose said that when abuses in the Vice-Admiralty courts abroad were detected, measures were always taken to rectify them, and proceedings were at present pending against 3 of those courts, but he defied the noble lord to point out any impropriety in the Admiralty courts at home. After the minutest investigation, he could find not a single ground of complaint against the officers of that court. The proctor for the Navy was remarkable for his attention and integrity, and his charges were more moderate than those of any other proctor. The interests of the officers of the Navy were as well attended to as those of any individual. The noble lord had failed in 2 charges on former occasions. He had brought charges against the Admiralty Court and against the Government for the treatment of prisoners of war. Both were utterly unfounded. The prisoners, as had been found on inquiry, were even more healthy than our militia regiments. Mr. Littleton said the right honourable gentleman who had spoken last allowed abuses existed. He did not know whether it was so or not, but he knew several officers of the Navy of the highest character who complained loudly that there were, and this was, in his opinion, good ground for granting the present motion. Lord Cochrane stated that, having complained to the Admiralty here of a grievance in being obliged to submit to exorbitant charges in the prosecution of a prize case at Malta, the opinions of the Attorney and Solicitor General and other lawyers had been put into his hands, purporting that his plan was to apply to the Judge of Malta. He wrote to the Judge accordingly, who referred him to the proctor, as he did not choose to enter into private correspondence with suitors in causes before him. He then wrote to the proctor, who sent for answer that it was unprecedented to demand a bill to be taxed that had been paid so long ago as 1808, so that he thought his having got the money a good reason for not parting with it. He then wrote to the judge, but got no answer, and this was the redress he got in the quarter where the Crown officers had advised him to apply. The noble lord further observed that, in opposition to the Act of the 45th of the King, the judge at Malta had not only established but altered the table of fees. An allusion was made to the spirited conduct of the judge, but he had affidavits of Captain Maxwell and others who were present, and the judge had admitted that he had no proof of the crime for which he, Lord C., had been sent to gaol. Against him, however, he would proceed in another way, unless he should find it necessary to call for the interference of the House to bring this judge home. He had consulted lawyers, and understood that he could not proceed against him till he came to this country. As to his former charges, he had been denied the opportunity of proving them. He concluded by repeating his charges of extortion, etc., against the judge and marshal. Mr. Whitbread said that if the official correspondence did not clear up the case, he would move for further papers if no one else did. Some alterations were then made in the motion in consequence of a difference of opinion as to the construction of the 45th of the King, relative to the establishment of tables of fees in the prize courts, after which they were all carried. Notwithstanding the admission of the First Lord of the Admiralty that the papers were necessary and that they were produced, it is scarcely creditable that the Government subsequently refused to act in the matter, thus turning a deaf ear to proofs that the enactments of the legislature were defeated by the rapacity of distant Admiralty courts, which continued to impound without scruple the rewards which the legislature had decreed for effective exertion. The naval reader who may wish to know more respecting the extortionate fees of these courts may refer generally to Captain Brenton's Life of Lord St. Vincent. I will extract one passage. He says, Volume 2, page 166, quote, "Lord Cochrane made a statement of some facts to this effect in the House of Commons, but he might have gone much further. The proctor's bill for a prize taken by the Spartan, when my brother commanded her, was £1,025, which, when refused payment and taxed, was reduced to £285." Captain Brenton thought I might have gone much further. So I might, but with as little effect. Even the facts I did state were impudently denied or shamelessly defended. On the 14th of June, an attack was made upon me by the Secretary of the Treasury on account of some remarks which I had deemed it my duty to make on the condition of the French prisoners at Dartmoor. In consequence of circumstances which had come to my knowledge, I visited that prison and was refused admittance the moment my name was announced. This did not, however, prevent my surveying the prison from an eminence on the exterior. This cursory inspection confirmed the information I had received. Quote, "Mr. Rose observed that it would appear from these documents that the total number of French prisoners remaining in England amounted to 45,939, and that the returns of the sick were 321. The number on parole were 2,710, and the sick 165. This statement, he conceived, would be a sufficient answer to the imputations of negligence upon the part of the Government, which had been thrown out by our noble lord." Lord Cochrane referred to the manner in which he had been reproached by Mr. Rose's pointed address, and thought it incumbent upon him, considering the repeated assertions of that honourable member that he was unable to prove facts which he had stated to the House, to justify his conduct in having given notice of a motion relative to the prison in Dartmoor, but in which he did not persevere for reasons very different from those assigned by the right honourable gentleman. His lordship had never asserted that which he could not establish. The time that had elapsed would sufficiently evidence his reluctance to bring the matter to the knowledge of the public, fearing that a disclosure might add to the misfortunes of his countrymen in France. Having received many letters stating the condition of the prisoners of war at Dartmoor to be truly deplorable, he determined to investigate the subject, and having had occasion to go to Exeter, he proceeded to Launceston and other depots, where he obtained the intelligence, and being satisfied that the complaints had some foundation, he went to Dartmoor, but was refused admittance, even in his capacity as a Member of Parliament (a laugh). Though members might laugh, he thought members of Parliament should be entitled to admission there, or to any other prison in the kingdom. Having contributed to place many individuals there, he applied for permission to see the interior, but was refused leave, except to look through a grating into the outer courtyard. He found the climate of the prison accurately and faithfully described, and he was the more anxious to see the interior owing to the refusal directly given him. He inquired the reason for building a depot in such a barren, elevated, and extraordinary situation, and was told it was for the purpose of attracting inhabitants. He proceeded to Plymouth, where he obtained a plan of the prison, which fully corroborated one complaint, that the health of the prisoners had suffered by exposure to heavy rains, while standing in an open space for several hours, receiving provisions issued at a single door, the cooking room being several hundred feet from the prison, which then contained 6,000 prisoners, divided into messes of 6. Consequently, 1,000 were soaked through in the morning attending for their breakfast, and 1,000 more at dinner. Thus a third were constantly wet, without a change of clothes. He was told, however, that they gambled or sold them. On a second visit to Dartmoor, his lordship, being again refused admittance, began to explore the exterior, and found, by a very peculiar coincidence, that the manure from this prison had been placed on the only spot in Devon where the stercoraceous matter of the depot could descend on a neighbouring and elevated estate belonging to the Secretary of His Royal Highness the Prince Regent, Mr. Tyrwhitt. Had such a circumstance happened in the island of Walcheren to an estate of the Secretary of Louis Napoleon, he would not have been surprised. The prison of Dartmoor was built in the most inclement part of all England, on top of the highest mountain in Devonshire, involved in perpetual rains and eternal fog. That the prison was not built there on a principle of economy might be seen by inspecting the contracts for provisions, coals, and necessaries furnished at Dartmoor and at Plymouth. He thought he calculated a difference of more than £7,000 a year on the provisions alone. It might be very proper, he imagined, that prisoners should not be collected in great numbers at Plymouth, but he asserted that Dartmoor Depot ought not to have been placed upon the top of the highest and most barren range of mountains in Devonshire, where it is involved in constant fog and deluged with perpetual rain. He had relinquished his intention of entering into the matter because he received assurances that the situation of the prisoners would be immediately attended to. He would abstain from remarking upon the manner in which Mr. Rose had taken him by surprise, and wrested from him those facts in his own defence. Had he brought the matter forward voluntarily, his lordship would have cleared the house to prevent publicity." Captain Brenton, in his Life of Lord St. Vincent, when speaking of the treatment of our prisoners of war, bore testimony to the truth of my representations, which Mr. Rose had so emphatically denied. "The charge of sick and wounded prisoners of war fell into the hands of a set of villains, whose seared consciences were proof against the silent but eloquent pleading of their fellow creatures, sick and imprisoned for no crime, in a foreign land, far away from their friends and relations." Volume 2, page 165. No one supposed the government to be guilty of the matters complained of, but they refused to inquire into the conduct of those who were, thereby protecting them in their iniquity. I saw at Dartmoor old and recently mutilated bulls, covered with dust and gore, driven along the road towards the prison, leaving tracks of blood behind. Thus the contract for supplying the prisoners with ox beef was fulfilled by some partisan of the government, who had sublet his contract to a Devon butcher. It was not always in those days that a contract was given to a tradesman who fulfilled it. On the 18th of July I brought forward a motion on the subject of my arrest at Malta. Conduct of the Vice Admiralty Court at Malta. Arrest of Lord Cochrane. Lord Cochrane rose and said, "Sir, the delay that has taken place since my return to England, and the legal authorities that I have consulted, will, I trust, evidence that I trespass on your attention with reluctance, relative to the conduct of the Judge and members of the Court of Vice Admiralty at Malta, partly from a desire to avoid the possibility of private motives being imputed to me, but chiefly from a conviction that Parliament should not interfere in matters cognizable in the courts of justice. However far, under the last impression, I am warranted in calling upon this House to exercise an authority in the present instance, will appear by the opinions of Sir A. Piggott, Mr. Holyrood, Mr. Leach, and of another learned gentleman who is not now in his place." Process of the courts, says Sir A. Piggott, does not extend to Malta. There is no mode, whilst they are abroad, to compel appearance to actions here. The answers of the other learned gentlemen being the same in substance, I need not detain you by reading them. 3 years have passed since I memorialised the Admiralty on this subject. It cannot therefore be said that I have acted with precipitation. Indeed, I have had time enough to reflect, and I do assure you that I am fully aware of the responsibility which I shall incur if I fail in establishing whatever accusations I bring against a judge presiding in one of His Majesty's courts, and against those acting under his authority. But furnished as I am with original documents, having the signatures of the judge and members of the court, I am not inclined to shrink from the task of proving their violation of the acts on your table, especially of the 37th, 38th, 39th, and 41st sections of the 45th of His present Majesty, C-72. The first of which empowers the King and Council alone to make or alter a table of fees to regulate the charges in the Courts of Vice Admiralty. And yet the members of the Court of Malta fabricated one for themselves, which the judge subsequently altered by affixing a note in his own hand, abolishing the table in toto except by reference to certain unascertained charges made in a distant court, which were not set forth. This note is as follows. Reader's note, quote within the quote. At a meeting of all the members of the court shortly after its arrival, for the purpose of setting what should be considered as reasonable fees, it was agreed that in no instance they should exceed the proportion of 1/3 more than those paid for similar services in the High Court of Admiralty in England. Signed, J. Sewell, reader's note, quote within a quote ends, who thus assumed the authority of the King and Council in open violation of the 37th, and in contempt and defiance of the penalties enacted by the 38th and 39th sections, which declare that receiving or taking any fee or fees beyond those specified in the table aforesaid, that is, in the table authorised by the King and Council, shall be punished by the loss of office, and further, demanding or receiving any sum or sums of money other than the fees aforesaid, shall be deemed and taken to be extortion and a misdemeanour at law, and shall be punished under and by virtue of this Act. Words cannot convey a more direct prohibition, and yet I hold in my hand demonstration of an opposite line of conduct being pursued by the court. This is not all. The law directs that the table of fees, authorised as aforesaid, shall be suspended in some conspicuous part of the court, in which the several judges of the Vice Admiralty Court shall hold their courts. At Malta, however, it was concealed first during 5 years in a drawer, and when taken therefrom in consequence of loud complaints on the subject of their charges, it was affixed not in some conspicuous part of the court, not in the court at all, but on the door of a private room behind the registry, where suitors could have no access to it. Sir, the fabricating, altering, and concealing of the table of fees is perhaps the least profligate part of their conduct. What will the House think when they find that John Jackson, the Marshal, who, to the knowledge of the judge, acts also as proctor in defiance of the law, is in the constant habit of charging his clients of the Navy for attending, feeing, consulting, instructing, and admonishing himself, and this in the very teeth of the 41st section, which enacts that no registrar or deputy registrar, marshal or deputy marshal, of or belonging to any of His Majesty's Courts of Vice Admiralty, shall either directly or indirectly, or himself or themselves, or by any agent or agents, or any person or persons whomsoever, act or be concerned in any manner whatsoever, either as an advocate or proctor. Mr. Jackson's charges are so ingenious that I must beg leave to read a few of them. Attending in the registry and bespeaking a motion, 2 crowns. Paid for the said motion under seal and extracting, 9 crowns. Copy of the said motion for service, 2 crowns. Attending the Marshal, himself observe, and instructing him to serve the same, 2 crowns. Paid the Marshal for service of said motion, 2 crowns. Certificate of service, 1 crown. Drawing and engrossing an affidavit of service, 2 crowns. Oath thereto and attendance, 2 crowns, 2 reals, and 3 scudi. How exact! 10 shillings and 2 3 farthings for an oath that he had attended on himself with a monition. One of these bills was taxed by the Deputy Registrar, who admitted these iniquitous charges. Yes, sir, they were allowed and admitted by Stevens, the Deputy Registrar, who treats his friends with Burgundy and champagne, out of the proceeds of captures made by the Navy, from which fund John Locker, the Sinecure Registrar, like the Sinecure Registrar at home, also derives his unmerited emoluments. I ask, is it fit that the reward granted by His Majesty and the Legislature to the Navy for the toil and risk which they undergo in making captures from the enemy should be thus appropriated? That I had the right to demand the taxation of such a bill as that which I have shown, there can be no doubt. Even if I could not produce the opinion of His Majesty's Attorney General to that effect, yes, the opinion of Sir V. Gibbs, and of the Solicitor General, signed also Charles Robinson, William Battine, T. Jarvis, to all of whom the memorial which I presented to the Admiralty was referred in April 1809, the expenses, say these learned gentlemen, in this case do not appear to have been brought to the knowledge of the court, so as to have given the judge an opportunity of exercising his judgment upon them. That would be the proper mode of redress for grievances of this description. Thus instructed, I addressed the judge on my return to Malta in February last, soliciting that he would be pleased to direct my bill to be taxed, to which he returned the following answer, addressed on His Majesty's service. Reader's note, quote within a quote. My Lord, in reply to your letter of yesterday's date, I beg leave to refer you to your proctor for the information you are so desirous of, it not being the practice of the Vice-Admiralty Court here, any more than the Court of the King's Bench in England, to enter into private correspondence with suitors on the subject of their suits, or of any matters connected with them. Signed, J. Sewell. It appeared extraordinary that I should be referred to the person complained of as judge in his own cause. Still, however, in compliance with Dr. Sewell's advice, I directed my agent to make the application, and the following, as might have been anticipated, was the ingenious gentleman's reply. Sir, my bill in this case, having been delivered to you so long ago as the 8th of August 1808, and having been paid by you soon after, I was a good deal surprised at your note received yesterday informing me that Lord Cochrane wishes to have the said bill taxed, and therefore I beg that you will appraise his lordship that it is a thing quite unprecedented to tax a bill which is paid. I should have supposed that the advice I gave his lordship not to proceed in this cause would have exempted me from the suspicion of having made unwarrantable charges. Signed, John Jackson. As the unwarrantableness of the charges did not rest upon suspicion, I wrote to Mr. Jackson myself, who answered, I humbly conceive that your lordship is not now entitled to demand a copy of your account, and therefore I beg that you will excuse me from complying with such demand. I next required him to submit my account for taxation. This he also declined as follows. My Lord, in reply to your letter of this day, I have to inform you that I cannot consent to open any account that was closed 2 years ago, and that is my only objection to my bill in the cause of King George being taxed, which I hope your lordship, on reflection, will see to be a reasonable objection. I confess I did not consider the lapse of 2 years to be any objection at all, particularly as I was absent from Malta when the bill was paid, and no earlier opportunity had offered to call for a revision of the charges. For this reason, and fortified with the opinion of the learned gentleman opposite, Sir V. Gibbs, about a month afterwards, I again addressed Dr. Sewell on the subject, who, so far from exercising his judgment on the Marshal's iniquitous bill of costs, did not condescend to take the slightest notice of my communication, though furnishing him with extracts from Mr. Jackson's written refusals. Neither did the judge reply to a note delivered to him the following day. Being thus excluded from the proper mode of redress for grievances of this description, I proceeded to the court-room of the Vice-Admiralty for the purpose of comparing the charges contained in numerous bills in my possession with the established fees, which I was instructed by the Acts of Parliament should be suspended in some conspicuous part of the court, every part of which I searched in vain. Neither was the table in the registry, where His Majesty's advocate directed me to look for it, who, on my returning into court again to make further inquiry, said that I would find it affixed on a door leading to an adjoining room. That mutilated paper, concealed contrary to law, I was accused of having taken down and carried away from a place where it could not have been affixed, except in defiance of these statutes, and in contempt of justice. That, sir, was the paper for which I was followed through the streets of Malta for the space of a week by the deputy auctioneer, styled in the judge's warrant and attachments by the title of deputy marshal, but who, in fact, never had an authority from the marshal, perhaps because the marshal was conscious of having vitiated his powers by the illegal acts of which he was guilty, and thus thought to escape the consequences which might arise from the acts of his nominal deputy. So loosely are things conducted in that court, surely no reasonable man can blame me for refusing to be taken to gaol by the deputy auctioneer. Indeed, Chapman admits in his affidavit of the 24th of February that my objection was to his want of authority, for I naturally concluded that unless he was an officer of the court, his acts might be disowned, and thereby the guilty would escape punishment. That this was the view I took of the case will appear by my offering no resistance to James Horton Stevens, who was appointed on Chapman's nominal resignation. I say so that I offered no resistance, for by refusing to walk to gaol, I did no more than decline, by an act of my own, to contribute to illegal proceedings. It is not my intention to trouble the House at length relative to this affair, which is of trifling importance compared with the mischiefs that arise from the system of plunder and abuse practised in the courts of Vice-Admiralty. However, it may not be improper to mention that I was conducted by the keeper of the gaol to a place with a broken window barred with iron, furnished with an old chair and a close stool in the corner. From this, however, I was removed, as the judge began to fear the consequences of his illegal acts, and on the third day, being brought from the keeper's room to the court of Vice-Admiralty, there, without an accuser except the judge, that learned and worshipful gentleman attempted, in the absence of proof, to administer a long string of interrogatories, which I, of course, refused to answer, and thereby furnished what might be construed by him in evidence of my having taken away his illegal table. Being further pressed and threatened, I delivered a protest in writing against the illegal warrant issued by William Stevens, an examiner and interpreter to the Vice-Admiralty Court of Malta, registered merchant, commission broker, and notary public, calling himself Deputy Registrar of the Court, and professing to act under an appointment of John Locker, Sinecure Registrar, and further against the illegal endeavours to execute the warrant by John Chapman, Deputy Auctioneer, acting for and on behalf of Wood, late Private Secretary to Lord Castlereagh, a non-resident, enjoying an income of about £7,000 sterling per annum, derived from the sale of prizes and the goods of merchants trading in Malta, but calling himself Deputy Marshal of the Vice-Admiralty Court, and professing to act under an appointment from John Jackson, Proctor and Marshal, contrary to law, and farther, against all acts of said John Jackson, in the capacity of Marshal by himself or his deputy, and against John Locker, Sinecure Registrar, and William Stevens, calling himself Deputy Registrar, John Locker having, under the signature of William Stevens, taxed bills of fees and expenses of the Court of Vice-Admiralty, wherein the fees of said John Locker and William Stevens, in their capacity of Registrar, Deputy Registrar, Examiner, Interpreter, etc., 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 are made and examined by themselves, and in which various illegal charges were allowed and suffered to be made by John Jackson as Proctor, for attending, freeing, consulting, and instructing himself as Marshal, in which double capacity he acts in defiance of the 41st and 45th George III. Chapter 72. And further, I solemnly protested John Sewell, styling himself Judge of the aforesaid court, for refusing, by letter dated on the 13th of January 1811, to order satisfaction to be given by the said John Jackson, referring to him a judge in his own cause, and likewise for not having given any answers to official letters delivered to him, bearing date the 19th and 20th of February 1811 on the same subject, and further, I protested against the said John Sewell for not complying with the Act of Parliament, which directs that a table of fees shall be suspended in some conspicuous part of the court, in which the several judges of the Court of Vice-Admiralty hold their sittings. Sir, the judge at first refused to receive any protest, but afterwards did so, and afterwards I was recommitted to prison, not for contempt of court, but for the old accusation of not having complied with certain warrants addressed to a person styled Deputy Marshal, who never had an authority to act as such. That no proof existed of my having taken the table of fees will appear from the following affidavit of Commodore Rowley, Commissioner Fraser, and Captain Murray Maxwell of the Navy. Be it known to all persons whomsoever it may concern, that on the 2nd day of March, in the year of our Lord 1811, personally came and appeared before me the undersigned Notary Public Percy Fraser, Commissioner of His Majesty's Navy, resident in the island of Malta, Charles Rowley, Esquire, Captain of His Majesty's ship Eagle, and Murray Maxwell, Esquire, Captain of His Majesty's ship Alceste, and solemnly made oath on the aforesaid 2nd day of March, whilst the Court of Vice-Admiralty of the said island of Malta was sitting, that they severally and distinctly heard John Sewell, LL.D., the judge thereof, and whilst sitting in his judicial chair, admit in open court, and in the presence of divers persons there assembled, to the Right Honourable Lord Cochrane, that there existed no proof in the aforesaid court of his said lordship's having taken down the paper in question, by the judge aforesaid, called the Table of Fees. Signed, Percy Fraser, C. Rowley, Murray Maxwell. On the 2nd day of August, 1811, the aforegoing attestation was duly sworn at Malta, where stamps are not used, before me, Charles Edward Fenton, Notary Public. Quote within quote begins. Notwithstanding the confession of the judge in open court thus attested, I remained unnoticed 3 days longer in the public gaol, where I now clearly saw it was the intention of the judge to detain me until the packet had sailed for England, and probably until she returned to Malta with instructions. I therefore wrote to the governor, who, having consulted Messrs. Moncrief, Forrest, and Bowdler, 3 gentlemen of the law, sent me their opinion that his Excellency should not interfere with the court acting, as they were pleased to call it, under his Majesty's authority, although in violation of the law. I addressed the President also, who said that the courts of Malta could not interpose. Indeed, had it been otherwise, little good could have been expected from an appeal to these courts, which are still governed by the iniquitous and oppressive Code of Rohan, to the disgrace of all the ministers who have ruled since the surrender of the island to England. Sir, the Maltese stipulated then that a constitution securing property and rights should be granted, and trial by jury, but these have been denied, and examinations are still taken and sentence pronounced with shut doors by their judges, whose appointments are during pleasure. I do not impute blame to His Excellency the Governor, for whom I have a high respect, yet I must say that the system of blending the military and civil authority cannot fail to become oppressive. Ministers have no better excuse for this union of power, contrary to the express stipulations of the inhabitants of the island, than a despicable petition signed by the dependents on government, and shamelessly transmitted and received as the voice of the people. Being furnished with an affidavit that the judge did not intend to proceed in the matter on the next court day, I resolved, as the door was locked and guarded, to get out by the window, which I accordingly effected, and the following proclamation was issued for my apprehension, in which I am designated by as many names as if I had been a notorious thief. Quote within a quote. Escape of Lord Cochrane. Whereas the Honourable Thomas Cochrane, Esquire, otherwise known as the Honourable Sir Thomas Cochrane, Knight Companion of the Most Honourable Order of the Bath, commonly called Lord Cochrane, escaped out of the custody of James Horton Stevens, the Deputy Marshal of the Vice Admiralty Court of this island, from the prison of the Castellania during the course of last night, this is to give notice that whoever will apprehend or cause to be apprehended the said Lord Cochrane, and deliver him into the custody of the said Deputy Marshal, shall receive a reward of 2,000 scudis, currency of Malta, and that whoever will give such information as may lead to the apprehension of any person or persons who was or were aiding and assisting the said Lord Cochrane in such his escape, shall receive upon such conviction, if only one person was so aiding and assisting, the sum of 1,000 scudis, or if more persons than one were so aiding and assisting, then, upon the conviction of each of such persons, the sum of 500 scudis, notwithstanding that in such latter case the person so giving information shall himself have been aiding and assisting to the said escape. Witness my hand this 6th day of March, 1811, James H. Stevens, Deputy Marshal, No. 118 Strata Stretta. Quote within a quote ends. Now, sir, although the treatment which I received is altogether foreign to the main point, yet I am desirous to learn from you, as Speaker of this House, whether my imprisonment was or was not a breach of the privilege of Parliament. The Speaker. I do not know whether the House expects me to reply to the question which the noble lord has put to me, perfectly new as it appears to be, but as far as my information goes, I will give it if the House thinks fit that I should do so. (Hear, hear, close bracket.) With respect to the privileges of the House, I know of no means of enforcing its privileges, but in the usual way, from time immemorial, by its own officers, and I never knew one instance of any officer having been sent across the seas at the instance of any member on a complaint of insult offered to him personally. (Hear, hear, close bracket.) So much for the question of privilege. In the next place, I never knew an instance in which any member of Parliament, properly before a court of justice, was at liberty to treat with impunity the proceedings of that court, or to say that what was done in respect to himself was done in contempt, or could authorise him to say that the privileges of Parliament were infringed in his person for such conduct. Lord Cochrane. Sir, it was my first intention to have moved an address to the Prince Regent to recall the Judge, Registrar, and Marshal to answer for their conduct and proceedings, contrary to the express words of Acts of Parliament, but on consideration and in compliance with the suggestion of the First Lord of the Admiralty, I have thought it better to move, that a committee be appointed to examine into the conduct of the Judge, Registrar and Marshal and their deputies of the Court of the Vice Admiralty of Malta for the violation of the 37th, 38th, 39th and 41st sections of the 45th George III, cap. 72. Mr. P. Moore seconded the motion, not from any knowledge of its merits, but thinking that if the matter of charge was not inquired into, it would reflect upon the House. Mr. Stephen could not avoid applauding the benevolent motive of the honourable gentleman who had seconded the poor outcast of the noble lord. With respect to the conduct of the learned judge alluded to, he was satisfied it was the opinion of the House that he had done nothing amiss, that the dignity of his office required that he should exert his authority after the direct insult that the noble lord had offered to the court. The charge against the noble lord was for taking down the public document of the court, a charge which he had not denied. Nay, indeed, the noble lord had exhibited what he termed a facsimile of the table of fees, and so closely imitated that the very impression of the wafers, the document itself, and its smoke-dried appearance, seemed to proclaim its originality. The conduct of the noble lord, when required to answer for this contempt, was not merely that he refused to obey the monition, but that he pulled out a pistol and threatened to shoot any man who attempted to execute it upon him. Chapman, the officer, therefore, and the fact was confirmed by 2 witnesses, thought it not prudent to execute a warrant at the point of a pistol, and had not the courage to act. The noble lord had stated that he refused to answer interrogatories, and that he made a protest against the proceedings of the court. It was not regular for the court to receive protest arraigning its proceedings, and upon the inquiry it did not think there were sufficient grounds for discharging the noble lord from his arrest. If, however, he was aggrieved, there was a channel through which he might have had redress, without coming to the House, by appearing before the Privy Council and stating his charges against Dr. Sewell, who would, if proved, be removed. But should there not have existed in the executive government a disposition to redress the noble lord's grievances, then it would have been open to him to appeal to the House, but to come at the end of the session was not very regular. Dr. Sewell was a person of correct conduct, and unlikely to act with injustice to any individual. Mr. Yorke objected to the motion on 3 grounds. First, because the case was one of the most frivolous ones he had ever met with. Secondly, because the noble lord, if he had just cause for complaint, should have made it at the Admiralty, and that board would have investigated the complaint. And thirdly, because the complaint, instead of being made by the noble lord, was, by his own showing, a complaint against himself. He had this to state to the noble lord, that if he had not been an officer on half pay, he would have heard from the Board of Admiralty in a different way. With respect to the Marshal exercising the office of Proctor in conjunction, he would recommend an inquiry to be made, as it was contrary to the express provisions of the Act of Parliament. But with respect to the noble lord's case, it was, he must repeat it, one of the most frivolous cases ever brought before Parliament. That is, the First Lord agreed with my statements, but objected to inquiry because I moved for it. Mr. Rose, said his lordship in reply, has expressed his persuasion that the interests of the Navy are best protected by being in the care of the King's Proctor. That is, continued his lordship, under the absolute control of one man, who, in addition to the management of His Majesty's business in 2 courts, and the monopoly of libelling and prosecuting to condemnation all captures made by the Navy, possesses also the exclusive privilege of conducting the numerous and intricate litigations which have arisen of late years out of the seizure of neutrals, causes in which not only the property detained is at stake, but all that a captor possesses is answerable for the costs of suit and demurrage, which, if he is unable to pay, he may be thrown into gaol, not for errors or misconduct of his own, but owing to neglect arising from confusion in an office, where there have formerly been from 1,800 to 2,000 cases in progress at one and the same time, an evil which, unfortunately for the country, is working its remedy in a way highly prejudicial to its best interests. Let me ask, would the right honourable gentlemen opposite exert themselves with zeal if every motion they made subjected them to risk of costs, damages, and imprisonment? They would not sit on these soft cushions unless they were amply paid, although it is easier to do so than to make captures on the enemy's coast. How would they like to be compelled, as the Navy is, to employ one attorney to conduct all their affairs even if he had not their opponents' interests also to promote, as is the case with the Procurator General? Will such management of their affairs encourage the Navy to impede suspicious commerce in neutral bottoms? And if the condemnation of a boat costs as much as the condemnation of a ship, is not the capture of the enemy's coasting commerce virtually discouraged? Nothing, he continued, can better demonstrate the effect which the dread of fraud and neglect in the Procurator's office has on the exertions of the Navy than an account before the House, by which it appears that the numbers of causes belonging to the whole Navy amounted only to 92, including droits of the Admiralty and Crown, while about 36 privateers, possessing the inestimable privilege of employing counsel of their own choice, had actually 110, not injudicious captures, but such as had been sanctioned by the decisions of the lower courts. The Navy are told by a public minute in the Procurator General's office that it is the King's Proctor's particular desire in respect to his bills, first, that in all successful cases they should be made out moderately; secondly, that in unsuccessful cases they should contain those fees only which are allowed on taxation. "Permit me," said Lord Cochrane, "to ask what fees he is entitled to that are disallowed on taxation, and permit me to ask the Treasurer, who is desirous to remove the misconception that prevails in the Navy, if he thinks that were the commanding officers all compelled to employ one tailor, the Chancellors, for instance, that it would be quite satisfactory to learn, whilst there was a certainty of their cloth being damaged, that being cut up and sewed by old women it was made up cheaper, as might be ascertained by a minute behind the shop-board, that it was the master tailor's particular desire in respect to his bills, first, that the old ladies should be moderate in their cabbaging, if the coat fitted, and secondly, if spoilt, that they should take only what they could get. Would not persons thus restricted, and desirous of expedition or care, stimulate the old ladies by a dram, and would not they quit one job and take up another? Would the interests of all be best protected thus?" Lord Cochrane instanced a case of capture, wherein the captor had a balance of £11 14s. Against him in the prize courts, after the prizes were condemned. He stated a case wherein £63 were deduced from a bill upon taxation, and the same sum to a farthing charged for taxing it; and he asked the Attorney General whether he did or did not receive 22 guineas out of the pockets of the Navy for every cause which came before the Court of Appeals, though he had attended but once there since the court commenced sitting in November. "Is this," said he, "one of the law charges which the Treasurer has no occasion to disapprove of? And does he think it right that the Procurator, the boasted guardian of the interests of the Navy, should not only pay the Attorney General for staying away, but fee another for coming to court and performing his duty? I have passed nearly 20 years in the Navy, having been constantly employed until lately. I have had full opportunity to be acquainted with the feelings of those with whom I have mixed, and I believe that, unless the laws and regulations made to guide the Courts of Admiralty are reformed, captures will soon cease to be made. Were that done, the enemy would then suffer the loss of all the trade which is of such importance to France and her dependent states. 2/3 of our present naval establishment would be quite sufficient for the purposes of blockade and all others. Nay, I am clearly of the opinion that if the courts were reformed, it would be a benefit to our country if 1/3 of our ships were converted into firewood. I am sure that the First Lord of the Admiralty would not vote against the production of papers and full investigation if he knew the extent of the evil. He has, however, no means personally to become acquainted with the facts, and there are but few who will venture to inform him." The motion was negatived without a division. End of chapter 32. Recording by Timothy Ferguson, Gold Coast, Australia. Chapter 33 of Autobiography of a Seaman, Volume 2, by Lord Thomas Cochrane. This LibriVox recording is in the public domain. Recording by Timothy Ferguson. Opening of Parliament, 1812. The opening of the session of 1812 was in many ways remarkable. The speech of the Prince Regent, read by the Lords Commissioners, made everything colour de rose, both as regarded our foreign wars and domestic policy. Notwithstanding that we were on the brink of war with America, both houses were assured that the affair of the Chesapeake had been "finally adjusted, though other discussions were not yet brought to a close." The finances were represented as being in a flourishing condition, and His Royal Highness had no doubt of the liberal disposition of Parliament "to sustain the country in the great contest in which it was engaged." The hollowness of these representations was met by Lord Grenville, who contrasted it with the "critical circumstances of the times, and the present alarming state of the country. The framers of the speech," said his lordship, "were the very men who, by their obstinate blindness, had brought the country to the brink of ruin, but who, in the midst of the distress they had themselves occasioned, still held forth the same flattering and fallacious language. He would protest against a continuance of those measures which had brought such calamities upon the country. People might choose to close their eyes, but the force of the truth must dispel the wilful blindness." Lord Grey similarly denounced the policy which was "the source of present and impending calamities." Yet these very complications were brought forward in assertion that the system of the government had contributed to the security, prosperity, and honour of the country, etc., etc. In the House of Commons an unusual circumstance occurred. After the speech had been read by the Speaker, Lord Jocelyn was rising to move the usual complimentary address, but Sir Francis Burdett, having risen at the same time, first caught the eye of the Speaker, who decided that Sir Francis was in possession of the House. One of the Honourable Baronet's cutting speeches followed, in which he denounced the ministers as an oligarchy of rotten boroughmongers, who alike imposed upon the people and the Prince Regent. "A system of taxation had been created which ruined many and oppressed all. This fiscal tyranny being carried to its height, the lower orders had been reduced to a state of pauperism, whilst the desperate resistance which such pauperism was calculated to produce was kept down by the terrors of a military force. Depots, barracks, and fortifications had been established in all quarters, and foreign mercenaries, who had been unable to defend their own country, had been brought over to protect the native land of courage and patriotism, or rather to protect its rulers against an indignant and oppressed people, and to support the scandalous invasions of the liberty of the press, and the severe punishments which those who ventured to express popular opinions were visited by the courts of justice." This interruption by Sir Francis took the House by surprise, but still greater was its astonishment when the Honourable Baronet proposed, in place of the ordinary address to the Prince Regent, a memorial of remonstrance, laying before His Royal Highness all the instances of misgovernment and oppression, of infringement of the public liberty and accumulation of abuses, which had been characteristic of the system pursued by the government for many years past. As a matter of course, the address proposed by Sir Francis was read by the Speaker, amidst the ill-concealed dismay of those most affected by it. I then rose to second the address, denouncing the impolicy of the war, and more still the way in which it was conducted, so far as the policy of ministers was concerned. The subjoined is from the usual reports of the period. "Lord Cochrane rose for the purpose of seconding the address of the Honourable Baronet. He agreed with the speech delivered in the name of the Prince Regent, that a high tribute was due to the bravery of our army in Portugal, and to the conduct of the Commander-in-Chief. But he would deny that the war in the Peninsula would come to speedy or successful conclusion. The forces of Great Britain there were insufficient to cope with those Bonaparte could bring against us as soon as he had completed the subjugation of Spain and obtained command of its resources. Of this we were quiet spectators. To what was our army indebted for its success, and for maintaining itself in Portugal, but to the unproductiveness of that country? Every credit was due to Lord Wellington for his conduct of affairs, but even his lordship expected little from the Portuguese, who were dragged to the army more like slaves than soldiers, to support they did not know what. At Peniche he had seen 10,000 of them collected almost naked, and in want of every necessary. The Portuguese were themselves despots. The dungeons of the Inquisition were full of victims, and the British minister, who formed part of the Regency, was lately under the necessity of retiring from Lisbon, that he might not appear to countenance arrests and imprisonments which he could not approve. He would not scruple to assert that the Portuguese government was obnoxious to every class of society in that country. nay, farther, that in both Sicily and in Portugal the British name was detested because of the support which this country gave to the respective governments of each, with all their oppressive abuses. With regard to Sicily, he thought that the real purpose of ministers was not so much to keep the French out of that island, as to keep the people subject to one of the most despotic governments in existence. With regard to Portugal, which was considered of such importance, he would ask, how long would our army defend that country? Only till the French had made themselves masters of Spain, and then it would be compelled to retire within its fortified lines, the whole extent of which could not afford grass enough to feed bullocks for 6 weeks' subsistence of the troops alone. He would assert as a fact, extraordinary as it might appear, that even at present the bullocks and flour for the supply of Lord Wellington's troops passed through the French army with licences from the interior of Spain. This was a notorious fact, and he would leave the House to make reflection upon it. The noble lord then adverted to that part of the honourable baronet's proposed address which referred to the internal state of the country, and professed his concurrence with the greater portion of the sentiments therein contained, almost owned that the freedom of the people had been greatly encroached upon, particularly by the oppressive mode of levying taxes, the produce of which, he regretted to say, was grossly misapplied. No part of a man's house was free from the visits of the tax-gatherer, and a man could not remove articles that had paid duty on importation without a permit, even so much as a dozen of wine. The noble lord trusted that a committee would be appointed to take both the conduct of the war and the state of the nation into consideration. Lord Cochrane then adverted to that part of the speech which referred to the naval defences of the country, and maintained that our naval force was not rendered efficient in annoying the enemy. Commanding the seas, as this country did, our navy ought to be employed in threatening the coast of France in all directions, by which means Bonaparte would be compelled to keep his armies at home, instead of sending them to be fed, clothed, and paid by our allies for the purpose of their own subjugation. Were the gigantic naval force of England used as it ought to be, the whole force of France, vast as it was, would prove inadequate to the defence of its widely extended shores. Perhaps demonstrations of attack might prove sufficient. If the enemy despised these, it would then be, as at this moment it was, easy to destroy everything on the French coasts. For England could, in spite of all the efforts of the enemy, bring a force to any given point far superior to anything the enemy could assemble for our annoyance, and thus we might effect most powerful diversions." End quote. The address proposed by Sir Francis and seconded by myself was, of course, unsuccessful. The mover of the address originally intended was Lord Jocelyn, who, when I had concluded, made not a word of allusion to any part of the speeches of Sir Francis or myself, beyond stating that he wholly disapproved of all we had said. Such was the legislation in those days that the arguments of those who did not belong to the ruling faction were not listened to, much less answered. Lord Jocelyn's address, which was only an echo of the Lords Commissioners' speech, had, however, to be proposed as an amendment to that of Sir Francis, and was carried without a division. The feeling towards myself for having, as it was said, "thought fit to countenance Sir Francis," needs not to be animadverted on. Yet I had given some good advice as to the way in which our naval power was frittered away to no purpose. English historians, by their silence on this point, appear to have little conception as to the extent of the evil. As in seconding the address of Sir Francis Burdett I had mentioned Sicily, I will give a remarkable example of the way in which war was carried on in that quarter against the French. The reader may deduce from that why I was not permitted to put my plans of harassing the French coast into execution. The following letter is from Captain Robert Hall, commanding what was singularly enough called the Army Flotilla at Messina. The document is a curious one, and may do something towards enlightening future English historians. Reader's note, letter begins, Messina, January 14th, 1812. My dear Lord, it is so long since I heard of you, and being disappointed at not seeing you in this country, as the papers gave us reason to believe, that I must take the liberty of asking how you are. We were led to expect you in the Mediterranean with a flying squadron, but I am sorry to see there is now no probability of it. I am serving here in an amphibious kind of way, having the rank of a brigadier to command an army flotilla, but why it should be an army one I cannot find out, though I have well considered the matter for the last 18 months. There is an immense naval establishment here of 140 vessels of different descriptions, quite independent of the Admiral. Reader's note, there is a footnote here. The footnote reads, I had only asked for 3 or 4 handy frigates to carry out my plans, and indeed could not have employed more with effect, as being under my entire supervision. Reader's note, the footnote ends. These are maintained by the British government at the expense of at least £140,000 per annum. I have, in fact, lessened its expense by £60,000 a year, namely by reducing the pay of the seamen to the standard of our own, though they have been paid at double the rate of English sailors, whilst the padrones of gunboats, taken from the streets, are paid more than our lieutenants. It is a singular thing that the establishment cannot be thrown into its proper channel, the Navy. The island of Zante has another flotilla of $60,000 a month to protect it, and the commandant of the barren rock of Lissa, not content with his gunboats, sent in the other day a serious memorial stating the necessity of defending his island by placing gunboats all round it, wherever there were no guns on shore. If this flotilla mania should reach our West India Islands, what will be the consequence? At least, I should think, as army matters are conducted, an expense equal to 1/2 that of the whole Navy. It is the duty of officers to serve where they are ordered, but this mixture of services is, I believe, altogether new, and may, if followed up, be fatal to the independent spirit of the Navy. If that spirit perishes, all ardour is gone, and we shall be like some foreign countries, where the services are mixed, neither the one thing nor the other. My lord, I believe you know me. You may therefore guess my feelings, after 18 years' service, to be ordered to serve under another person who is a perfect stranger to the service to which I belong. What do you think of an order to make a passage to Zante in the dead of winter by sailing close to the land in the Gulf of Tarento? It is too ridiculous, and really deserves the consideration of the Admiralty. If we can combine our naval and military tactics, it will be a greater effort of human ingenuity than has hitherto been devised. We may then dispense with the rapidity of our manoeuvres, and march in ordinary time. Figure to yourself 18 subalterns of different regiments commanding divisions of the flotilla. When I took it out to sea, they were all seasick, and blank about the decks. Each of these subalterns received 17 and 6pence a day for this extraordinary and fatiguing service, nearly 3 times as much as a lieutenant in the Navy. Endeavour, my lord, to reconcile the meaning of such an establishment, glancing your eye at the same moment on the manner of conducting the flotilla establishment at Cadiz. We have at this moment more troops on the Faroe line than the French have in both Calabrias, independent of those which, under our nautico-military chief, sacrificed our friends in Catalonia. Yet there is a sad outcry here. We tell the Sicilians that they mean to murder us all, and there is no doubt their will is good enough. Reader's note, there is a footnote here. It reads, see my speech on the address of Sir Francis Burdett. Reader's note ends. Numerous are the remonstrances against sending a single soldier out of the island. The firm and manly mind of Lord William Bentinck was proof to this outcry, and it is to be regretted that circumstances did not admit of this zealous and active officer accompanying the expedition himself. Nothing can equal my respect for Lord William Bentinck as a soldier and a gentleman, but I must say with old Neptune, when jealous of the interference of some longshore deity, non illi imperium Pelagi servamque tradentum, sed nille sorte datum est. What end, what purpose, can it answer to put a naval establishment under the command of a person who acknowledges that he does not know how to use it? As it was formed under the auspices of my Lord Mulgrave, this arrangement may probably have been made with a view of simplifying naval matters. For example, my lord, the long sentence of "back the main topsail" might be more readily expressed by the short word "halt." Filling and making sail, according to the strength of wind, might be called marching in quick or ordinary time. Instead of the boatswain's mates to march off the different detachments of the watch, it would, according to our present system, be more regular to march them off with corporals, though in squally weather this might be inconvenient. In short, there might be many improvements. The army officer appointed to command one of our vessels mislaid what he called the route given him by the quartermaster-general, lost his way, as he expressed it, and got ashore in the Gulf of Squillence. On his exchange, he reported to me that the night was so dark he could not see the rock on which the vessel ran, and that when fast, a board broke in her bottom, so that the water ran in so fast he could not scoop it out again. Thus it is that Mr. Bull is humbug. For my part, I have remonstrated repeatedly on the folly of this establishment, and it only remains with me to serve where I am ordered. Of the politics of this country, the public journals will have informed your lordship. We are certainly doing nothing in the way of amelioration, and all parties seem discontented. The new-fangled constitution strikes too much home to be popular amongst those who profited by the old system. Our views are certainly for the prosperity of Sicily, yet no Sicilian thinks so. They dislike us, and I believe they know not why. Some of the knowing ones appear apprehensive of assuming the government altogether, and urge their fears of out-treating them as we do the Irish Catholics. The French partisans, of course, make the most of this state of things. It is to be hoped that Bonaparte's failure in Russia will blast his other prospects, or Sicily will be his in a short time, if we do not oblige the government to adopt some energetic measures. If they would only put the troops we have here on shore in Calabria, there would be no necessity for gunboats. They would excite an immediate insurrection, and would throw plenty of grain, of which we are in want, into Sicily. But if the Sicilian troops should intend running away on the approach of a French regiment, as they did formerly, we had better remain and colonise Messina. Your Lordship's faithful servant, Robert Hall. The Lord Cochrane. Reader's note. Letter ends. The above will show the useless manner in which our best naval force and officers were employed, no less than their testimony to their own uselessness. Yet with upwards of 1,000 ships in commission, we had no naval enemy to oppose, and persisted in employing our seamen anywhere but on the enemy's coast. For simply urging the common-sense employment of our numerous navy, and a proper investigation into the minor details which crippled its action, I was regarded as a common disturber of the ministerial peace. And yet it had not been my intention to throw blame on the Admiralty, but simply on the system under which they continued to act, but which, for all practical purposes, had become obsolete. The Admiralty, whatever might be its wish, was unable to do its work for want of some one of high professional skill and resolute character, whose business it should be authoritatively to investigate the efficiency of naval establishments, and personally to superintend investigation alike into inefficiency and suggested improvements. Had this been done, many evils hidden from the knowledge of successive Admiralties would be perceived and remedied. The Admiralty, even as at present constituted, is not sufficiently numerous to execute so many and such varied duties, even though the ability of the members comprised all professional knowledge, and their industry was indefatigable. The overwhelming pressure of detail renders inquiry into and deliberation on important matters impracticable, whilst on minor matters it is prohibitory, and thus abuses remain unremedied because unperceived. The Board, at all times within my recollection, has been one of reference to persons in inferior departments. These persons pronounce an unquestioned verdict on all matters referred to them, their reports remaining concealed under a rule adopted to avoid trouble or correspondence. The framers of the rule not anticipating that such concealment may be fraught with the most injurious consequences to the Navy, whilst it may shield from exposure the most self-interested and flagrant impositions. This, however, is not the place to enter on a subject the ramifications of which have penetrated into every single department, till beyond the control of the most patriotic and unflinching, who, with all their pains, can only arrive at the one fact, that the whole system requires renovation, which, as it is nobody's business, is never undertaken. So long, however, as such a system exists, so long shall we be in danger of being taken unawares by powers fully alive to the importance of unity of purpose and action. To such a system we have nothing to oppose in case of emergency but our own embarrassment. End of chapter 33. Recording by Timothy Ferguson, Gold Coast, Australia. Chapter 34 of Autobiography of a Seaman, Volume 2, by Lord Thomas Cochrane. This LibriVox recording is in the public domain. Recording by Timothy Ferguson. Chapter 34, My Secret Plans. Soon after my return from the Mediterranean, I had the honour of laying before His Royal Highness the Prince Regent a new and most formidable method of attacking and destroying an enemy's fleet, and of performing other warlike operations on a large scale. His Royal Highness was pleased to refer the plans laid before him to a secret committee, consisting of the late Duke of York as President, Lord Keith, Lord Exmouth, and the two Congreves, one of whom, Sir William, was the celebrated inventor of the rocket which bears his name. These officers, as stated to me in a private letter from Lord Keith, who took a warm interest in the matter, gave it as their opinion that under the circumstances detailed in my explanatory paper, such a mode of attack would be irresistible, and the effect of the power and means proposed infallible, adding, however, that if the plan was divulged, it might become perilous to our colonial possessions, an observation marked by no little foresight, for had the same plan been known to the rebels in the late Indian mutiny, not a European in India would have escaped. The Prince Regent and the Duke of York fully concurred with the committee in the destructive character of the plans submitted for their consideration, as well as in the danger of divulging them. His Royal Highness, sending for me to Carlton House, commanded secrecy on my part. I told His Royal Highness that my plans were only known to Sir Alexander Cochrane and to my uncle Mr. Cochrane Johnson, who had, in fact, written out for me the papers which had been laid before His Royal Highness, but that I would obey his injunctions, and had no fear of my relatives disclosing so important a secret. The investigation being secret, of course, no official report was made on the subject. Not long after this interview, Lord Melville signified to me his intention to put in execution a portion of my plans, and requested my attendance at the Admiralty for the purpose of conferring on the subject. To this partial execution of the project I of course demurred, as unfair to the invention, and necessarily incomplete in operation, whilst development of a portion might give the enemy such an insight of the whole as would enable him to turn it against ourselves on a large scale. His Lordship, nevertheless, did not seem inclined to give way, and I quitted the Admiralty without having been enabled to arrive at any satisfactory conclusion. Lord Melville having mentioned to Lord Keith the result of our interview, Lord Keith urged me to acquiesce in the First Lord's views, adding that he was too well acquainted with the soundness of my plans to doubt the practicability of destroying with a portion only the enemy's ships in Genoa harbour and the outer roads of Toulon. His Lordship further urged that a success once achieved, the popular voice would place it in my power to enforce the execution of the more destructive portion of the invention within the enemy's inner harbours. In deference to Lord Keith's opinion, I at once prepared a plan of attack on the outer roads of Toulon, in accordance with the views of Lord Melville. That communication, omitting the essential parts of the plan, I now subjoin. 12 Portman Square, May 12, 1812. My Lord, in consequence of the conversation I had the honour of holding with your Lordship yesterday, and of your desire that I should state what force would be required for carrying into execution the plan submitted for the destruction of the Toulon fleet, I beg to submit the following arrangements as applicable to this particular object. Reader's note, there's a footnote here, it reads, viz. As not having reference to the execution of the whole. Reader's note, footnote ends. 174, 2 38-gun frigates, 2 18-gun brigs, 2 cutters or schooners. The above force is requisite as an escort and to protect the boats. In order to ensure success, although one half will probably be sufficient, the subjoined will be necessary. Open bracket, here follow particulars, close bracket. As your Lordship permitted me to recommend such officers as I thought best calculated for this service, I beg here to name the following: Captain Robert Bain, Sir Thomas Staines, now of the Hamadryad, Captain Johnston, now commanding the Avenger, if he has not sailed, and if he has, Captain Hall, now commanding the gunboats at Messina, and lastly, the Honourable Lieutenant Napier, now in the Mediterranean. My late First Lieutenant Travers, now in the Imperieuse, to be first of whatever ship your Lordship may be pleased to assign to me, which, in order to further conceal the enterprise, may, if your Lordship should think it proper, be placed under the command of my brother Captain Archibald Cochrane, late of the Fox frigate. I can furnish him confidentially with all necessary instructions, so that I might at once proceed to Lisbon, apparently in a private capacity, so as to disarm suspicion. I have taken the liberty of submitting the names of the above officers to your Lordship, because I am well acquainted with their characters and zeal for the service, and am sure that whatever is undertaken by them will first be well weighed and then executed with determination. The above operation is calculated without the assistance of troops, but if your lordship wish to secure the ships instead of destroying them, 4,000 troops should be embarked at Messina. Reader's note, there is a footnote here that reads, "How well these could have been spared is evident from Captain Hall's letter," see page 221. Reader's note, footnote ends. As though under the destination of Catalonia, and having been shifted into the ships of war now blockading Toulon, should be held in readiness to be disembarked in the peninsula of Cape Cepet, the heights of which may be held, although not yet fortified, against any force that may be brought against them. When I was last there with Lord Collingwood's fleet, I stood particularly close in, within point-blank range shot, and there were not sufficient men in any of the batteries to train more than one gun at a time. Indeed, they appeared merely to be stationed there to take charge of the stores. There was neither smoke in the chimneys of the barrack rooms, nor was there a door or window open, though the weather was extremely hot. If the operations are to be extended along the coasts, your lordship will see the propriety of embarking 300 marines on board the 74, and 100 in each of the frigates. The expense of the expedition will be within 3 months' cost of that of the blockading force, and half the stores enumerated may accomplish the service. I have, etc., etc., Cochrane, the Right Honourable Lord Melville, etc., etc. Reader's note, letter ends. Inconsiderable as was the expense in comparison with other armaments producing little or no result, Lord Melville hesitated to incur it, or rather, as I have reason to believe, his lordship was overruled by the ill feeling against me at the Admiralty, as the concurrence of the board would have placed me in command of a squadron, with my flag flying in a line of battle ship. This was evidently considered too high a position for one who had been for 3 years kept unemployed from political and personal dislike, was evidently not to be thought of, and the project, after long fruitless expectation, was dropped. I then proposed to conduct a similar expedition against Flushing, but this also was declined. As, however, public dissatisfaction began to manifest itself, Lord Melville informed me that I might make an attempt on Toulon on a small scale. In other words, that I might, on a small scale, show the enemy how to put my plans in operation against ourselves on a large scale. The permission was so preposterous, besides being not altogether free from the suspicion that failure would be more acceptable than success, I declined it, notwithstanding the renewed recommendation of Lord Keith to close with Lord Melville's offer. As at this time only a few sail of the line remained at Toulon, I hesitated to comply, considering that the result of destroying these would have been badly compensated by the disclosure of the means whereby the destruction had been effected. Soon after the accession of William IV, I submitted my plans to His Majesty's consideration, and being himself a practical seaman, His Majesty at once admitted their importance, and honoured me with personal interviews on the subject, at which I explained my methods of putting them in execution under various circumstances. His Majesty was further pleased to observe that I ought to be rewarded as well for the plans as for the secrecy which had been observed, yet not the slightest reward did I ever reap for the invention, or for having kept my secret out of pure love to my country, a motive which will be better appreciated when subsequent temptations to divulge it came to be shown. An incontrovertible proof of the efficiency of the plan submitted by me to various ministries is on record in the shape of a report from a comparatively recent commission, one of the commissioners, who ranks amongst the highest in his profession, being still living. As from the non-employment of those plans on any occasion, an opinion may have gone abroad that their destructive character is illusory, I feel myself justified in dispelling the illusion by subjoining the report. Towards the close of 1846, when the late Lord Auckland was at the Admiralty, suspicion being excited as to the motives and intentions of the then French government, another commission was appointed to decide upon a mode of trying my inventions in a way to satisfy the public as to their efficacy, and at the same time to preserve secrecy. This being found impracticable, the trial was never made, but the commission proceeded to report on the plans. The members were Sir Thomas Hastings, Sir F.J. Burgoyne, and Lieutenant Colonel Calhoun. The subjoined is their report, addressed to the then Minister of Ordnance, and forwarded to me by Lord Auckland. Reader's note, letter begins. Ordnance Office, January the 16th, 1847. My Lord, in conformity with your Lordship's instructions, we, the undersigned, have met to consider and report on the secret war plans of Vice-Admiral the Earl of Dundonald, transmitted to us by the First Lord of the Admiralty, the Earl of Auckland. These plans may be classed under 3 heads. First, 1. on which an opinion may be formed without experiment for concealing or making offensive warlike operations, and we consider that, under many particular circumstances, this method of his lordship may be made available as well by land as by sea, and we therefore suggest that a record of this part of Lord Dundonald's plans should be deposited with the Admiralty, to be made use of when, in the judgment of their lordships, the opportunity of employing it may occur. Second, one on which experiments would be required before a satisfactory conclusion could be arrived at. Third, numbers 1 and 2 continued for the purpose of hostile operations. After mature consideration, we have resolved that it is not desirable that any experiments should be made. We assume it to be possible that the plan contains power of producing the sweeping destruction the inventor ascribes to it, but it is clear this power could not be retained exclusively by this country, because its first employment would develop its principle and application. The last observation applies equally to plan number 1. We considered in the next place how far the adoption of the proposed secret plans would accord with the feelings and principles of civilized warfare. We are of unanimous opinion that plans 2 and 3 would not do so. We therefore recommend that, as hitherto, plans 2 and 3 should remain concealed. We feel that great credit is due to Lord Dundonald for the right feelings which prompted him not to disclose his secret plans when serving in war as naval commander-in-chief of the forces of other nations, under very trying circumstances, in the conviction that those plans might eventually be of the highest importance to his own country. We have only to add that we have sealed up, under one cover, all the papers which have been submitted to our consideration by the First Lord of the Admiralty and the Earl of Dundonald, and our correspondence with the latter in another, both of which have been marked secret. With regard to the disposal and future custody of these papers, we await instructions from your Lordship, or the Earl of Auckland, to whom we propose this letter should, after your Lordship has perused it, be transmitted. We have the honour to be your Lordship's obedient servants, Thomas Hastings, Captain R.N. and Principal Storekeeper, J.F. Burgoyne, J.S. Calhoun, Lieutenant Colonel, R.A. To the Marquess of Anglesey, K.G. and K.C.B. Readers note the letter ends. Let the public now judge the nature and value of those plans, of the merit of never having disclosed them, though exposed to severely trying circumstances, and also whether they are impracticable. I have been told on indubitable authority that during the late war with Russia, an interchange of warlike plans took place between the English and French governments. It was further pointed out to me but the other day that a French journal of high authority had marked to this effect, quote, "Should a war arise between England and France, the latter power would bring warlike engines into play, to which rifled cannon were a trifle." End quote. From this I make little doubt but that my plans are known to the French government, and if so, whenever they are applied, the people of this country will find them no trifle. For, as the report just adduced infers, no power on earth can stand against them. It is one of my most bitter reflections that such plans have been entirely thrown away as regards our own nation, and that from the imprudence of governments they may one day be turned against my own country. In the late war with Russia, I twice offered these plans to the government. The first time they were declared inexpedient. The second time I offered to conduct them myself, either against Kronstadt or Sebastopol, old as I was, the forts of Kronstadt being especially open to their application. As regarded Sebastopol, the question was put to me whether I would instruct 2 engineer officers in applying them. My answer was, no, I have offered to risk my own life and reputation on their efficacy, but will not impart my mode of applying them to others who may not, either from preconceived notions or professional jealousy of naval inventions, comprehend them. Had I not adduced the report of the last committees appointed to examine the plans, this may be thought the bombast of an old admiral whose physical vigour had outlived his judgment. I flatter myself, however, that more years of sharp experience than usually falls to the lot even of admirals has fixed my judgment of warlike operations too firmly to be shaken even by age. I repeat that should those plans ever be turned against ourselves, the English public will be in a condition to pronounce an opinion on that point. The report of the committee gives me great credit for not having made use of those plans elsewhere. As before stated, I promised the Prince Regent never to divulge them except for the honour and advantage of my own country, and although driven from the profession of my choice, I did not forget my promise. It may be permitted me to add that when, in 1820, I came with 4 ships before the castles of Callao, it was perfectly well known to me that money and property considerably exceeding in value £1,000,000 sterling, besides all the plate in Lima, had been sent to these castles for security. I could, with the aid of a small portion of my plans only, and in spite of opposition, have possessed myself of this treasure in an hour, and my share could not have been less than £500,000 sterling. Let posterity judge of my conduct as compared with the blind enmity of those who persecuted me wrongfully. Yet there was every inducement to employ my own plans for my own benefit. When I entered the service of the South American States, my private income, never large and entirely of my own creation, had been wholly wasted by the expenses consequent on forced litigation and on in defending myself from an iniquitous prosecution. For more than 4 years I had been deprived of my professional income, and at 40 years of age found myself thrown on the world to seek the means of making provision for myself and an increasing family. Had I been indifferent to the welfare of my own country, my position as Commander-in-Chief of the squadrons of Chili and Peru, and afterwards of the Brazilian squadron, would have enabled me to amass an immense fortune by putting an early end to the wars of those countries, through the adoption of my secret plans, as the governments of those states expected. For not having done so, they manifested their displeasure, and declined to pay me the stipulated rewards for what I effected towards their liberation. It was forcibly urged upon me by the South American governments that the unjust deprivation of rank and honour in my own country released me from any obligation to obey the injunction of secrecy which had been imposed upon me, and that I ought to profit from my own discovery by applying it to the ample opportunities before me. I can safely say that love of country alone restrained me from listening to their temptations, and that I did not yield to the great necessities of my position is now one of the proudest consolations of my life. Yet I repeat, and the assertion will one day be confirmed, that these plans afford the infallible means of securing at one blow our maritime superiority, and of thereafter maintaining it in perpetuity, of at once commencing and terminating war by one conclusive victory. 100 millions employed in war could not complete the ruin of our maritime opponents so effectually as could be done by the simple methods indicated in my plans, and that too in spite of apparently formidable fortifications and other defences of ports and roadsteads. The expenditure of millions in the construction of such works on the coasts of any country would be in vain, when any hostile power in possession of the knowledge of such means of attack could, at a trifling cost, and with the utmost facility, accomplish in a few hours any assignable amount of destruction without impediment from such costly but really impotent safeguards. Still more easily might this country protect itself by destroying at one blow the marine of an enemy, and that by a process which our most eminent engineer officers, as has been seen, have pronounced infallible. It is somewhat singular that, notwithstanding my admitted experiences demonstrating by the acts and successes of my early life, and notwithstanding the destructive character of my plans, as certified by committees of the most eminent men to be found in both services, I have never, throughout my whole life, been officially consulted on the means of defence of this country. This cannot have been accidental. It is not probable that any Prime Minister should consider himself so well up in naval matters as to despise my experience, nor is it probable that he should prefer consulting officers who never saw a shot fired in actual warfare, as was frequently the case previous to the Russian war, to the opinions of one whom committees of the highest professional character had declared to be the inventor of plans which would totally change the aspect of war and supersede every known system of warlike operations. When the dominion of the sea, the existence of our mercantile marine, and the peace of Europe were, as they are at this moment, in question, it is nevertheless difficult to conceive the extraordinary inconsistency. Still, there is the fact. None to whom my plans have been submitted have ever pretended to throw doubt on their efficacy. Some, it is true, have said, For heaven's sake, don't encourage such plans. What is to become of us? What? Universal peace. For after their disclosure, not a man would be found to engage in war, except for defence of his country, when, as was said of the cholera by an eminent French surgeon, il cadavasira le monde. What can have been the cause of such neglect and contumely as I have suffered, under the full knowledge that such a secret was in my power? There can only have been two causes: unmerited personal aversion, without reason, or want of political courage to put my plans in execution. Whether of the two causes be accepted, they form the highest compliment which was ever paid to a man, viz. That no amount of neglect or persecution could induce me to betray my country. The report of the committee paid me the compliment, which is at least my right, and how great a compliment it is, futurity may one day unexpectedly have to decide. No doubt, to use such powers for ambitious purposes would be wicked. But what guarantee have we that if in the possession of ambitious nations, they may not be turned against us? To use them in the defence of order and civilization would be praiseworthy, but to let the world know that we are at all times prepared to use them against aggression would be a protection of the best interests of mankind, no less than of our own. Such knowledge can only be dangerous to those who have cause to fear it, but to those possessing it, it is power, strength, and safety. The public is now in possession of all material circumstances connected with the subject, except the plans themselves, which, for obvious reasons, are, it is to be hoped, still secret. I am not certain whether, were the plans disclosed, the advantage would not be in favour of publicity. Such disclosure would demonstrate that there could be no security in coast defences and other stationary asylums, on the construction of which it is now proposed to expend so many millions of the public money. It would show the inexpediency of expenditure of 10, which may mean 20, millions for the construction of forts and harbours, instead of applying half the amount to remodel and renovate the navy. The disclosure might have the effect of preventing useless expenditure and of averting the danger of future parsimonious naval administration by lending to the adoption of essential measures of nautical improvement, by which alone the safety of the country can be preserved. The disclosure of these plans would also have the effect of binding over nations to keep the peace. Still less would the English public countenance the extravagant and inefficient projects devised for the protection of their insular position, open at all points and only to be protected by a superior naval force, which shall avert danger on the first menace. As the subject of fortifications is now uppermost in every man's mind, I will venture a few remarks on my experience of this model of defence. A story is told of the Duke of Wellington, which embraces the whole subject. On his appointment as Warden of the Cinque Ports, the inhabitants of Dover, well known for their keen scent of a profitable job, applied to the Duke for an increase of their fortifications, already a stupendous monument to the folly of those who have added to them. The Duke's reply was the perfection of military wisdom. Quote, "The fortifications of Dover would be, no doubt, very useful if an enemy came in that way, but I don't think he would. They might also be very useful if an enemy went out that way, but I don't think he would." End quote. In that sentence is comprised the whole subject of fortifications, unless erected specifically for the defence of a dockyard or an arsenal, such as Portsmouth, Plymouth, etc. It is true that in his last years the Duke retracted his opinion in some degree, but I could never learn the reasons he assigned for so doing. Why should an enemy go to a coast fortification when he can land miles away from it? I will take the instance of the Dover fortifications, which are amongst the most stupendous in the country. What is there to prevent an enemy from landing at Walmer, where there is nothing to oppose him but the 6 pop-guns in the flower garden of the castle? He may effect a debarkation there, at all times of the tide, in any wind, and almost any weather. The distance from the fortifications of Dover is little short of 7 miles. By making a strong feint by sea on Dover, the garrison could not quit their works to prevent the disembarkation at Walmer, for if they did, the feint would be turned into a real attack. Neither, when the disembarkation had been effected, would they be likely to quit their works for the purpose of harassing the invaders, for so surely as they marched out for this purpose, a sufficient portion of the enemy would march in. The whole would simply amount to this, that the garrison, say 10 or 20,000, would be cut off from communication with the army elsewhere, and would thus be completely neutralised. Lastly, when disembarked at Woolmer, the fortifications of Dover could not in the slightest degree interrupt the enemy's communications by sea. Nothing but an efficient navy could do that, and with an efficient navy the disembarkation at Woolmer would never be attempted. All this is plain enough, for, after all, military tactics are founded on common sense, and the amount of common sense decides their superiority. Where fortifications are the key to a province, frequently advisable to capture them, and this may be an easier matter than military men in general are willing to admit. Of course, if they sit down before fortifications secundum artium, the matter is one merely of time and calculation, as we have learned at Sebastopol. When on the coast of Chile, I captured a province with 120 men only, and that by storming its fortifications. These were 13 in number, and were garrisoned by 2,000 men. I was accused of rashness for the attempt, yet no more doubted the fact of my success than I doubted the reality of the attack. It was simply a matter of well-matured deliberation and calculation, in which, of course, the panic of the enemy formed an important item. The result was that I did not lose a man, whilst the enemy's killed and wounded amounted to more in number than my whole force. With this, in addition to my former experience, it will perhaps not be wondered at that my respect for fortifications is by no means great, though my respect for an efficient navy is excessive. Full discussion of this matter would, however, require more space than can here be devoted to it, and should my life be spared, I will on a future occasion enter more extensively into this and other cognate subjects. Were I to do so now, I am afraid public faith in some of its newly cherished fortifications would be materially shaken, and will therefore refrain from so doing, in the hope that improvements in our navy, the only true basis of national safety, will render such remarks unnecessary. In short, immovable stations of defence as a protection against invasion are not only costly and of doubtful utility, but a reliance on them is, in my mind, an indication of a declining state. It is little short of national imbecility to suppose that because we erect imposing fortifications, an enemy will come to them, when he can operate elsewhere without the slightest regard to them, and the more so as the common experience of warfare will tell him that numerous fortifications are in the highest degree national weakness, by splitting up into detail the army which ought to be in the field against him, but who are compelled to remain and take care of their fortifications. Yet half the sum required for fortifications as defences, in case of war, would suffice to place the navy in a condition of affording far more effectual protection. There is no security equal to that which may be obtained by putting it out of the power of an enemy to execute hostile intentions. This can never be effected by forts, but may be accomplished by the adoption of proper measures, which I shall, at present, refrain from commenting on. End of chapter 34. Recording by Timothy Ferguson, Gold Coast, Australia.